ಹಾಂ ಮಾಡ್ಕೊಳ್ಸಿ. ಹೋಗ್ಲಿ ಹೋಗ್ಲಿ, ಬೇಜಾರಿಲ್ಲ, ತೊಂದರೆ ಇಲ್ಲ, ಅಡ್ಡಿಲ್ಲ 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 ಅಡ್ಡಿಲ್ಲ. ಹೌದು ಹೌದು, ಹಾಕಲಿಕ್ಕೆ ಹೌದು ಹೌದು ಹೌದು. ಶಿರಸೆ ಕೋಳಿ ಕೇಳಿದ್ದು ಇಲ್ಲಿ ಹೇಳ್ಕೊಂಡಿದ್ದೀರಿ, ಕೇಳ್ತಾ ಇಲ್ಲ ಬೇಡ್ತಾ ಇಲ್ಲ ಹೇಳಿದ ಅವಾಗ ಮತ್ತೆ ಅಂತ ಸೇರಿಸ್ಕೊಂಡು ಇಲ್ಲಿ ಎಲ್ಲಿ ಹೇಳಾಗ ಹೋಗಿದ್ಯಾ ಆನ್ ರೆಕಾರ್ಡ್. ಹ್ಞೂ ಹ್ಞೂ ಹೌದು 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 ಹೌದು, ಒಬ್ರಿಗೊಬ್ಬರು ಇರೋದು. ಹ್ಞೂ ಅಡಿಲ್ಲ ಅಡ್ಡಿಲ್ಲ, ಅವ್ರವ್ರನ್ನ ಮಾತಾಡ್ಕೊಂಡಿದ್ರು ಕೇಳಿ, ಅಕ್ಷರಿ ಕೇಳಿ ಅವ್ರವ್ರಿಗೆ ಹೇಳಿ ಮಾಡಿ ಮಾಡ್ಕೊಂಡಿದ್ದು ಹಾಕೊಂಡು ಹೇಳಿದ್ದು, ಹಾಗಾಗಿ ಹಾಕಿದ್ದು.
ನೀವು ಹೇಳ್ತಿ ಅಂದ್ರೆ ಅವ್ರು ಎಂತ ಗೊತ್ತಾಯ್ತು,
ಹೌದು ಹೌದು ಹೌದು, ಅದು ಕರೆ.
ಅದಕ್ಕೆ ನನ್ನ ವಿಚಾರ ನಾನು ನಿಮ್ಮ ಹತ್ರ ಹೇಳ್ತೇನೆ.
ಕರೆಕ್ಟ್ ಕರೆಕ್ಟ್,
ನನಗೆ ಅಂತ ಇತ್ತು, ನಾನು ಹೇಳ್ತೀನಿ ನಿಮ್ಗೆ.
ಅಡ್ಲಿ ಅಡ್ಲಿ.
ಅಂದ್ರೆ ಈಗ ನಾವು ಇಬ್ಬರಿಗೆ ಎಕ್ಸ್ಪ್ರೆಸ್ ಮಾಡಾಗಲಿ, ನಾನು ಕಡೆ ಹೋಗಿ ಅಲ್ಲಿ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಿ
page 19, 74 to 76, page 20, 77 to 81, page 21, 82 to 85, page 22, 86 to 90.
Serial number 89, Your Lordship. Kindly next week. Counsel on record is out of station.
You're for?
I'm for petitioner, Your Lord.
Inform ಮಾಡಿದ್ದೀರಾ?
Yes, please. Your Lordship.
89 at the request of counsel for the petitioner released on 20 5th.
Much obliged.
Page 23, 91 to 93. Page 24, 94 to 100. Page 25, 101 to 104.
102, your lordship. 102, your lordship. 2 weeks of time, your lordship.
At the request of counsel for the petitioner, relist on 4th March.
Interim order may be extended.
Interim order earlier granted is extended.
Much obliged.
Page 26, 105.
Well, that's serial number 41, my lord.
Dismissal. 52. 71. 50 to 71, whatever you want to comply, pay by end of the day. If not done by end of the day, it will be dismissed. 50 to 71.
50 to 71.
Serial number 41, my lord.
Hmm.
I'm for the petitioner, my lord.
Yes.
Lord, withdraw the writ petition, my lord.
Petitioner is before this court seeking for the following.
To
reasons.
liberty to the, my lord.
Liberty and
Application by mistake throw side, my lord, in the
application. A memo dated 12/2/2025 has been filed, signed by the petitioner and the counsel for the petitioner, which reads as under. Accepting the said memo, petition is dismissed as withdrawn, reserving liberty to the petitioner to file appropriate application in the pending suit.
My name is Toast, my lord. Lingesh Kattemine, my lord.
Registry direct print the name of Shri Lingesh Kattimani as that appearing for the
Yes,
petitioner.
well, okay.
Delete the name of Shri Uday Shankar Shinde as that appearing for the petitioner.
Lordship, serial number 48, Lordship. Last occasion, Lordship directed to take notice, Lordship, in respect of TMC, Lordship, Bhagyanagar. I'm not in the panel list, Lordship.
Let's,
Panel, Agbudi panel. Inyari there panel.
ಯಾರು ಇಲ್ಲ
let's
ಅಂತ ಸ್ವಾಮಿ.
may make one submission, Mullets. I'll take hand summons on the respondent because Mullets, despite the interim order being granted by this honorable court, after that Mullets, they have come for demolition. Will serve hand summons, Mullets. Your lordship may have it on Wednesday.
Why, who is the standing counsel for the
ಇಲ್ಲ
case?
ಯಾರು ಇಲ್ಲ ಅಂತ
Oh,
ಸ್ವಾಮಿ. Verify
standing
ಮಾಡಿದ್ದೀನಿ.
counsel for Bhagyanagar, Mullets.
ಒಂದ್ರಲ್ಲಿ ಹೇಳಿದೀವಲ್ಲ ಏನಾಯ್ತು?
is still under progress. We have informed.
This is all unnecessary.
Since my lord, they will appoint the local advocate. They will not come before this court.
We observed that we'll direct the GA to take notice.
Yes.
Then you correspond. ನಿಮಗೆ extra work ಆಗುತ್ತೆ.
It would be convenient for us also. Instead of getting the advocates, if the government advocates are permitted to appear, then we will start appearing in all the cases.
Extra work ಆಗುತ್ತೆ. ಅದು ಹಿಂಗೂ ನೋಡ್ಬೋದು ಹಂಗೂ ನೋಡ್ಬೋದು. But this
That
is
can be taken care of.
TMC ಬಂದಿಲ್ಲ ನೋಟಿಸ್ ಹೋಗಿ ಅವರು ಅಪಿಯರ್ ಆಗಲ್ಲ.
At least we can communicate to them at the most.
48 Shri Vijay Kumar Balgerimat submit that he is not on the panel of the respondent town panchayat.
Please.
In that view of the matter, registry is direct delete his name as that appearing for the respondent. Counsel for the petitioner is permitted to take out hand summons on the respondent, returnable by 19th February.
Please, Mullets.
Please.
Interim order granted earlier, may I
Order
give it?
earlier granted is extended till next.
Let's, in the meanwhile, Mullets, I may be permitted to comply the office objection. Typed copies are sought.
Has to be complied by the next date. If not so complied, the petition would be liable to be dismissed for
Please.
permitted direction.
Obliged, Lordship.
That's serial number 24. It is for amendment. I may be permitted to carry out the amendment, Mullets.
When it is,
Please.
ಯಾವುದಿದೆಯೋ ಮಾಡಿ.
My lord, serial number 43, cause list number 1. I'm seeking,
43.
yes, sir.
ಹಾ.
I'm seeking adjournment for 2 weeks, my lord.
2 days ಎಲ್ಲ ಆಗಲ್ಲ. At the request of counsel for the petitioner, relist on 20th February.
My lord's interim order may be extended.
Interim order earlier granted is extended till.
Much obliged.
1, Mr. Kundappa.
Yes, Mr.
I request this honorable court, madam. We will pass an award within the stipulated time given by the court, madam.
Hmm.
And we will consider their passing of award as per new act, madam.
New act.
As per new act,
Consider a will.
we will consider.
Will consider ಅಲ್ಲ. Will pass ಅಂತ ಹೇಳ್ಬೇಕು.
Yes, sir. And keep the notification in abeyance till that, madam.
If you are going to pass it.
Yes.
Mr. Gundappa.
My lords, there is an inordinate delay of 13 years, 1 month. Preliminary notification that is on 5/6/2009. Final declaration that is on.
Argument ಮಾಡಿದ್ರೆ dismiss ಆಗತ್ತೆ.
Yes.
No, my lords.
You are getting the compensation in 22 act.
And the price,
2013 Act
Price, my lord,
calculated on
that is on,
22.
my lord, sir, price fixed by the other side, that is on lowest side, wherein 2000,
ಅದಕ್ಕೆ 22 ಗೆ ಇವಾಗ ಫಿಕ್ಸ್ ಮಾಡ್ತಾರೆ. As on the date of the final notification,
please.
under the Act of
okay, my lord,
2023.
sir, 13 years, 1 month in final declaration. So far, no award passed, possession not taken.
They will pass an award in 3 months,
6 months.
6 months.
Because
6 months.
parties, ತುಂಬಾ parties ಇದ್ದಾರೆ. We have to issue the
They are
notice.
the
and
poor
we have called
farmers,
for-
my lord,
we have
poor
called-
farmers,
ಎಲ್ಲ farmers.
please.
The price advisory committee fixed the compensation for
This is a fair.
consent, 35 lakhs they have fixed.
9 price, my lord, 2009.
ನಿಮ್ಗೆ 2009 ಬೇಕಾ?
9 ಅವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ, that is
ಅವ್ರು
lowest
ಇವಾಗ
side.
22 ಕೊಡ್ತೀನಿ ಅಂತ ಇದ್ದಾರೆ. ಅರ್ಥ ಆಯ್ತಾ ಅವ್ರು ಹೇಳಿದ್ದು?
Please, my lords.
Final notification date, they'll give the they'll fix the price as on the date of the final notification in terms of the Act of 2013. ಅದಕ್ಕಿಂತ ಇನ್ನೇನು ಬೇಕು?
Price advisory committee has fixed the compensation.
ಅರ್ಥ ಆಯ್ತಲ್ಲ
35
ಅವ್ರಿಗೆ?
Please, my lords, I can understand.
ಹಾ, ಮತ್ತೆ ನೀವು ಅಗ್ರಿಯಬಲ್ ಅಂದ್ರೆ ಕನ್ಸೆಂಟ್ ಅಲ್ಲಿ ಮಾಡಿ ಮುಗಿಸೋಣ. ಸೊ ದೇ ವೋಂಟ್ ಬಿ ಇಶ್ಯೂ ಲೇಟರ್.
Let them deposit the amount within specific time.
ಅವಾರ್ಡ್ ಆದ್ಮೇಲೆ ತಾನೇ ಡೆಪಾಸಿಟ್.
ಅವಾರ್ಡ್ ಮಾಡಬೇಕು, ಅವಾರ್ಡ್ ಮಾಡಿದ ನಂತರ ಡೆಪಾಸಿಟ್ ಮಾಡ್ತಾರೆ.
ವಿಲ್ ಡೈರೆಕ್ಟ್ ದೆಮ್ ಟು ಡೂ ಇಟ್ ಇನ್ 6 months ಟೈಮ್. 2009 ಇಂದ ಕಾದಿದ್ದೀರಾ, ಇವಾಗೇನು 6 ತಿಂಗಳಿಗೆ ಅಷ್ಟು ಅರ್ಜೆಂಟ್ ಮಸ್ತ್ಕೊಂಡು.
Please.
They are fence sitters. They are fence
No,
sitters.
no, my lords, we are not fence sitters.
The matter is moved for being spoken to. Shri P.N. Atti, counsel appearing for the KIDB, submits that if the order dated, the date 10/2/2025 is withdrawn, stroke recalled, the KIDB would, the SLO attached to the office of the KIDB would pass an award in terms of the right to fair compensation, so and so Act 2013, by taking into consideration the valuation of the property as on
7/7/2022.
7/7/2022, as on the date of issuance of the final notification.
Final declaration, please.
That is final
Annexure-
notification under subsection 4
Annexure
of section 28 of the KID Act, that is 7/7/2022. Shri H.R. Gundappa, learned counsel appearing for the petitioner, submits that so long as the award is passed within a reasonable period of time,
3 months.
Within a reasonable period of 3 months' time, the petitioner is agreeable. In response thereto, Shri P.N. Atti, learned counsel for the KIDB, submits that there being large number of petitioners and the documents being required to be considered, an additional opportunity could be given to the petitioner to submit such other and further documents as they may wish to rely upon. And thereafter, the KIDB would pass, the SLO would pass an award within 6 months from today.
Please.
The submission made by Shri P.N. Atti appears to be, is reasonable. In that view of the matter, I pass the following order. The order dated 10/2/2025 stands recalled. The preliminary notification under section 228(1) of the KID Act dated 5/6/2009 stroke 8/6/2009, and the final notification under subsection 4 of section 28 of the KID Act dated 7/7/2022 are kept under suspension. The petitioners are permitted to submit such other and further documents as they wish to rely upon within 30 days from today, that is on or before 12th March 2025. the SLO shall consider the documents submitted by the petitioners, as also take into consideration all other surrounding circumstances and pass necessary award by 12th August in terms of the Right to Fair Compensation Act 2013 by taking the valuation of the property subject matter of the acquisition as on the date of the final notification of subsection 4 of section 28, that is 7/7/2022. In the event of the award not being passed by 12th August 2024, the order dated 10/2/2025 shall come back into force, and the preliminary notification dated so and so, a final notification dated so and so shall stand quashed. The order dated is recalled, order dated so and so is kept under suspension. Relist on 18th August.
Please.
Great.
The first three petitions, my name will be deleted.
Registry is direct, delete the name of Sri
Pawan Dodatti.
Pawan Dodatti as that appearing for respond number 2 to 4.
Please.
And print the name of Sri P. N. Natti as that appearing for respond number 2 to 4.
Great.
Hearing 2, Kumar,
Please, my lordship, I am for the petitioner, my lordship. Lordship, I am challenging the order passed by the Labour Court, my lordship. My lordship erroneously rejected on ground that my lordship petitioner has not served the 240.
Respondent error, private station. Heady.
My lordship, I am challenging the order passed by the Labour Court, my lordship. My lordship, Labour Court, my lordship erroneously rejected that, my lordship, on ground that the petitioner has not served the more than 240 days, my lordship.
240 days.
No,
For regularization.
please, my lordship. My lordship, the initially, my lordship, petitioner has worked as, my lordship, in the PU college, my lordship, as a librarian, my lordship. Thereafter, my lordship, the first respondent has established on the ITA college.
ಎಲ್ಲಪ್ಪ ಏನೇನೋ ಮಾಡಿದ ಅಮೆಂಡ್ಮೆಂಟ್ ಹಾಕಿದ್ದೀರಾ?
ಫಸ್ಟ್ ಗೆ ಇದೆ ಸ್ವಾಮಿ, ಅದು ಫಸ್ಟ್ ಗೆ ಇದೆ ಸ್ಟಾರ್ಟಿಂಗ್ ಅಲ್ಲಿ ಸ್ಟಾರ್ಟಿಂಗ್ ಅಲ್ಲಿ ಇದೆ ಸರ್. ಅದನ್ನ NOC ಬಂದ ಮೇಲೆ ಅದು ರಿಪೇರಿ ಆಗಿದೆ ಸ್ವಾಮಿ.
You are challenging the order of 2018.
Please. The petitioner has filed in writ petition in the year, my lordship.
2018.
18, my lordship.
2018 ಇಂದ preliminary hearing pending ಇದೆಯಾ?
ಏನೋ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡ್ಕೋಬೇಕಂತ ಕೊಟ್ಟಿದ್ರು ಸ್ವಾಮಿ, ಅದು ಡೇಟ್ ಇಲ್ಲಿವರೆಗೂ ಅದು ಯಾವ್ದು ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗಿಲ್ಲ. 20ರಾಗ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರು, ಅಪ್ಲಿಕೇಶನ್ ಆದ್ಮೇಲೆ ಅಮೆಂಡೆಡ್ ಆಗಿಲ್ಲ ಅಂತ ಪೋಸ್ಟ್ ಆಗ್ತಾ ಇತ್ತು. So when I have entered, my lordship, I amended the cast rate.
Amendment ಆದ್ಮೇಲೆ ನೋಟಿಸ್ ಹೋಯ್ತಾ ರೆಸ್ಪಾಂಡೆಂಟ್?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಹೋಗಿಲ್ಲ.
ಮತ್ತೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಲ್ಲ?
Please.
The petitioner has caused an amendment to the petition seeking for additional reliefs. In that view of the matter, notice would have to be again issued to the respondents. Issue notice to the respondents returnable by 19th March. 20th March. Petitioner is also permitted to take out hand summons on the respondent and file acknowledgement of service.
Oh, please.
In serial number 3, I am for the respondent.
Yes.
Plaintiff's petition, your lordship, that against the first instance, has granted a TI, your lordship, that subsequently in the miscellaneous application, it has been set aside by the senior civil judge, your lordship.
Yes.
It's only on that ground, your lordship, that the one thing. The petitioner was an archaka of the Venkatesh Dev temple, your lordship. And your lordship, as there was a dispute among the archaka, that the present petitioner and the management, he demanded an application, he filed an application as for a demand he has made, your lordship. That in the demand he has made that if you not fulfill the demand, I will withdraw from this, your lordship. That he will not perform the puja. Subsequently, they have not made any, your lordship, that the subsequently, your lordship, that they have removed him from the
Temple.
temple ಅಲ್ಲಿ ಅರ್ಚಕ ಅಂತಿದ್ರು.
ಇವಾಗ ಟೆಂಪಲ್ ಅಂದ್ರೆ ಅಪೀಲ್ ಇಲ್ವಾ ಇದ್ರಲ್ಲಿ?
ಇದು ಬಟ್ ಸೂಟ್ ಇಲ್ಲ, ಸೂಟ್ ಹಾಕೊಂಡಿದ್ದಾರೆ ಇವರು ನಮ್ಮವ್ರು.
ಸೂಟ್ ಹೆಂಗ್ ಮೇಂಟೈನಬಲ್?
ಸೂಟ್ ಇವ್ರು ವರ್ಷ ಟೇ ಹಾಕೊಂಡಿದ್ದಾನೆ.
ಅಲ್ಲ, ಸೂಟ್ ಹೆಂಗ್ ಮೇಂಟೈನಬಲ್?
ಸೂಟ್ ಅರ್ಚಕ ಅಂತಂದ್ರೆ yes lord,
there is a temple.
You
are filing, it's not a private dispute between two archakas.
They say that it's not notified temple. They themselves admit, your lordship. It is not the notified temple. If it is the notified temple, then Rajya Dharmika Parishad, your lordship. The prayer, your lordship, that in page 17, because he has a pariah that every year it changes.
Defendant has submitted that temple defendant mart is situated at Sunkeri, registered in Bombay Public Trust, now governed by the Karnataka Hindu Religious and Institution Charitable Endowments Act.
Registered anತಾರೆ, but your lordship, that it is not idananta ಬರೀತಾರೆ. In objection statement, your lordship, in page first of the objection statement, para 3. Page number 1. Para 3, your lordship. It is not a notified temple. The temple belongs to Mutt and local committee.
Mutt. So Mutt is excluded.
Mutt is excluded. That's the,
from the.
That's also he filed a suit. Now they have produced one document. After verifying this document, only the trial court has granted a TI, or also that he has made this. That's annexures R1 produced by my learned friend. If you don't pay me the amount, I will not continue with the puja.
Annexure R1.
R1, your lordship. Page 6, your lordship. Page 6 of the
Statement of Objections.
Statement of Objections.
ಇವಾಗ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರು.
I have produced.
ಇವಾಗ ಇಲ್ಲಿ objections ಹಾಕಿದ್ದಾರೆ. Yes, from Damodar P. But
ನನ್ನ ಬೇಡಿಕೆ ಮೇ ರೀಡ್ ಯುವರ್
ನೀವೇ ರೆಡಿ ಇಲ್ಲ, 15,000 ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ
ನಾನು ಮಾಡೋದಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅಷ್ಟೇ.
ಮತ್ತೆ ಇನ್ನೇನು?
ಬಟ್ ಯುವರ್ ವೆದರ್ ಮೈ ಕಂಟೆಂಟ್, ಇಟ್ಸ್ ಎ ಕ್ವೆಶ್ಚನ್ ಆಫ್ ಟ್ರಯಲ್ ವೆದರ್ ದಿಸ್ ಕಮಿಟಿ ಕ್ಯಾನ್ ಯುವರ್ that pass such an order.
ಅವ್ರೇನು ಆರ್ಡರ್
ಮಾಡಿಲ್ಲ, ಇವನೇ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅವ್ರು ಇಲ್ಲ ಅಂತ
ಹೇಳಿದ್ದಾರೆ ಅಷ್ಟೇ. His contention is that they don't have a powers and all. That is question of trial. That's
the petitioner is before this court.
May I make one more submission, madam?
ಇನ್ನೇನು submission ಮುಸ್ತಿಯಾಜಿ?
ಅಲ್ಲ, pursuant to this letter, we have passed the resolution, appointed third person, and I have produced a document, especially bank account statement, to show that payment is made to the other priest till January 2025. Sorry, madam. Howdu? By a resolution, that is annexure R2 is the resolution. He has submitted the resignation letter on 26/2022. Sorry, madam.
Payment ಮಾಡಿದ ಮೇಲೆ ಪೂಜೆ ಮಾಡಕ್ ಬಿಡಿ.
ಇವ್ರಿಗಲ್ಲ, in his place, one Anant Bhatt was appointed and regularly payment is made, and I have produced the bank account statement. Till January 7th, we have paid the salary to the appointed priest.
Petitioner is before this court seeking for the following reliefs. The petitioner had filed a suit in OS number 105 of 2024 seeking for the following relief, page 17. In the said suit, an application under Order 39, Rule 1 and 2 had been filed seeking for an ad interim injunction restraining the defendants by seeking for the following release, page 20. The trial court, initially considering the said application, allowed the same and granted the injunctive relief as sought for. The defendant preferred an appeal in miscellaneous appeal number 6 of 2024. The additional senior civil judge in JMFC Karwar, Uttara Kannada, wide order dated 17 September 2024, set aside the order passed by the trial court and vacated the order of injunction on the ground that the defendant
Himself has
appointed one
Petition
other
has voluntarily resigned,
Archaka, Sri Anant Bhatt,
but
who has been performing the pujas on account of the plaintiff himself having refused to perform puja without the temple stroke defendant making payment of a sum of rupees 15,000 per month, as also certain other amounts as claimed by the plaintiff in his letter dated
22/6/2022.
26/2022. And it is in pursuance of said letter of refusal that the temple has passed a resolution on 22/6/2022 appointing Sri Anant Bhatt, who has been carrying on the said pujas. It is challenging said order that the petitioner is before this court. The submission of Sri Jagdish Patil, learned counsel for the petitioner, is that the trial court, having taken into consideration the right of the petitioner, right of the plaintiff in performing the pujas, had granted an order of injunction, rightly granted an order of injunction, which ought not to have been vacated by the first appellate court. His submission is that his submission is that the petitioner, the plaintiff, having been performing pujas for a long period of time, could not have been removed and another person appointed in his place. Sri SVIG, learned counsel appearing for the cavator respondent stroke defendant, would again reiterate that the plaintiff has voluntarily resigned from the post on account of, he is deemed to have voluntarily resigned from the post, since the plaintiff had categorically indicated that without the payment of rupees 15,000 per month and certain other amounts, the plaintiff would not perform the pujas. Heard so and so, peruse papers. The first appellate court has rightly taken into having gone through the papers, I am of the considered opinion that the first appellate court has rightly taken into consideration the letter dated 26/2022 of the plaintiff. The plaintiff himself having refused to perform pujas without the payments as indicated therein, namely enhancement of monthly remuneration from 10,000 to 15,000 and certain other amounts. The offer of performance of puja by the plaintiff is conditional upon the payment of the aforesaid monies. Thus, it is not that the plaintiff is willing to perform the pujas without the payments being made. In that view of the matter, the first appellate court has rightly taken into consideration that the plaintiff is deemed to have voluntarily resigned from the post on non-payment of the amounts demanded. I find no infirmity in the said order. The petition stands dismissed.
Please, much obliged.
Fourth, to doubt.
Well, Your Honor, seeking for a mandamus to consider the request of the petitioner. The petitioners are the members of Gram Panchayat, wherein the PDO has granted permission to put up the liquor shop in a particular area in the village of Torangatti without seeking any objections from the public.
Blood. Their representation is blood. Now petitioners are in 6 members. Blood. The total membership is 14 members. It was already considered and placed before the Gram Sabha, wherein 7 members have been blood have taken decision that blood it in accordance with law blood whatever their license is concerned, they have been permitted to run the shop. It was already taken decision as per my instructions, my lord.
Place it on record. Place the resolution on record.
Please, my lord, please.
And counsel for response number 2, 5, and 6 submit that a resolution has been passed after considering the request of the petitioner. He seeks for and is granted
But next week, my lord.
a
Any
week's
day.
time to place the said resolution on record. Relist on 18th February at 2:30 PM.
File Abjit, confirm, sir.
They are seeking a writ of mandamus to the respondent number 3, PDO, to issue no objection certificate with regarding to conversion of agriculture to non-agriculture land. They have filed an application, but unless and until no objection certificate is enclosed, seeking for conversion is not permissible.
ಯಾರು no objection ಯಾರಿಂದ ಬೇಕು?
PDO ಕೊಡು, ಗ್ರಾಮ ಪಂಚಾಯತ್ ಅವ್ರು ಕೊಡಬೇಕು.
Lords, petitioner counsel is out of state, my lords. So I request on 21st, my lords, because connected matter is posted on 21st.
Who is for respond number 3?
Lord, nobody appears. ಉತ್ತರ ಕನ್ನಡ ಯಾರು ಇಲ್ಲ. ಜೋಯಿಡಾ ಕಾರವಾರ.
ಯಾರು ಅಪಾಯಿಂಟ್ ಆಗಿಲ್ಲ?
ಇಲ್ಲ, ಆ ಕಡೆ SV ಅಜಿ ಅವರು ಒಬ್ರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ ಅಷ್ಟೇ.
Mr. Yaji?
Whether he appears at ಕಾರವಾರ ಅವ್ರಿಗೆ ಗೊತ್ತು. ಜೋಯಿಡಾ.
And AG accepts notice for respond number
1 and 2.
1 and 2. ಯಾಜಿ ಅಪಿಯರ್ ಆಗ್ತಾರಾ ಏನು?
ಅಲ್ಲ, ಯಾಕಂದ್ರೆ he used to appear at ಕಾರವಾರ ಅಂಕೋಲ ಬರ್ತಿದ್ರು ಅವರು. I will intimate him.
ಅವ್ರು ನೋಟಿಸ್ ಕೊಡೋದ ಇಲ್ಲ summons? Petitioner is permitted to take out hand summons to respond number 3 as also serve any panel counsel of respond number 3 if so appointed. Relist on 21st.
Please, lords.
Please, my lordship, petitioners and respondent number 3 and 4. There is dispute between the parties before the appellate court here, my lordship, in RSA. The petitioners are filed a suit for partition and separate possession. Suit was decreed, my lordship, and we are objected that they are not the children of Gangadhar Sir. Even then, my lordship, we gave a representation before the Tehsildar. They are not the children of Gangadhar Sir.
2022 order challenge.
Also, we never about this order, my lordship, because they are not issued any notice. In the year 2020 itself.
State, just because you came to know about it.
My lordship,
And
in the
he accepts notice for respond number 1 and 2. Issue emergent notice to respond number 3 and 4, returnable by 14 March.
Till then status quo, my lordship, because my lordship, in the year 2020 annexure C, my lordship, I gave a representation stated that the appeal is pending before this honorable court, and RTS case also proceeding before the court, Tehsildar. Even then, without considering those documents, my lordship, he passed the enter their names, my lord.
This is the order of 22.
May please, my lordship, recently. May please, ma.
For the petitioner in this case, petitioner's father is a owner of land bearing survey number 28/2 and 29/2 and 126/3, my lords. He was died on 28/5/2021. After that, the petitioners are filed application for
Interim order ಏನಿಲ್ಲ.
the
He accepts notice for respond number 1 to 4. Issue emergent notice to respond number 5, returnable by 21st March.
next week, small.
Service ಆಗಿ ಬರ್ಬೇಕಲ್ಲ, ಒಂದ್ ವಾರಲ್ಲಿ ಬರುತ್ತಾ?
I will serve the copy next week.
Petitioner is also permitted to take out hand summons to respond number so and so.
Date next.
Emergent next week ಅಲ್ಲ, 3 weeks ಆದ್ರೂ ಬಿಡು. 7th March.
Please.
8/6/30.
Lord, the petitioner, Lord, is the trust, Lord. It owns more the property acquired under the gift deed, Lord. Annexure B, Lord, page 647. It is, Lord, dated 16/1/2020, 2013, Lord. Lord, for reconstruction, Lord, the conventional, my lord, the cultural hall, my lord. As per Annexure C, permission has been given by the sixth respondent, dated, my lord, 30th/3/2013. Lord, according to the my lord, plan has been produced. It has been accepted, Lord, by the Panchayat, page 54. Lord, then, my lord, construction, my lord, carried out. I have produced the photograph, page 55, Annexure D. The construction work is not completed, except finishing work, plastering, painting, and electrocution. Lord, then, my lord, the Panchayat also issued as per Annexure, my lord, Lord, my lord, no objection for a power supply in respect of, my lord, the premises. Then, my lord, the respondent number, my lord, 7, stated to have made an objection about, my lord, the construction of, my lord, the building will come in the way. Therefore, it is to be stopped, my lord, as per Annexure, my lord, F, page 58. My lord, acting on this, my lord, the sixth respondent by notice dated 11/9/2024 informed the petitioner to stop the construction work. Then, my lord, we have given the complaint to the police, my lord, because, my lord, in the photographs, my lord, the police personally, my lord, are interfering. Though the permission was obtained, construction already completed, for finishing work, my lord.
Construction already completed.
Completed, my lord.
It can't be completed.
Only finishing plastering and electrocution, my lord, paintings works left out. For that, my lord, the, after even issuing this notice, my lord, as per Annexure, my lord, J, page 24/9/2024, my lord, page 67. For that also, my lord, because of interference by the police and local, we have taken permission for finishing work. The Panchayat has given permission. Page 67.
Where is the complaint filed by them to the PDO?
My lord, complaint, my lord, according to, my lord, is, my lord, Annexure F, my lord, 6/9/2024.
Complaint by the PDO.
Page?
PDO on there.
Page?
Page, my lord, 58.
58. It is the respondent, contesting respondent having submitted
Respondent number
objection.
7.
It is not a.
ಏನಂತ ಹೇಳ್ತಾರೆ? What is their problem?
ಇದರಲ್ಲಿ ಅವರು ನಾವು ಇದು
Second paraದಲ್ಲಿ ಹೇಳ್ತಾರೆ, the
ಮಾಡೋದ್ರಿಂದ
reason for what.
ಅವ್ರಿಗೆ ತೊಂದರೆ ಆಗ್ತಾ ಇದೆ ಊರಲ್ಲಿ ಅಂತಂತ.
And what is the complaint? Why should they stop?
Being the lawful owners, my lord, they are not supposed to.
Yeah, accepts notice for respondent number 1 to 4. ಯಾರು ಕೊಟ್ಟೂರ್ ತಾಲೂಕ್ ಪಂಚಾಯತ್,
ಕೊಟ್ಟೂರ್ ಗ್ರಾಮ ಪಂಚಾಯತ್,
ವಿಜಯಪುರ, ವಿಜಯನಗರ,
ವಿಜಯನಗರ, ಭೂಷಣ್ ಕುಲಕರ್ಣಿ ಅಲ್ಲ, ವಿಜಯ್.
ಶಿವರಾಜ್ ರೆಮಟ್ is directed to accept notice for respondent number 5 and 6. 7 ಯಾರು ಇದಾರ ಅಪೇರ್ ಆಗೋರು?
Not emergent notice.
Issue emergent notice to respondent number 7, returnable by 21st March. The execution and implementation of notice dated 5/12/24, bearing number so and so, issued by 6th respondent to the petitioner. He stayed till the next date of hearing. Process fee and copies to be furnished by end of day 14th February, failing which the interim order will stand automatically vacated. Accepting reasons stated in IA 1, production of certified copy of Annexure L is dispensed with.
On this party,
For the petitioners here in your lordship. Your lordship, here we are seeking a writ of certiorari to quash the proceedings initiated by the respondent number 1, your lordship. The complaint was filed under section 3(1)(b) of the Anti-Defection Act, your lordship. The fact is that your lordship, the president of the Gadag district had issued a whip which was violated by the petitioners, your lordship, and based on that, complaint was lodged before the chief executive officer. Your lordship, the first ground is that, your lordship, the whip which was issued by the president was not as per the law, your lordship. That was not personally served to the petitioners. And another ground is also in the same in the said election there was there was a split in the political party, your lordship. The petitioner number 4 and 5 nominated as president and vice president, and they got elected by the majority of the BJP parties, your lordship. And even there was no delegation of power to the district president to issue a whip, your lordship, as per the law.
They only initiated proceedings, you'll have to reply to it.
But here the petition number
Respondent number 1 has the power to initiate proceedings.
is, please, your lordship.
Complaint which has been filed.
But the whips which were issued were not personally.
Now nodbeka or respondent number 1 nodbeka. Let respondent number 1 consider it. Then thereafter you can come here. It's only a notice which has been issued.
Pursuant to which they have appeared and sought time to file objections. ಹೌದು ಆಗಿದ್ದಾರೆ. ಅಲ್ಲ ಆರ್ಡರ್ ಶೀಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ. At page 43 is the order sheet. Typed copy on 9/1/2025.
Reserve all your contentions are kept open. Petitioner is before this court seeking for the following reliefs. Now AG accepts notice for respondent number
1 and 3.
1 and 3. 2 and 4 error.
2 and 4 Gajendra, TMC.
Naregal Gadag.
Bhushan Kulkarni, Naregal. Bhushan Kulkarni.
ನೀವು ಹೇಳಬೇಕು ಅವರಲ್ಲ ಹೇಳಲಿಲ್ಲ ಅಂದ್ರೆ ಜಂಡ್ ಭೂಷಣ್ ಕುಲಕರ್ಣಿ ನರೇಗಲ್ ಗಜೇಂದ್ರ ಗಡ್
ಹೌದು
ತಾಲೂಕಾ ವೈಸ್ ಇಲ್ವಾ ಅದು ಲಿಸ್ಟ್
ಅಲ್ಲಿನ that is the difficulty.
ಫುಲ್ ಮಿಸ್ಟೇಕ್ ಮಾಡಿದ್ದಾರೆ. Notice to respond number 2, 4 and 5 is dispensed with in view of the proposed order to be passed. The petitioner is before this court seeking for the following reliefs. What is essentially challenged is the proceedings initiated by respondent number 1 by issuance of notice under section 3(1)(b) of the Karnataka Local Authorities Prohibition of Defection Act 1987. Though several contentions have been urged by the counsel for the petitioner that the whip had not been the person who had issued the whip was not authorized to do so, and that the whip has not been properly issued. And as said, there is no violation by the petitioners requiring the initiation of proceedings. What can be seen from the papers is that only a show cause notice has been issued. It is for the petitioner to submit their objections to the said show cause notice. And this court cannot at this stage intercede in the matter when the matters are proceeding pending before the deputy commissioner. In that view of the matter, keeping all contentions open, reserving the liberty to the petitioner to agitate all their defenses before the first respondent, the petition stand disposed.
Then Rajshekar Gunjali.
Petition. The question is annexure C issued by the PDO, respond number 3 PDO. But they are not issuing the form number 9 and 11. Since there was a dispute regarding the boundary by the adjacent owners.
What is annexure C?
C is the endorsement issued by the respond number 3 Since there was a boundary dispute, they are not going to issue the form number 9 and 11 until
pending.
No, my lord, there is no. The earlier, my lord, the survey was conducted in 2002. As per the survey, my lord, we have from the layout. After, my lord, obtaining the approval from the authorities.
Layout plan sanction ತಗೊಂಡಿದ್ದೀರಾ?
ತಗೊಂಡಿದ್ದೆ. I have produced the, my lord, annexure. A is the, my lord, plan, approval plan of the, my lord, layout.
ಇದೇನೆಲ್ಲ
Hereafter, my lord, adjacent.
ಹೋಗಿ ಒಂದೇ ಸೈಟ್ ಒಂದೇ ರೋಡ್
Adjacent owners, my lord, there is a boundary dispute. Objection raised by the, I mean, adjacent owner, landowners. The PDO has written a letter to the, my lord, ADLR to remeasure the land, my lord. ಮತ್ತೆ ಇನ್ನೊಂದ್ಸರಿ measurement ಮಾಡಿದ್ರು. Thereafter also, my lord, we have requested him to issue the, my lord, form 9 and 11. Again, my lord, adjacent owners, my lord.
Where is the survey reports? ಮಾಡಿಲ್ಲ. ಯಾವುದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ?
Annexure B, my lord, that was the letter written by the, my lord, ADLR.
ಸರ್ವೆ ರಿಪೋರ್ಟ್ ಇಲ್ಲಿ. ಸರ್ವೆ ರಿಪೋರ್ಟ್. And AGA accepts notice for respond number 1, 2 and 3 are
For 2, my lord, one Hosmat appears for Jilla Panchayat Dharwad. Hosmat. GS Hosmat. GS Hosmat.
GS Hosmat for respond number 2. 3 ಗೆ
ಯಮನೂರು ಗ್ರಾಮ ಪಂಚಾಯತ್.
ನಾವೀಗೊಂದು ಯಮನೂರು.
PDO.
ನೀವು ಯಾರು
ಅವ್ರು ಹೇಳ್ತಾರೆ ನೀವು ಸುಮ್ಮನೆ ಇರ್ತೀರಾ?
ಅಲ್ಲ, ಕೌನ್ಸಿಲ್ ಯಾರು
ಚೆಕ್ ಮಾಡ್ಕೊಳ್ಬೇಕು ನೀವು.
ಅಲ್ಲ, ZP ಇದ್ದಾರೆ, ಬಟ್ ಪಂಚಾಯತ್ ಯಾರು
ಲಿಸ್ಟ್ ಮಾಡಿದಾರೆ ನೋಡ್ಬೇಕು ನೀವು. ಏನ್ ಮಿಸ್ಟೇಕ್ ಇದ್ರೆ ಅವ್ರಿಗೆ ಹೇಳ್ಬೇಕು.
ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ ಇಲ್ಲ. ಯಮನೂರದಿಲ್ಲ ಸ್ವಾಮಿ.
ಯಮನೂರ್
ಇಲ್ಲ.
Issue emergent notice to respond number 3, returnable by 14th March. Counsel for the petitioner is also permitted to take out hand summons to respond number 3. He is also directed to place on record the survey reports as regard the survey which are said to be conducted on earlier 2 occasions.
Please.
We list on 14.
My lordship, petitioner is the defendant, my lordship. I was denied my opportunity to further cross-examination of PW1, my lordship. Aggrieved by the annexure G, my lordship, page number 6, typed copy. My IA number 3 and 4 for recall and reopen of the case of PW1 has been rejected by lordship. Due to ill health of the defendant counsel, he could not further cross-examine the PW1, my lordship, on the said date. But the trial court has wrongly applied the principle of res judicata, considering the adjournment given on IA number 2, my lordship. The grounds have been different. On IA number 2, the adjournment was sought for the purpose of the counsel being engaged in the other court, my lordship. And subsequently, whenever the defendant counsel was ready, the PW1 had remained absent. On 5 consecutive dates, he remained absent, but no adverse orders were passed against him, my lordship. But one final opportunity when the defendant counsel had prayed for further cross-examination of PW1, principle of res judicata was being, and though the plaintiff counsel did not have any objection for being allowed on cause, my lordship, even then the trial court has rejected my prayer for recall and reopen of the case of PW1, my lordship.
Senior civil judge.
Yes, my lordship. Just an adjournment for the next day was being prayed, my lordship. Adjournment for the next day was not allowed.
You also not been diligent, madam. Issue notice to the respondent returnable by 21st March. The further proceedings before the invoice number 131 of 2022 on the file of the third additional senior civil judge and CJM Dharwad is stayed till the next date of hearing. Process fee and copies to be furnished by end of day 14 February. Acknowledgement of service on the counsel for the respondent before the trial court to be filed on or before 19th February, failing either of which the interim order will stand
Next date
automatically.
is given on 24, my lord. 24.
Acknowledgement serve ಮಾಡಿ ಅವ್ರಿಗೆ,
Please, my
so ಅವ್ರು ಬೇಗ ಬರ್ತಾರೆ.
Please, my lord.
As per Annex D, my lord, an award came to be passed for the damages, my lord, about 8 months back. Now, till this day, my lord, they have not paid the, my lord, the amount, compensation, page number 20, my lord.
Execution.
Yes.
Execution will writ petition.
Similar matters, my lord, this on court has.
All those
directed.
such type of petitions, my lord, we objected in so far as implementing that of award is concerned. They have to initiate execution proceedings.
No, no, this,
attachment ಮಾಡಿ.
this on court, my lord, may take your lordship, but page number, similar orders, my lord, page number, annexure E3. Page
That is the fault which has been
because,
committed on behalf of the respondent
the
state.
respondents 1 and 2 have undertaken, my lord, to deposit the amounts in similar cases.
Playing
And they have
mandamus in
deposited and they have paid, my lord.
How do we grant mandamus when you have alternate remedy? What is your right for a mandamus?
My lord, so because as per Annex D, my lord, that's based, Annex D. Annex D. My lord, the damages came to be passed award, damage award.
ಇದನ್ನ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿ, KNNL ಆಫೀಸ್ ನ ಅಟ್ಯಾಚ್ ಮಾಡಿ.
ಅಲ್ಲ
ಬರ್ತಾರೋ
ನೀರಾವರಿ ನಿಗಮದವರು ಅವರು. ಅಲ್ಲಲ್ಲ.
It's an award, not an order passed by any competent authority. That's the civil judge alla.
ಇದು
It's only
deputy
an award
commissioner.
passed by the SLO.
SLO has passed award.
If it is passed by the any
Civil court.
and all, we can file it.
Because the damages, this is before taking possession.
You are not asking for enhancement.
No.
No, enhancement.
This is attained finality.
Yes, yes.
Why not AEP?
Because the, since SLO has passed an order, award. Yes.
ಯಾವಾಗ್ಲೂ SLO ನೇ ಅವಾರ್ಡ್ ಮಾಡೋದು.
ಹೌದು, that's.
If you want enhancement ಮಾತ್ರ ಕೋರ್ಟ್ಗೆ ಹೋಗ್ತೀರಾ.
Yes, yes.
If you are agreeable for that amount, can you not file a EP?
Because these damages award came to be passed by virtue of the direction of the Honorable Supreme Court. Supreme Court and.
We'll observe your, if that is the issue which is coming in the way, then we'll set that law in place.
Lordship.
That you can file a, we'll reject your contention and say that EP is maintainable. So that in future you can do that.
Lordship, kindly day after tomorrow, my lord, will let me know the position of the law, whether the EP is maintainable against the.
You can't be a mandamus coming for enforcement of an award. ಎಷ್ಟು ಮ್ಯಾಟರ್ ಬರುತ್ತೆ ಆಮೇಲೆ ಹೈಕೋರ್ಟ್ಗೆ? We'll be opening floodgates. ಎಷ್ಟು ಅಕ್ವಿಸಿಷನ್ ಆಗುತ್ತೆ?
Only in respect of interest, that by way of damages.
Damages,
awarding interest. Any of the orders.
ಯಾವ್ದಾದ್ರೇನು Mr. Patil, it is executable.
Executable, it's if it is a decree, but it's an award. That's what you're saying.
Sir,
This contextual, otherwise the writ is not.
Not maintainable, that's.
That is the.
It is executable. You will be entitled for interest in terms of Land Acquisition Act only.
This, under section 34 only, my lord.
ಬರುತ್ತೆ.
But.
Be entitled for all the benefits if they don't pay.
Yes. But.
Realization. ಎಲ್ಲ ಇರುತ್ತೆ.
But.
ನೀವು ಇಲ್ಲಿ mandamus ಬಂದ್ಬಿಟ್ರೆ ಆಮೇಲೆ ಅದೆಲ್ಲ ಹೋಗುತ್ತೆ.
ಮತ್ತೆ ಅವ್ರು ಬಂದು objection
Speed.
pillar ಅಂತ ನಾವು ಬರೇ ಇದರಲ್ಲಿ ಅಡ್ಡಾಡೋದು. 10 acquisition ಇರೋದು.
ಅಲ್ಲಿ ಇಂಟ್ರೆಸ್ಟ್ ಎಲ್ಲ ಹೋಗುತ್ತೆ ನಿಮ್ಗೆ ಇದ್ರಲ್ಲಿ ಮಾಡಿದ್ರೆ.
2010 first acquisition. They did not pay the damages because prior to issuance of 4-1 notification, they have taken the possession of the land.
They have fixed 1,15,000.
Yes, ma'am.
These
what? Damages,
Yes, ma'am. Page number 24, Maladi, total damages, Maladi, 67 lakhs, 66,000.
ಬಡ್ಡಿ 8% ಕೊಟ್ಟಿದ್ದಾರೆ.
Yes, ma'am.
That is first year 9%, ಆದ್ಮೇಲೆ 15%.
But 1% ಕಡಿಮೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಮತ್ತೆ
Losing that
ಅದರಲ್ಲೇ.
if you go by this.
ಅಲ್ಲ ಇದನ್ನ ಕೊಡ್ತಾ ಇಲ್ಲ ಅವರು.
ಅದಕ್ಕೆ 12% ಬೇಡವಾ?
ಇಲ್ಲ, page 27.
Page 25 ಇಲ್ಲ 8%.
Last page number 25.
May kindly be seen.
ಹಾ
ಮಾಡಿದ್ದಾರೆ.
ಬಡ್ಡಿ 8% ದಿನಾಂಕ 2/7/2009 ಇಂದ 7/6/2024 ವರೆಗೆ
8% ಇಲ್ಲಿದೆ. 8%. ಕಬ್ಜಾ ಪಡೆದುಕೊಂಡ ದಿನಾಂಕ 10/9/91 2009 15% ಕೊಟ್ಟಿದ್ದಾರೆ.
2009 ವರೆಗೂ.
ಹಾ 2009
2009 ಇಂದ 8%.
2009 7/24 8% ಕೊಟ್ಟಿದ್ದಾರೆ. 12% ಆಗ್ಬೇಕಾದ್ರೆ.
ನಾವ್ ಹೇಳ್ಬೇಕು ನೀವ್ ಹೇಳ್ಬೇಕು ಗೊತ್ತಿಲ್ಲ.
ನಾವ್ ಇದು ದುಡ್ಡು ಬಂದ್ರೆ ಸಾಕಂತ ನಾವ್ ಹಾಕೊಂಡಿದ್ದೆ. ಅಷ್ಟಾಗಿದೆ ಪರಿಸ್ಥಿತಿ.
ಒಂದ್ ವರ್ಷ ಆಗ್ತಾವ.
7%
award in the year 2024.
7% ಡಿಸ್ಕೌಂಟ್ ಕೊಡ್ತಾ ಇದೆ. ಇಲ್ಲೇ ಕೊಟ್ಬಿಡಿ.
ಅಲ್ಲ
Actually they should.
ಒಂದ್ ವರ್ಷ ಆಯ್ತು ನಾವು
ಬೇಕಲ್ಲ.
ಅಲ್ಲ, ಇಟ್ ಇಸ್ ಎ ಬೆನಿಫಿಷಿಯರಿ.
ನೀರಾವರಿ ನಿಗಮ 1 to 3
7% ಡಿಸ್ಕೌಂಟ್ ಸಿಗ್ತಾ ಇದೆ.
ಅಲ್ಲ ಒಂದ್ ವರ್ಷ ಆಯ್ತು ನಾವು.
ಇಲ್ಲಿ AG accept notice for respond number 4. KNNL ಯಾರು?
Accept notice for KNNL. ಏಜ್ ಇವರು ಗವರ್ನಮೆಂಟ್
Kanvi is appearing, I think. ಅಲ್ಲ
ಅವ್ರು ಯಾರು ಬೇಕಾ ಹೇಳಿ.
ಅಲ್ಲ ಯಾರು ಇದ್ರು ಮತ್ತೆ
ಯಾರು? KNL ನೀವು ಪ್ಯಾನಲ್ Sri V.S. Kalsurmat is directed accept notice for respond number 1 to 3. The sixth one is granted a week's time to obtain instruction, make a submission. Relist on 20th.
Next matter same.
ಚಾಲೆಂಜ್ ಮಾಡಬೇಕು ನೀವು. 13 same.
Please
Connect to each other and relist.
please. Yeah, that's it. Copy put.
14 we have party.
Please. I have filed this application for Madras State. Earlier, this honorable court was pleased to granted the interim order. My lord, thereafter, my lord, time to time it was extended. And my lord, the previous occasion.
14.1 amendment has not been carried out. Who appears in 14.1? Mr. Badulli,
Yeah, I'm appearing for Shivraj.
non-filing dismissed.
Two days time.
No 2 days time. 25/1/25. You are granted time.
Not get any details of the legal heads. 8 and 16.
If needful is not done, for dismissal.
Lord, I appear for that petition. So far as
Both will be dismissed.
so far as the non taking of steps, abatement may be ordered. Lord, clear request. So far as the
Preemptory order has been passed, Mr. Tali. We'll abide by it. ಏನು ಅಷ್ಟು ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ
I had paid a PF, but I am unable to get the details of legal heirs. I called my party, he tried it. He is telling he is unable to get the details of legal heirs. I had paid a PF on the same time, but they have not.
14.1, despite the order dated 25/1/2025, the amendment has not been carried out, nor the amended cast title has been filed. Hence, petition is dismissed for non-prosecution. 14.2. Process fee for 16 ಕೊಟ್ಟಿದ್ದೀರಾ?
I had paid already on last day.
Counsel for the petitioner submit that he has made payment of process fee for respond number 16, 6 and 8.
16 and 8 and 16 have expired. That respondent number 18 has expired. 7 and 18 again not claim, unclaimed, my lords.
16, 6 and 8 ಕೊಟ್ಟಿದ್ದೀರಾ?
Please, lords. Please, I had paid.
If needful has been done, registry is directed to issue notice to respond number 16, 6 and 8, returnable by 23rd April. Despite several opportunities have been granted and despite the order dated 25/1/2025, no application has been filed to bring the legal revenue of deceased respond number 7 and 18. Respond number 7 and 18 having expired long ago, the petition having been abated against them. the petition is formally dismissed against respondent number 7 and 18.
So far as the merit is concerned, my lord, this is covered by the judgment of the Supreme Court.
They have to be served, Allah, Mr. Patil.
Please.
Without hearing them, we can't do. Unless you accept notice.
No, I can't do it.
If
Whole
you accept
difficulty, my lord,
notice for
everything is
16
settled. The tribunal has decided the rights of the parties correctly.
If any of you accept the
It
notice
is
for
not
them,
like
we'll
that.
take it up. Error accept ಮಾಡ್ತೀರಾ? 18, 16, 6 and 8. ಯಾರು ಇಲ್ಲ. Let it come.
My lord, stay, my lord, stay may kindly be granted.
How can it
Earlier, my lord, earlier stay was granted. Your question is very short. My lord, the family definition, the occupancy right has been granted to the, my lord, second wife of daughter. Second wife daughter. So his son is, and class 1 here is there, my lord, wife, my lord. Earlier stay has been granted. Your lordship kindly see. The interim order.
Came to an end on 27 to 24.
It was extended, but time to time, your lordship kindly see, extended.
You
my
show
lord.
us, we'll see.
Huh?
You show us and we'll see. From what we see, 27 to
Subsequently
24.
extended.
27 to 24, it has come to an end. We can't extend it.
My lord, I have filed an application, my lord. Grant for at least, my lord, stay, my lord.
1.5 ವರ್ಷ ಆದ್ಮೇಲೆ ನೀವು
Delay.
application ಹಾಕಿದ್ರೆ
What has happened is, now, my lord, your lordship kindly see, because earlier stay has been granted.
We'll have to hear the other side on that. That is actually final hearing. We'll hear you on 23rd.
Please.
Your lordships may kindly.
You file recall application, will impose cost of 5,000 rupees and then consider. Preemptory order ಏನು ವ್ಯಾಲ್ಯೂ ಇಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡಕ್ಕೆ?
We carry out.
Next week.
You file.
Next week, your lordship may take the matter.
23rd April.
Please.
My lord,
Dismissed for non-production of certified copy. I issued a certified copy, my lord, so please.
ಯಾಕ್ರಿ ಹಿಂಗ್ ಮಾಡ್ತೀರಾ?
Typed copy and certified copy I received it, my lords. Now I want to place it.
Non-compliance with process objection. ಏನ್ office objection? You have produced it?
But now I will produce it, I am having it.
ಬರೀ ಅಷ್ಟೇ ಅಲ್ಲ. ಇನ್ನ 4 ಇದಾವೆ.
No, sir. I am permitted to comply thereafter next Wednesday or Thursday. By that time I will come.
The 1 of 24 has been filed for recalling the order dated 23/8/2024. The said order was passed dismissing the above petition for non-compliance with the office objection. Pending consideration of IA 1 of 24, the petitioner is permitted to comply with the office objection. If office objection not complied by 20th February, IA 1 of 24 would also be liable to be dismissed by imposing cost. Relist on 24th.
Please.
I am for the contesting respondent port 10, my lord.
Ready? Ready?
Ready, sir.
Password.
Lord, sir. Challenging the order passed by a regional commissioner to delete my name as one without the jurisdiction.
You are appearing for R1.
Please.
Mahesh H. delete man. Shri Mrityunjay Tata Bangi has appeared for respondent amount. Delete the name of Shri Mahesh H. as that appearing for respondent number 1. Shivraj Badoli Wakalat not filed.
For Milord, municipality.
You don't want to appear?
No, we'll do the needful, my lords.
Then why haven't you filed Wakalatnama?
We'll do the needful by today.
We are not ready?
Yes, my lords. My lords,
Yes.
I'm challenging the order.
Respond number 4 to 6 notice dispensed with.
ಹಾ ಹೌದು, ದೇ ಆರ್ ಮೈ ಪ್ರೀವಿಯಸ್ ವೆಂಡರ್ಸ್.
3 ಆಯ್ತು. Yes, ಹೇಳಿ.
My lords, I am challenging the order passed by Regional Commissioner Kalburgi in deleting my name from the property records and directing me to a civil court as one without the jurisdiction, my lords, and also on a factual grounds. My lord, the property in question is a house site, my lords. That was within the jurisdiction of the Amravati municipality in the year 1980s, my lords. In the year 1980s, my lord, the property belongs to one Lakshmi Devi, wife of Panduranga.
Yes.
My lord, then my lord, in the year 1995, that Lakshmi Devi got her son's name entered in that particular property, my lords. Then my lord, her son named it in his wife's name, that is Hanumakka. That is page number annexure B, my lord, that is page number 14. Then my lord, this Hanumakka sold his property by way of a registered sale deed to respond number 5. That sale deed is produced at annexure C. Then my lord, this respond number 5 sold that particular property to respond number 6. Then my lord, the respond number 6 names entered into municipality records. She in turn sold through a registered sale deed to these petitioners, my lords.
16, 17, 18.
My lords.
On 16,
16, 17, 18.
18 ones.
18, my lords.
Yes.
Then my lords, one of the neighbor tried to interfere with my possession, my lord. I filed a civil suit, my lord, wherein the injunction order has also been passed. That is produced at annexure M, my lords. So my lord, this respond number 1, after all these years, after 4 decades, files a revision before the regional commissioner stating that in the year 1947, her grandfather has purchased that property and that has been inherited by her father. Her name is to be entered in the property records.
2018, respond number 6 sold southern half portion to petition number 1.
Yes, my lords.
And northern half portion to respond number 2 ಅಂತ ಹೇಳಿ.
ಇಲ್ಲ petitioner number 2, my lords.
Respond number 2 ಅಂತ ಬರ್ದಿರ.
Oh, I'm sorry, my lords.
Respond number 2 regional commissioner ಗೆ sale.
And my lord, this particular, my preliminary contention is, my lord, this particular order has been passed under section 322. 322, my lord, the regional commissioner doesn't have a jurisdiction because the jurisdiction lies with the director of municipal commission. Yes, my lords. So, my lord, even on a factual aspects, my lords, this in the year 2000, they challenged the order of entering our name in the year 2000, my lord, and not before that, my lord. Even before in 1980s, my lord, our names are in the property records. Municipalities Act.
Suit in 94 was filed for?
Filed for injunction, my lord, against somebody else who is not a party here. Only to show my possession, I have produced that.
So everybody wants your property.
The director of municipal administration may call for and examine the record of any proceeding, including the orders of assessment and revision of assessment under this act of any subordinate officer, and after such an inquiry as is deemed fit, if he is satisfied that the order of the subordinate officer is contrary to law and has resulted in a miscarriage of justice, pass such orders thereon.
Where is the impugned order?
Impugned order is at annexure A, my lord, at page number 10. And even on factual aspect, my lord, simply the order, it is mentioned that the fraud has been played. Absolutely, there is no basis for that.
How did Lakshmi Devi get the property?
My lord, it is an ancestral property. Since 1980, it is in her name. And the original title couldn't have been traced. And as far as this revision petition has been filed, my lord, even she doesn't have a entire order says that, my lord, there is no registered sale deed. So the entry in the year 2000 cannot be believed. But at the same time, my lord, even one who has objected, she doesn't have a sale deed.
How did Lakshmi Devi get the property?
That is ancestral property, my lord.
ಎಲ್ಲೋ ಒಂದು ಏನೋ ಡಾಕ್ಯುಮೆಂಟ್ ಇರಬೇಕಲ್ಲ ಬಿಫೋರ್ ದಟ್.
ಯಾವುದು ಅದರಿಂದ ಮೊದಲು ಅಮರಾವತಿ ಕಾರ್ಪೊರೇಷನ್ ಇತ್ತು 1988 ನಲ್ಲಿ ನಾನು ಅದನ್ನ ಪರ್ಮಿಷನ್ ತಗೊಂಡು ಅಲ್ಲಿ ಮನೆ ಕಟ್ತೀನಿ. ಸೊ ಸಿನ್ಸ್ 1980 there are records, my lords.
So prior to that, nobody has records.
No, my lords.
Lord, this property was belonging to the first respondent's grandfather. Lord, after his demise, my lord, father did not get his name entered. It is thereafter, my lord, the granddaughter made an application to enter her name. My lord, the finding of fact with regard to, my lord, before the commissioner is,
Firstly, he is not competent under 320.
Lord, the civil court, my lord, it's a pure
Secondly,
civil
there is a
court.
title dispute.
Yes, so far as my lord, the sale deed, on perusal of the sale deed says, my lord, though there are sale deeds which are produced before me, however, I have seen the encumbrance of these properties. Absolutely, there is no sale deed which is reflected in the sale deed, in the encumbrance. So the sale deeds which are produced before are fictitious, and the person who has
Where is the encumbrance certificate?
My lord, encumbrance, the first sale deed is at annexure D, my lords. Sorry, my lords. The encumbrance, that is at page number 15. That is Hanumakka, that is wife of Ramanna, originally, who sold it to Mrutyunjaya for 10,87,000.
ಇದೆಯಲ್ಲ encumbrance certificate.
Then, my lord, next sale deed, my lords, that is a registered sale deed. That Mrutyunjaya in turn sold it to respondent number 6. That is at page number 17. This is also a registered sale deed. Then, my lord, her name got entered into municipal records. Form number 3 is produced at annexure E. That is at page number 23. Then, my lord, she in turn sell it to these petitioners. That is at annexure F. These are also registered sale deeds. Then, my lord, their name came to be entered.
And PDOs and Tahsildar, the regional commissioner passing this kind. ಇವ್ರಿಗೇನು ಹೇಳು? ಡಾಕ್ಯುಮೆಂಟ್ ನೋಡದೆ which encumbrance certificate did you see that ಅವ್ರಿಗೆ ಆಕ್ಸೆಸ್ ಇಲ್ವಾ ಭೂಮಿ ಕಾವೇರಿ ಎಲ್ಲ?
ಅವಾಗಿರ್ಲಿಲ್ಲ. 2020-21.
ಯಾವಾಗ ಮಾಡಿರೋದು ಇದು ಆರ್ಡರ್?
2020, my lords.
2020. 13/5/21.
21, my lords.
13/5/21 ಇಲ್ಲ.
Page number 12. Internal page number 3 of the executive order.
Yes.
ಅರಕ್ಷಣದಾರರ ದಿನಾಂಕ 21 23/4/2019 ಪ್ರಕರಣದಲ್ಲಿ ಆಸ್ತಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಹೊರಾಯುಕ್ತ ನಗರಸಭೆ ಹೊಸಪೇಟೆ ಅವರು ಸದರಿ ಆಸ್ತಿ ಹಕ್ಕು ಬದಲಾವಣೆ ಪ್ರತಿಯ ಸಂಖ್ಯೆ ಸುವರ್ಣ ಸುದ್ದಿಪತ್ರ ಪ್ರತಿ ಹಾಗೂ ದಿನಾಂಕ 1/1/47 7/2/19 ಸದರಿ ಆಸ್ತಿಯ ಪೂರ್ಣಭಾರ ಪ್ರಮಾಣ ಪತ್ರ ಪ್ರಮಾಣ ಪತ್ರ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಇವುಗಳನ್ನು ಉಲ್ಲೇಖಿಸಿದಾಗ ಪರೀಕ್ಷಣದಾರರು ಅಜ್ಜ ಮುಕ್ತ ಶಂಕರ್ ಭಟ್ ಅವರು ಶ್ರೀ ಮುನಿರಾಜ್ ಇವರಿಂದ ಪ್ರಕರಣದಲ್ಲಿನ ಆಸ್ತಿಯನ್ನು ಖರೀದಿಸುವ ಬಗ್ಗೆ ಕಂಡು ಬಂದಿದೆ. ಹಾಗೂ ಪೂರ್ಣಭಾರ ಪ್ರಮಾಣ ಪತ್ರವನ್ನು ಉಲ್ಲೇಖಿಸಿದಾಗ ದಿನಾಂಕ 1/47 ಇಂದ 2019 ವರೆಗೆ ಸದರಿ ಆಸ್ತಿಯು ಶ್ರೀ ರಾಮ್ ಭಟ್ ಅವರ ಹೆಸರಲ್ಲಿರುವ ಬಗ್ಗೆ ಹಾಗೂ ಸದರಿ ಪೂರ್ಣಭಾರ ಪ್ರಮಾಣ ಪತ್ರ ಮೇರೆಗೆ ದಿನಾಂಕ 2 ಮೇರೆಗೆ ಸದರಿ ಆಸ್ತಿ ಕುರಿತು ಯಾವುದೇ ನೋಂದಾಯಿತ ಪತ್ರಗಳನ್ನು ಮುಖಾಂತರ ಆಸ್ತಿ ವರ್ಗಾವಣೆ ಆಗದೇ ಇರುವುದು ಸ್ಪಷ್ಟವಾಗಿ ಕಂಡು ಬಂದಿದೆ.
ಅದು ಸರ್ವೆ ನಂಬರ್, ಇದು ಮುನ್ಸಿಪಲ್ ನಂಬರ್.
And my lord, even the commissioner has filed his objection stating that there is absolutely no records in their name. That is at page number 2, the 11 ನಲ್ಲಿ.
previous ನಂಬರ್ ಒಂದು ಎನ್ಕಂಬ್ರೆನ್ಸ್ ಸರ್ಟಿಫಿಕೇಟ್, ಮುನ್ಸಿಪಲ್ ನಂಬರ್ ಒಂದು ಎನ್ಕಂಬ್ರೆನ್ಸ್ ಸರ್ಟಿಫಿಕೇಟ್, ಖಾತಾ ನಂಬರ್ ಒಂದು, ಹೌಸ್ ಲಿಸ್ಟ್ ಒಂದು, ಇನ್ನೇನ್ ನಂಬರ್ ಇದೆಯಪ್ಪ ಇಲ್ಲಿ?
And my lord, as far as those documents, they have filed objections. None of the documents are forthcoming. ಅವ್ರು ಹೇಳೋ ಹಾಗೆ ಇತ್ತಂದ್ರೆ.
The petitioner is before this court. What is to be delegated?
ಅಲ್ಲ, ಅದನ್ನ ಆರ್ಡರ್ ನಲ್ಲೇ ಮಾಡಿದ್ದಾರೆ. What is our contention is let them go to a civil court, not us.
Not you.
Yes, my lord.
Exactly. Petitioner is before this court seeking for the following reliefs. The petitioners claim to be absolute owners in possession of residential property bearing old door number 89-103 having old assessment number 90-100 and new door number 52 and assessment number 54. ಇಷ್ಟೆಲ್ಲ ಆಗಿದೆ, ಅದು ಯಾವುದು ನೋಡಿಲ್ಲ. Situated in 15th ward of Hospete city of Bellary district.
See that is, I did not make her also.
The petitioner claims that the property originally belonged to the family of one Lakshmi Devi, wife of Pandurang, and her name came to be registered, entered into the property register of the then Amravati municipality in door number 89-203 and assessment number 90-100. Subsequently, the property was mutated in the name of her son Ramanna and thereafter in the name of his wife Anumakka. In the meanwhile, the Amravati municipality was changed to Hospete municipality and a new door number and assessment number were given to the property as door number 52 and assessment number 54. The said Anumakka is stated to have sold the property to respond number 5 PR Mrutyunjaya and a registered sale deed dated 5/4/2016. Respond number 5 Mrutyunjaya sold the property to respond number 6 Vimla Devi and a sale deed dated 17/3/2017. The said respond number 6 Vimla Devi sold the properties, aforesaid property in two portions. The northern half portion to petition number 1, the southern half portion to petition number 1 and northern half to respond number 2. And their names were entered into in the tax register and they have been making payment of the taxes. It is at this stage that respond number 1, Srimati Vinuta Gangavati, claimed that the property belongs to her family and her name is required to be entered into the property register, claiming that the property earlier belonged to her grandfather. Property in survey number ಏನಾದ್ರು ಹೇಳಿದಾರಾ ಇಲ್ಲ?
ಇಲ್ಲ, ಅದೇನು ಇಲ್ಲ. ಆಮೇಲೆ ಇವನ್ ಡೈಮೆನ್ಷನ್ ಇಸ್ ರಾಂಗ್ ಮೇಲೆ 26x22 ಅಂತ ಹೇಳ್ತಾರೆ.
Where is our petition?
ಸರ್ವೆ ನಂಬರ್ 259C.
ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲಿ
ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲ, ಹಾಕಿಲ್ಲ.
ಸರ್ವೆ ನಂಬರ್
259C ರಲ್ಲಿಯೇ 26x22 ಗಜ ಅಂತ ಹೇಳಿ. The entire property which is claimed is also different.
That she is the that grandfather was the owner of the land in survey number
259C
of
ಅಷ್ಟೇ ಹೇಳ್ತಾರೆ. ಏನು ಇದೆ ಇಲ್ಲ ಅಷ್ಟೇ.
Measuring 22x26 square yards. The regional commissioner, quite the impugned order dated 13/5 and as such sought for rectification of the entries made in the name of the petitioner and adding the name of respond number 1 by filing a revision petition before the regional commissioner under section 322 of the Karnataka Municipalities Act 1964. The regional commissioner, while the impugned order dated 13/5/2021 take into account the encumbrance certificate which has been produced by respond number 1 from 1/1/1947 to 7/2/2019, not indicating any transaction in respect of the aforesaid property, came to a conclusion that there is no sale which has been effected by the grandfather of respond number 1 and thereafter directed the entry of the name of respond number 1 in respect of survey number 259C measuring 26x22 yards and reserved liberty to the petitioner to approach the civil court. It is challenging the same, the petitioner is before this court. The submission of Shri Dayanand Baddi, learned counsel for the petitioner, is that from the year ಯಾವಾಗ ಇದು ಡೋರ್ ನಂಬರ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದು?
ಇದನ್ನ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ 2000 ಇಂದ, ಬಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಇರೋದು 27/6/88 ನಿಂದ ಇದೆ.
That from the year 88, the names of the predecessors of the petitioner have been found on the records of the Amravati municipality as indicated above. The documents which have been produced by the petitioners have not been looked into. It is only on the basis of the encumbrance certificate not reflecting the transaction in favor of the petitioner and her predecessors and their predecessors that the impugned order has been passed. Secondly, he submits that essentially, if at all there are any disputes, those disputes are civil in nature, the claim being made by respondent number 1 as regards ownership of the property, the documents reflecting the ownership of the petitioners, respondent number 2 regional commissioner ought to have relegated respondent number 1 to a civil court and not cause the entries of respondent number 1 in the records and relegate the petitioners to the civil court. Lastly, he submits that the regional commissioner is not the revisional authority under section 322 of the Karnataka Municipalities Act 1964. It is the director of municipal administration who is the revisional authority, and as such, the regional commissioner could not have excised any right in respect, any revisional powers in respect to the revision petition filed by respondent number 1. Shri Mrutyunjay Tatabangi, learned counsel for and on the basis of all the above, is submitted that the petition is required to be allowed. Shri Mrutyunjay Tatabangi, learned counsel for respondent number 1, would submit that the property in question, measuring 26 into 22 yards, is the ancestral property of respondent number 1. No transaction has occurred in respect of the said property as evidenced by the encumbrance certificate. This has been rightly taken into consideration by the regional commissioner. The sale deeds of the petitioners not being reflected in the encumbrance certificate as regards the aforesaid property, the regional commissioner has rightly passed the order. If at all the petitioners were to assert their title of the property over the property, they are required to approach the civil court seeking for necessary declaratory relief. And the above petition is not maintainable. Heard so and so peruse papers. Essentially, the order of the regional commissioner, the points that would arise for consideration are: 1, whether the regional commissioner would have revisional powers under section 322 of the Karnataka Municipalities Act 1964. 2, whether the regional commissioner could have considered the encumbrance certificate produced by respondent number 1, indicating no encumbrance in respect of survey number 259C, to come to a conclusion that there was no transaction as regards the residential property claimed by the petitioners. 3, what order? Answer to question point number 1. Section 322 of the Karnataka Municipalities Act 1964 is reproduced hereunder for easy reference. A perusal of the above provision indicates that it is the director of municipal administration who has the revisional powers. Subsequent to the amendment which has been carried out, which has been brought into effect from 28/2003, replacing the word commissioner with the director of municipal administration. Though the regional commissioner could be said to have revisional powers until 28/2003, post the amendment which has been effected, it is the director of municipal administration who is conferred with the revisional powers. Thus, it is rather shocking that the second respondent regional commissioner has excised revisional powers under section 322 when no such revision powers are vested with the said regional commissioner. In that view of the matter, I answer point number 1 by holding that a regional commissioner does not have any revisional powers under section 322 of the Karnataka Municipalities Act 1964, and it's only the Director of Municipal Administration who has such revisional powers post 28/2003. The Principal Secretary, Revenue Department, is directed to forward a copy of this order to all the regional commissioners so that in future no exercise of powers under section 322 could be made by the regional commissioners. Answer to point number 2. Essentially, the order passed by the regional commissioner is on the basis of encumbrance certificate produced by respondent number 1 in respect of survey number 259C. And it is on that basis that the regional commissioner has come to a conclusion that there is no sale which has been effected in respect of the said property claimed by respondent number 1, and as such the petitioners cannot claim any right, title or interest over the property. From the narration of the facts above, it is clear that the petitioner claims that the property was bearing old number, that the property firstly is a residential property and not an agricultural property. Secondly, it was bearing number 89-103, bearing old door number 89-103, old assessment number 90-100. Then subsequently was renumbered as new door number 52 with assessment number 54, coming under the jurisdiction of the Amravati municipality, coming under the
15th ward Hospete.
15th ward of Hospete city. Subsequently, the property came under the jurisdiction of the Amravati municipality.
No. Earlier it was Amravati municipality, my lord. In the year 1999, it came to Hospete.
Amravati.
Subsequently, in the year 1999, the Amravati municipality was changed into the Hospete municipality.
From the narration of the facts above, it is seen that the property was originally within the jurisdiction of the Hospete
Amravati
municipality. Amravati, Matte Hospete.
My lord, second para, my lords. Subsequently, in the year 1999, the Amravati municipality was changed into the Hospete municipality. And new door number and assessment number were given the said property as door number 52 and assessment.
Assessment number 54. Coming under the jurisdiction of the Amravati municipality. Subsequently, the name of Amravati municipality was changed to Hospete municipality. From narration of the facts above, it is seen that originally the property came under the Amravati municipality when old door number 89-103 with assessment number 90-100 was allotted. Subsequently, on the said property, Amravati municipality being renamed as Hospete municipality, a new door number 52 and assessment number 54 came to be allotted. When the property is residential in nature, and the claim of the petitioners was that the municipal numbers which have been allotted to it, and there's an assessment made to the said numbers, the question of the regional commissioner referring to an encumbrance certificate relating to an agricultural property would not have arisen. This court refrains from making any statement as regards the manner in which the encumbrance certificate of agriculture property has been considered by the regional commissioner when the property is claimed to be a residential property. Apparently, the reason for the same is on account of different encumbrance certificates being issued by the sub-registrar's office for the agriculture property on the basis of a survey number, when the property has already been converted and residential property numbers have been allotted to the land situated in the said agriculture survey number. They said property no longer being agriculture property and put to residential use. It would therefore be required that in order to avoid these kind of situations, the encumbrance certificate issued in respect of is agriculture property by survey number also reflects the municipal numbers allotted to sites formed in the said survey number as and when so formed. Needless to say, if the agriculture property continues to be agriculture property, an encumbrance certificate in respect of the said agriculture property could be considered. In that view of the matter, the Yav department, IGR Yav department, Revenue department, the Principal Secretary Revenue department, in association with the Principal Secretary E-Governance department, is directed to implement a system which would cater to the above situation. And when an encumbrance certificate is issued as regards an agriculture property on the basis of a survey number, the details of all the plots which have been all the sites which have been formed thereon and allotted with municipal numbers, door numbers or assessment numbers are also reflected in the said encumbrance certificate with the details of the sale deeds which have been executed in relation thereto. Or in the alternative, if sites have been formed, the sub-registrar would have to refuse issuance of encumbrance certificate on the basis of agricultural property, on the basis of an application made in respect of a survey number which was earlier agriculture in nature. Necessary endorsements to be made in the revenue records like the RTC, Akarban, etc., indicating that the property is no longer agriculture in nature and sites have been formed. Once sites are formed, the sub-registrar would have to issue encumbrance certificates only in respect of the door number or assessment number, no door number and assessment number, so that multiple encumbrance certificates are not issued individually on the door number basis or the assessment number basis. If there is change in the door number or assessment number, the encumbrance certificate should also reflect such changes in the door number and assessment number. These are but a few observations. The Principal Secretary, Revenue Department, being the person in charge of the said department, having better knowledge of the matter, with the assistance of other experts in the department, could well develop a more robust system to cater to the above situation. A detailed project report to be filed within 6 weeks from today, that is on or before 21st March 2024. In view of the above, having come to a conclusion that the encumbrance certificate in respect of survey number 259 could not have been referred to by the regional commissioner as regards residential properties towards which municipal door numbers have been allotted, I have the considered opinion that even on merits, the finding of the regional commissioner is bad in law, even though I have come to a conclusion that the regional commissioner would not have had any revisional powers. As such, I pass the following three. In the above circumstances, I pass the following order. Writ petition is allowed. A certiorari is issued. The order dated 13/5/2021 passed by respondent number 2 regional commissioner in proceeding number so and so at annexure A is quashed. Liberty is however reserved to respondent number 1 to approach a competent civil court seeking for necessary relief, since it is the respondent number 1 who is claiming a right over the property, as regards which the names of the petitioners and their predecessors have been entered into from the 1980s.
Much.
Though the above petition is disposed, relist on 25th March for reporting compliance. Registry direct print the name of the learned AGA to enable the reporting of compliance in the cause list.
Order was needed.
ಹೆಂಗ್ ಮಾಡಿದ್ರೆ
It will go a long way.
ಅವ್ರು ಮಾಡ್ಬೇಕಲ್ಲ ಇನ್ನು ಇಟ್ಕೊಂಡು ಮಾಡಿಸಿ.
In this case, for the petitioner sought for directing the fourth respondent to stop the illegal process of eviction from the unauthorized agriculture of the land, your lordships. Since the petitioner for the last 3 to 4 decades, the petitioners cultivating the unauthorized, your lordships. Government
ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ ಮಾಡಿದೀರಾ?
Please, your lordships.
ಯಾವಾಗ ಫೈಲ್ ಮಾಡಿದ್ರಿ?
Annexure E and F, your lordships. In terms of annexure C, your lordship, petitioner filed the application, your lordships. Application still pending, your lordships.
Annexure?
Annexure E, your lordships.
Page.
Please, your lordship.
Page ಹೇಳಿ.
Page number 39, your lordships. Annexure D and E, your lordships. Sorry. Page number 39, your lordships.
It's not in the proper format.
And they also obtained the acknowledgement at.
Been received and annexure E.
Yes, sir.
ಎಲ್ಲಾರ್ದು ಇದೆ ಅಲ್ಲ?
ಎಲ್ಲಾರ್ದು ಇದೆ, sir.
ಇನ್ನ ಈ ಪೊಸಿಷನ್ ಅಂತ ಇದ್ದಾರೆ.
Please, your lordship.
They have filed, your lordship, the application, your lordship, on 13/7/2022. They have dispersed, your lordship, on 26/6/2022. Your lordship may direct the respondent to consider, but your lordship already they are dispersed.
If they already dispossessed, then why should we direct? On what basis do you say they are dispossessed? ಯಾವ basis ಮೇಲೆ ಹೇಳ್ತೀರಾ dispossessed?
As per our instructions also, your lordship.
No, your lordship. In fact, as per
Then produce documents indicating they are dispossessed.
Produce the panchayats also.
Learned counsel, learned AGA submit that the petitioners are no longer in possession of the property and the state has taken over possession. And it is thereafter that the application for regularization of possession, unauthorized possession was made. He seeks for and is granted a week's time to place the necessary documents in relation thereto. Relist on 21st February.
Easy.
First case appeared for the respondent number 2 and the second case appeared for the petitioner. That's
Yes.
Ready for final hearing it, sir.
ಹೇಳಿ.
Let's see. One Chanmalappa Urlingappa filed form number 7 on 21/6/1976 for grant of occupancy rights in respect of RS number.
How petition ತಗೊಂಡ್ಬೇಕು? First or second?
Second.
2509 or 3447?
ಅಲ್ಲ 3447. Yes. That is filed by the owners of the land.
Yes.
Then the land tribunal on 24/9/1981 granted occupancy rights. That was challenged before this honorable court. Annexure K this honorable court at page number 91. This honorable court remanded the matter back to the land tribunal on the ground that the land tribunal has passed the order against the dead person. After remand again on 7/3/2018, the land tribunal annexure L once again the granted occupancy rights. Again, that was challenged before this honorable court, my lord, annexer M, my lord, an order passed by this honorable court, my lord, allowed and remanded. There is a specific direction by this honorable court, my lord, to consider the documents, entries, etc. My lord, at page number 116 is concerned. Then, my lord, after again remand, this annexer A came to be passed, my lord, on 5/3/2023. Annexer A, my lord, may I request your lordship kindly see the, my lord, the order passed by the annexer A at page number, my lord, 23, your lordship. Page number 23 is the, my lord, the page number 23. My lord, the tribunal, my lord, has considered, my lord, it has reproduced the, my lord, the evidence and the, my lord, the written arguments up to page number 40. That is not discussed. Then, my lord, ಪರಿಶೀಲನೆಯಿಂದ page number 40, lordship. Then, my lord, the item number A, B, C, D. This is the, my lord.
Yes.
This is again, my lord, it has reproduced the, my lord, the act of the, my lord, the Karnataka certain Inam abolition act, page number 41 onwards. Then, my lord, the reasonings, page number 46, I will take, your lordship. Page number 46. It has produced the, my lord, the entire the act, my lord, section 4 and 5.
45 in the ಶುರು ಆಗುತ್ತೆ G ಇಂದ.
Yes, 45. Right. ಗಮನಿಸುವ ವಿಷಯ ಇದೆ. This is page number next, my lord. That is also the produce the, my lord, the arguments of the, my lord, the parties. Then your lordship kindly see para J, my lord. ಕಾರಣ ಕಲಂ 5(1) ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುವ ಬಗ್ಗೆ ಪರಿಶೀಲಿಸಲು ನೆಕ್ಸ್ಟ್ 3 lines, my lord. ವ್ಯಾಪ್ತಿ ಅರ್ಜಿದಾರರು ಕಲಂ 5(1) ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುವರೆ ಅಥವಾ 5(2) ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುವರೆ ಇಲ್ಲವಾ 5(3) ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುವರೆ ಎಂಬುದು ಪರಿಶೀಲನೆ ವಿಷಯ ವಸ್ತುವಾಗುತ್ತದೆ ಮತ್ತು ಉತ್ತರವು ಹೌದಂದಲ್ಲಿ ಮಾತ್ರ ದಾವಾದ ಜಮೀನು ಗೇಣಿಯು ವೈಯಕ್ತಿಕವೇ ಅಥವಾ ಜಂಟಿ ಕುಟುಂಬಕ್ಕೆ ಸಂಬಂಧಿಸುವುದು ಎಂಬುದನ್ನು ಪರಿಶೀಲಿಸಬೇಕಾಗುತ್ತದೆ. ಕಾರಣ ಕಲಂ 5(1) ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುವ ಬಗ್ಗೆ ಪರಿಶೀಲಿಸಲಾಗಿ ಈ ಮೊದಲೇ ಪರಿಶೀಲನಾ ಖಂಡಿಕೆ ಬಿ ರಲ್ಲಿ ಉಲ್ಲೇಖಿಸಿದಂತೆ ದಾವಾದ ಜಮೀನಿನ ಹರದ ವ್ಯವಸಾಯಗಾರನ ಕಲಂ 12ರಲ್ಲಿ ಸನ್ 63-64ನೇ ಸಾಲಿನಿಂದ 64-65ನೇ ಸಾಲಿಗೆ ಗುರುಲಿಂಗಸ್ವಾಮಿ, ಗುರುಬಸವಸ್ವಾಮಿ ಮಠದ ಇವರ ಹೆಸರು ನಮೂದಿದ್ದು ಸಾಗುವಳಿ ರೀತ್ಯ 2 ಎಂದು ನಮೂದಿಸಿದ್ದು ಇರುತ್ತದೆ. 65-66ನೇ ಸಾಲಿನಿಂದ 66-67ನೇ ಸಾಲಿವರೆಗೆ ರೈತ ಲಕ್ಷ್ಮಣ್ ಅಣ್ಣಪ್ಪ ಜಾಧವ್ ಇವರ ಹೆಸರು ನಮೂದಿದ್ದು ಸಾಗುವಳಿ ರೀತಿ 3 ಎಂದು ನಮೂದಿಸಿದ್ದು ಇರುತ್ತದೆ. ಸನ್ 67-68ನೇ ಸಾಲಿನಿಂದ 71-72ನೇ ಸಾಲಿನವರೆಗೆ ಹಿಂದಿನ ರೈತ ಸಾಗುವಳಿ ಬಿಟ್ಟ ಬಗ್ಗೆ ಸರ್ವೆ ನಂಬರ್ 34ಕ್ಕೆ ಬರೆದ ಪ್ರಕಾರ ವರದಿ ತಾಲೂಕು 4767 ಪ್ರಕಾರ ಎಂಬಿ ಘಟನಟ್ಟಿ ದೇವಸ್ಥಾನ ಕಮಿಟಿ ಚೇರ್ಮನ್ ಇವರ ಹೆಸರು ನಮೂದಿದ್ದು ಸಾಗುವಳಿ ರೀತ್ಯ 2 ಎಂದು ನಮೂದಿಸಿದ್ದು ಇರುತ್ತದೆ. ನಿಗದಿಪಡಿಸಿದ ದಿನಾಂಕ 1/3/74 ಇರುವುದರಿಂದ ಅರ್ಜಿದಾರರು ದಿನಾಂಕ 1/3/74ರಂದು ಮತ್ತು ನಿಕಟಪೂರ್ವ ದಾವಾದ ಜಮೀನು ಹೊಂದಿದ ಬಗ್ಗೆ ಹರದಲ್ಲಿಯ ನಮೂದುಗಳು ದೃಢೀಕರಿಸಿರುವುದಿಲ್ಲ. ಈ ಬಗ್ಗೆ ಕರ್ನಾಟಕ ಭೂ ಸಾಧನೆ ಕಾಯ್ದೆ 61ರ ಉಪಬಂಧಗಳಡಿ ಅಗತ್ಯಪಡಿಸಿದಂತೆ ಭೂ ಮಾಲೀಕರಿಗೆ ಲಾವಣಿ ಸಂದಾಯ ಮಾಡಿದ ದಾಖಲೆಗಳನ್ನು ಈ ಮೊದಲಿನ ನಡವಳಿಕೆಯಲ್ಲಿ ಹಾಜರುಪಡಿಸಿದ್ದರೂ ಸಹಿತ ಅವು 73-74ರ ನಂತರ ದಿನಾಂಕಗಳನ್ನು ಅಂದರೆ ನಿಗದಿಪಡಿಸಿದ ದಿನಾಂಕ 1/3/74ರ ನಂತರ ದಿನಾಂಕ ಹೊಂದಿರುವುದರಿಂದ ಅವುಗಳನ್ನು ಪರಿಗಣಿಸಲು ಬರುವುದಿಲ್ಲ. ಆದರೆ ದಿನಾಂಕ 23/9/73ರಂದು ಸದರಿ ಅರ್ಜಿದಾರ ಚನ್ನಮಲ್ಲಪ್ಪ ಗುರುಲಿಂಗಪ್ಪ ಕೋತ್ರವರಿಗೆ ನೀಡಿದ ಮೂಲ ನೋಟಿಸಿನ ಪ್ರತಿಯನ್ನು ಹಾಜರುಪಡಿಸಿದ್ದು ಇರುವುದರಿಂದ ಅದರಲ್ಲಿ ನಮ್ಮ ಶ್ರೀ ಮಹಾಲಿಂಗೇಶ್ವರ ಮಠದ ಸರ್ಕಾರಿ ಲೆಕ್ಕಪತ್ರಗಳ ಅಧಿಕಾರಿಗಳಾದ ಮೆಸರ್ಸ್ ಅಸಿಸ್ಟೆಂಟ್ ಚಾರಿಟಿ ಕಮಿಷನರ್ ಬೆಳಗಾವಿ ಇವರ ಕಚೇರಿಯಿಂದ ಲೆಕ್ಕಪತ್ರಗಳನ್ನು ಒಪ್ಪಿಸುವ ಸಲುವಾಗಿ ಎಲ್ಲ ಜಮೀನಿನ ಬಿರಾಡದ ಜಮಾ ಖರ್ಚನ್ನು ತೋರಿಸಬೇಕೆಂದು ನೋಟಿಸು ಕೊಟ್ಟಿರುವರು. ಅದರಂತೆ ನೀನು ಈ ನೋಟಿಸ್ ಮುಟ್ಟಿದ 8 ದಿವಸಗಳಿಗಾಗಿ ಶ್ರೀ ಮಹಾಲಿಂಗೇಶ್ವರ ಮಠಕ್ಕೆ ಹಿಂದಿನ ಎಲ್ಲವನ್ನು ಚುಕ್ತಾ ಮಾಡಿ ಪಾವತಿ ಪಡೆದುಕೊಂಡು ಹೋಗಬೇಕು. ಅದರಂತೆ ತಪ್ಪಿದಲ್ಲಿ ನಿನ್ನ ಮೇಲಿನ ಹೆಚ್ಚಿನ ಕ್ರಮ ತೆಗೆದುಕೊಳ್ಳಲಾಗುವುದು ಎಂದು ಎದುರುದಾರರು ನೋಟಿಸ್ ನೀಡಿರುವುದರಿಂದ ದಾವಾದ ಜಮೀನನ್ನು ಅರ್ಜಿದಾರರು ನಿಗದಿಪಡಿಸಿದ ದಿನಾಂಕ 1/3/74 ಪೂರ್ವದಿಂದಲೂ ಲಾವಣಿ ತಾರೀಖು ಹೊಂದಿ ಸಾವಳು ಮಾಡಿಕೊಂಡು ಎಂಬುದನ್ನು ನಿರೂಪಿಸುತ್ತದೆ. ಕಾರಣ ಅರ್ಜಿದಾರರು 5(1) ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುವುದರಿಂದ ಉಳಿದೆಲ್ಲ ಸಾಕ್ಷಿ ಪಾಟಿಸಾವಲು ಮತ್ತು ಮಂಡಿಸಿದ ವಾದಗಳು ಪರಿಗಣನೆಗೆ ಅರ್ಹವಾಗುವುದಿಲ್ಲ. ಆ ಮೇರೆಗೆ ನಿಗದಿಪಡಿಸಿದ ದಿನಾಂಕ 1/3/74 ಮತ್ತು ನಿಕಟಪೂರ್ವ ಪ್ರಸಕ್ತ ಅರ್ಜಿದಾರರು ಅಂದರೆ ಮೂಲ ಅರ್ಜಿದಾರರಾದ ಚನ್ಮಲ್ಲಪ್ಪ ಗುರ್ಲಿಂಗಪ್ಪ ಕೋತ್ ಇವರ ಹೆಸರು ಹರದಲ್ಲಿ ನಮೂದು ಇರುವುದಿಲ್ಲ ಎಂಬುದು ಸ್ವಯಂ ವೇದ್ಯವಾದರೂ ಸಹಿತ ಖಂಡಿಕೆ ಕೇರಲ್ಲಿ ಚರ್ಚಿಸಿದಂತೆ ಎದುರುದಾರರು ಅರ್ಜಿದಾರರಿಗೆ ದಿನಾಂಕ 23/9/73 ನೀಡಿದ ನೋಟಿಸ್ ಅರ್ಜಿದಾರರ ಸಾಗುವಳಿಯನ್ನು ನಿಸ್ಸಂದೇಹವಾಗಿ ನಿರೂಪಿಸುವುದರಿಂದ ಭೂ ನ್ಯಾಯಮಂಡಳಿಯು ಎದುರುದಾರರ ಎಲ್ಲ ಆಕ್ಷೇಪಣೆ ಮತ್ತು ವಾದಗಳನ್ನು ತಳ್ಳಿ ಹಾಕಿ ಸದರಿ ದಾವಾದ ಜಮೀನು ಗೇಣಿ ಜಮೀನು ಎಂದು ತೀರ್ಮಾನಿಸಿ ಅರ್ಜಿದಾರ ಚನ್ಮಲ್ಲಪ್ಪ ಗುರ್ಲಿಂಗಪ್ಪ ಕೋತ್ ಇವರು ಸಲ್ಲಿಸಿದ ಕ್ಲೈಮು ಅರ್ಜಿಯ ಮಂಜೂರಿಗೆ ಪರಿಗಣಿಸಿದೆ. ಸದರಿ ಜಮೀನು ದಾವಾದ ಜಮೀನು ಜಂಟಿ ಕುಟುಂಬದ ಗೇಣಿ ಆಗಿತ್ತು ಎಂಬ ಬಗ್ಗೆ ಉಳಿದ ಎದುರುದಾರರು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದವರು ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ 25/21 ಆದೇಶದಿಂದ ಕಲ್ಪಿಸಿದ ಅವಕಾಶವನ್ನು ಉಪಯೋಗಿಸಿಕೊಂಡಿರುವುದಿಲ್ಲ ಮತ್ತು ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಿದ್ರು ಸಹಿತ ವಿಚಾರಣೆಗೆ ಹಾಜರಾಗಿ ಜಂಟಿ ಕುಟುಂಬದ ಗೇಣಿ ಇರುವ ಬಗ್ಗೆ ನಿರೂಪಿಸಲು ವಿಫಲರವೆಂದು ಈ ಕೆಳಕಂಡ ಆದೇಶ. ಪೀಠಿಕೆಯಲ್ಲಿ ಚರ್ಚಿಸಿದಂತೆ ಮೂಲ ಅರ್ಜಿದಾರ ಚನ್ನಮಲ್ಲಪ್ಪ ಗುರ್ಲಿಂಗಪ್ಪ ಕೋತ್ ಇವರು ಈ ಹಿಂದಿನ ಮುಧೋಳ ತಾಲೂಕಿನ ಪ್ರಸ್ತುತ ರಬಕವಿ ಬನಹಟ್ಟಿ ತಾಲೂಕಿನ ಮಹಾಲಿಂಗಪುರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 34 ಕ್ಷೇತ್ರ 28-35 ಎಕರೆ ಜಮೀನಿನ ಗೇಣು ಹಕ್ಕು ಕೋರಿ ಸಲ್ಲಿಸಿದ ನಮೂನೆ 7 ಅರ್ಜಿಯನ್ನು ಸರ್ಕಾರ ಸುತ್ತೋಲೆ -- ಪ್ರಕಾರ ಕರ್ನಾಟಕ ಹಲವು ಇನಾಮ್ ರದ್ದತಿ ಕಾಯ್ದೆ 77 ಅಡಿ ಸಲ್ಲಿಸಿದ ನಮೂನೆ 1 ಎಂದು ಭೂ ನ್ಯಾಯಮಂಡಳಿ ಪರಿಗಣಿಸಿದೆ. Then granted my lord occupancy rights. This is the my lord the order passed by the tribunal. My first submission my lord would be my lord the tribunal is not empowered to my lord the convert form number 7 into form number 1 under the because form number 7 is governed under section 45 of the 48A(1) of the my lord the Karnataka Land Reforms Act and the read with my lord rule 19(1) of the Karnataka Land Reforms Act. Whereas 45 is prescribes the my lord the procedure for a grant of occupancy rights in respect of my lord form number 7. It has to deal under section 48A and 45 only by the land tribunal. That's because your lordship kindly see section my lord the under Karnataka certain Inam Abolition Act form number 1 is my lord to be filed. My lord under section 4 is the my lord the vest with the government. Then 5 is the my lord the form number 1 read with rule 4 of the my lord the form number 1 has to be filed. First my lord I will take the my lord the section 48A(1) my lord. Then I will take the my lord the Karnataka certain Inam Abolition Act. That is the my lord is not empowered. 48A(1) your lordship can see. Mary.
Yes.
48A(1) every person entitled to be registered as an occupant under section 45 make an application to the tribunal in this behalf. Every such application shall save as provided in this act may be made before the expiry period of 6 months from the date of the commencement of section 1 of the Karnataka Land Reforms Act. This is the my lord the procedure to file form number 7. That is my lord the last date for filing form number 7 was my lord 36/1979. That is. Then rule 19(1) also my lord prescribed.
39.
Yes.
39 ಅಲ್ಲ.
36/1979. 36/1979 form number so far as form number 7 is concerned. The last date for filing form number 7. That is rule 19 your lordship 19(1) also my lord of the Land Reforms Act is prescribed form of application and notice. The procedure prescribed. What are the details of the form number 7 to be contained and everything that is my lord prescribed.
ಯಾವ್ದ್ರಲ್ಲಿ?
19(1) my lord. Rule 19(1) of the Karnataka Land Reforms Rules.
Yes.
My lord, the 19(1) shall be in form number 7. 19(1), rule 19(1) prescribes, my lord, the application under subsection 1 of 48A shall be in form number 7. That is the, my lord, the procedure prescribed for grant of occupancy right. Form number 7 deals only with the, my lord, the agricultural lands, nothing else. Whereas the, my lord, the form number 1 deals with, my lord, both agriculture and non-agricultural lands, buildings, etc. Then, my lord, the section 45 prescribes the procedure for grant of what are the holding, my lord, the eligibility criteria or the, my lord, the qualification for grant of, my lord, occupancy rights.
Yes.
The subsection, the subject to the provisions of the succeeding sections of this chapter, every person who was a permanent tenant, protected tenant, or other tenant, or where a tenant has lawfully sublet such subtenant, shall with effect on and from the date of vesting be entitled to be registered as an occupant in respect of lands of which he was a permanent tenant, protected tenant, or other tenant, or subtenant before the date of vesting and which he has been cultivating personally. And then, my lord, the qualifications, whether the criteria for grant of occupancy rights is, my lord, prescribed, my lord, under section 45. Then, my lord, I will take, my lord, the section 126 of the, my lord, the Karnataka Land Reforms Act, where the, my lord, the Inams,
Yadu section?
section 126. Application of the Karnataka Land Reforms Act to Inams.
Yes.
It includes the, my lord, the village of the alienated villages, Inam villages, and including the, my lord, the Village Office Abolition Act also. That is, but subject to the provisions of the said act. Your lordship, kindly see the word used, my lord, subject to the provisions of this said act. It is not, my lord, it does mentioned in general. If it is general, my lord, then, my lord, is a different thing. But it is says that, my lord, subject to the provisions of this said act.
Yes.
Then, my lord, I will take the, my lord, the 141, section 141 of the, my lord, the abolition of Inam's tenure. That is also one of the criteria for consideration, my lord.
One not?
141, just section 141, because abolition of tenure is concerned.
Yes.
Nothing in this act shall affect the, my lord, the provisions of any of the Land Tenures Abolition Act specified in Schedule 2 of to the Act, whereas, my lord, the under Schedule 2, various Inams, the acts have been, my lord, repealed, and if they person who is cultivating lands, my lord, before abolition of those, my lord, their rights will not be affected. That is the, my lord, the section 41 says. That's, now, my lord, comes to the, my lord, the duties of the tribunal. Whether the tribunal has empower to, my lord, converts form number 1 to, my lord, the form number 7 into form number 1. 112B, my lord, the duties of the tribunal. Whether in that, my lord, the tribunal is empowered or not. 112 of the, my lord, B of the, my lord, the procedure and jurisdiction. Whether it got jurisdiction. B, my lord, 112 subclause B, my lord, I will take. That is the duties of the tribunal. With the lots of permission, married, this. Duties of the tribunal to make necessary verification or hold an inquiry, including local inspection and pass orders in cases relating to registration of a tenant as occupant under section 48A, to decide whether a person is a tenant or not, to decide whether the land in respect of which an application under section 48A is made, or in respect of which any question of tenancy is raised or involved, is or is not an agricultural land, to decide question referred to it under section 133, to issue interim orders under section 48C, determination of the land to be surrendered under section 67, to hold necessary inquiry including local inspection and pass orders in cases relating to registration of agricultural laborers as owners of dwelling houses and land appurtenant thereto under section 38, to perform such other duties and functions as are imposed on the tribunal under the provisions of this act or any rule made thereunder. My lord, this is the duties they have to carry and have to apply. My lord, nowhere in the act says that, my lord, it is empowering the land tribunal, converting when the form number 7 is filed under section 48A 1. My lord, it has to deal, my lord, the form number 7 under the Karnataka Land Reforms Act only. It cannot, my lord, convert it into the Karnataka Certain Inam Abolition Act. That's a different statute. And the procedure is also governed, my lord, under form number 1 is, my lord, section 5 of the, my lord, and section 11 of the, my lord, the Karnataka Certain Inam Abolition. May take your lordship the movement, my lord, form number 1. Now the Karnataka Certain Inam Abolition Act. Read with rule. My lord, the section 5, my lord, it prescribes right to be registered as occupant. My lord, the criteria, my lord, to grant occupants right under the Karnataka Certain Inam Abolition Act under form number 1 is a different from form number 7 filed under section 48A is.
Yes.
May I read, my lord? Right to be registered as occupant, save as otherwise provided in this act with effect from and or the appointed date. Every tenant of the inamdar or holder of a minor inam shall be entitled to be registered as an occupant of lands in respect of which he was a tenant immediately before 1st day of March 1974, where the inamdar is an institution of religious worship, a person rendering religious service in or maintaining the institution as a pujari, archaka, or the holder of a similar office by whatever name called, or rendering any service in such institution. I'm sorry, sir. I'm sorry. Karnataka Certain Inam Abolition. Section 5, your lordship.
Mysore Inam site ಕೊಟ್ರಿ ಅದು ಹೋದ್ರೆ Yes.
The lordship's kind permission, may I read?
Yes, please.
Section 5, right to be registered as occupant, save as otherwise provided in this act, with effect from and or the appointed date. Every tenant of the inamdar or holder of a minor inam shall be entitled to be registered as an occupant of lands in respect of which he was a tenant immediately before 1st day of March 1974, where the inamdar is an institution of religious worship, a person rendering religious service in or maintaining the institution as a pujari, archaka, or the holder of a similar office by whatever name called, or rendering any service in such institution and personally cultivating for a continuous period of not less than 3 years prior to the first day of March 74 by contributing his own physical labor or that of a members of his family and enjoying the benefits of any land comprised in the Inam of such institution without paying rent as such money or in kind to the institution in respect of such land shall be entitled to be registered as an occupant of such land. Every Inamdar, including a holder of minor Inam, shall be entitled to be registered as an occupant of. My lord, this is personally cultivating immediately prior to said. Now, my lord, this is, my lord, the consonance with the rule 4 of the, my lord, because the form number 1 has to be filed in terms of the rule 4 for grant of occupancy rights under the rule 4, my lord. Well, it's merit. Application for registration of occupancy rights. The application under section 11 shall be in form number 1. Every application shall be restricted to a single Inam. Where the application is made for any person other than the Inamdar shall be made a respondent to the application. If the application is made by Inamdar, the Tahsildar shall be made a respondent in such application. But the form number 1, under the last date of filing form number 1, under the Karnataka Certain Inams Abolition Act was, my lord, 31/3/1991. That was the last date. Yes. Thereafter, it seems the government has extended. Even then also the tenant has not filed any form number 1, even extended date also. Then, my lord, the details, my lord, the section 11 deals with, my lord, the procedure for granting occupancy rights under form number 1. Now, my lord, therefore, my lord, the acts, my lord, dealing with a different procedure for grant of occupancy rights. Therefore, my lord, the tribunal, my lord, has no power to, my lord, convert form number 7 into form number 1. Therefore, the order is a nullity because it has to deal, my lord, in accordance with the, my lord, the form number 7 under section 48A is the, my lord, my first submission. That in support of that, I will file the. Then, my lords, ಅವ್ರು ನಮಗೂ ಬರಲ್ಲ ಅಂತ ಇಲ್ಲ ಆಮೇಲೆ ರೀಗ್ರಾಂಟ್ ಆಗಿದೆ ನಮ್ಗೆ ಅಲ್ಲಲ್ಲ ನಮ್ಗೆ ಅಲ್ಲಲ್ಲ ನಮ್ಗೆ ನಾನು ಹೇಳ್ತೀನಿ ನಾನು ಐ ವಿಲ್ ಕಮ್ ಟು ದಟ್ ಅಲ್ಲಲ್ಲ ಐ ವಿಲ್ ಕಮ್ ಟು ದಟ್ ಆಲ್ಸೋ ಐ ವಿಲ್ ಕಮ್ ಟು ದಟ್ ನೆಕ್ಸ್ಟ್ ಸಬ್ಮಿಷನ್ ದಟ್ ಈಸ್ ದ ಸೆಕೆಂಡ್ ಸಬ್ಮಿಷನ್ ರಿಗಾರ್ಡಿಂಗ್ ದಿ ಎಂಟ್ರೀಸ್ ಇನ್ ದಿ ರೆಕಾರ್ಡ್ ಆಫ್ ರೈಟ್ಸ್ my lord, produce annex H series. My lord, the record of rights shows that, my lord, the 1963 prior to that and up to the, my lord, 1999, where, my lord, the Supreme Court has directed the receiver to hand over the properties. Till then, my name, that is the, my lord, the Mat Gurulinga Swami's name appears in the record of rights.
Yes.
My lord, the tribunal, my lord, has not considered, has not discussed about the, my lord, the entries regarding the, my lord, the appearing in the record of rights as on the 1374 or prior to that. It has nothing to do, has not at all, my lord, considered or assigned any reasons why those entries to be disbelieved or, my lord, why those entries are not disbelieved or to be disbelieved. There's no reasons as such, my lord, regarding entries. Then, my lord, that is not correct. So section 133 of the Karnataka Land Acts, my lord, the presumption, unless they rebut the, my lord, those entries, because the documents produced before the tribunal, my lord, in the even in the records, doesn't show that, my lord, they have rebutted the, my lord, the entries. There's a valid entries made in favor of the, my lord, the petitioner in this, because at the time of after filing the form number 7, my lord, a checklist was issued, my lord, submitted by the Tahsildar, saying that, my lord, the tenant, there's nobody tenant, nobody is cultivating the land as a tenant. That's a checklist was submitted, my lord, by the Tahsildar before the land tribunal. That is also not considered by the, my lord, the land tribunal. That is my second submission. My lord, so far as third submission is concerned, my lord, section 108.
Submission is that there was no tenancy right.
There is no tenants at all. Because the entries, my lord, beginning right from 1965, 63 onwards till, my lord, 1999. The first time when the, my lord, the tribunal granted occupancy right, they got the, my lord, the entries. In spite of that, they are not in possession at all. Because I'll show that.
Of the alleged notice of 23,974.
Yes, there's no such.
23.
Yes, sir. As on 1374, there is no entries up to 1374. Therefore, the Supreme Court says, my lords, no, subsequent entries, my lord, will not to be considered for the, my lord, the consideration of tenancy.
It is only the interpretation of the notice to quit and deliver.
Yes, my lord.
Of 23,973, which was taken into consideration to establish tenancy.
Yes, my lord. So far as the third submission is concerned, my lord, section 108 of the, my lord, the Karnataka Land Reforms Act.
So your submission is no entries of tenancy, therefore section 45 will not apply.
Apply and
So also will section 5 not apply.
5 not apply. Because that is a condition precedent, my lord.
Yes.
Then, my lord, third submission regarding section 108 of the, my lord, the Karnataka, 108 subclause A of the, my lord, the Karnataka Land Reforms Act. Because the, my lord, the earlier Swamiji, that is the, my lord, Mahalinga Devaru, my lord, has expired, my lord, in the year 1965. 6/5/1965. That is the first Swamiji.
6/5?
1965. The said Swamiji has executed a will, my lord, in favor of the present petitioner. To, my lord, then he, my lord, ascended the, my lord, as a Mahanta of that mutt. That is, my lord, the 16/4/1965. The will. Then, my lord, the two factions, my lord, there was a two factions fighting for, my lord, the in respect of the properties of the mutt. Then, my lord, they filed a complaint before the charity commissioner, assistant charity commissioner Belgavi, against the, my lord, the taking over the, my lord, the possession. Then, my lord, on in the, my lord, it is numbered as, my lord, complaint number 412 of 1965. My lord, the assistant charity commissioner, my lord, on 8/5/1965 handed over the, my lord, the properties to the panchas for management. Then, my lord, one more suit was filed. My lord, OS number 19 of 1978 by the, my lord, the opposite faction of the, my lord, the mutt. That came to be declared, matter went up to Supreme Court. There, my lord, during the pendency of the appeal, my lord, before the Supreme Court directed the district judge to, my lord, to appoint a receiver.
Suit was for?
Suit for, my lord, declaration to declaring that the, to calling the, my lord, the petitioner herein as a Mahanta of the mutt. That is.
But this was filed in 1978.
78.
After
1974.
How is that relevant for 108?
Because the of 19 prior to that, my lord, the assistant commissioner has, my lord, handed or charity assistant charity commissioner.
But 108 would apply only to court.
Court, yeah, my lord. There's only reference to.
Under the management of the court.
Yes.
Or of a government officer appointed in his official capacity as guardian under the Guardians and Wards Act 1890. Or management temporarily by civil revenue or criminal courts by themselves.
Yes.
Or receivers appointed by them.
Yes. Because
But till 1974, none of these things under 108.
Now, why I am referring, the assistant charity commissioner, my lord, they hand over the properties to the panchas, the 5 panchas, trust committee. That is 1965. Therefore, during that period also, that's another submission.
The charity commissioner appointing as
First, 8/5/1965, when the complaint was filed by the opposite faction before the Assistant Charity Commissioner, my lord, it is numbered as, my lord, complaint number 412 of 1965. On 8/5/1965, the Charity Commissioner, my lord, handed over the properties to the Panchas as indicated or by the, my lord, the opposite faction. Therefore, from 1965, the properties were in the hands of the Panchas.
Who are the Panchas?
My lord, the trustees of the, my lord, the Mutt, 5 trustees. The page number, annexure E, my lord, page number 19, page number 69. The trustees, my lord,
Except section 8 antade. What is section 8? That is the obligation to pay the rent during the time of the property being under the custody of.
Panchas and trustees.
Shall apply to lands taken under the management of the Court of
Court of
Wards
Wards. Yes.
or of a government officer appointed in his official capacity as a guardian under the Guardian in Wards
Yes.
Act, or to the lands taken under management temporarily by civil, revenue or criminal courts.
Yes. Because, my lord, 1965, 8,
So would the Assistant Charity
Charity
Commissioner
Commissioner.
be a court?
a court, yes, my lord, as a revenue or in terms of under the Public Trust Act, my lord, is a revenue officer, my lord, who is my lord, supervising the, my lord, the trust.
BPT Act. Charity Commissioner was under the BPT Act.
Yes, my lord.
So what is the status of the Assistant Charity Commissioner? Power of court ಇದೆಯಾ ಚಾರಿಟಿ ಕಮಿಷನರ್ಗೆ?
Yes, my lord.
ಯಾವ ಸೆಕ್ಷನ್?
Decision of the Charity Commissioner, section 40, your lordship.
40?
40 of the BPT Act, powers of the Charity Commissioner. And then section 41A, my lord, he has power to, my lord, issue direction to the trustees of the, my lord, the trust. (1950) Act.
Powers are 68 in the.
Then, my lord, section 68, my lord, prescribes the duties of the, my lord, the deputy and assistant charity commissioner. Section 68.
Is it a court?
But court is,
Appeal to the charity commissioner.
yes,
So would the assistant charity commissioner be a court? Because 108 only refers to court. Or a public officer appointed as a guardian under Guardians of Wards Act. Public officer will not become.
he will not guard it. He will only supervise the, the,
Or a receiver, etc., appointed by civil, criminal or revenue courts.
if there is any complaint by the trustees or mismanagement of the trust, he can hold an inquiry and.
So the handing over of the property to the panchas, would it constitute
Management,
constitute lands taken under management of court of wards, etc.?
yes.
Would it constitute court? If they, suppose the Tahsildar passes an order to maintain peace, that won't come under 108.
Yes, that will not come.
What comes under 108 is specifically court of wards, under the management court of wards or of the government officer, or management temporarily of the civil, revenue or criminal courts.
Yes, ma'am.
By themselves or through receivers. Yeah.
It is totally
No,
different.
It is completely
When
different.
a person who is the owner of land is lunatic or minor, then court of wards come in.
So the first portion will not apply at
No,
all.
no.
Only the portion which could apply
B
is all to the lands taken under the management temporarily by the civil, revenue or criminal courts by themselves or through receivers appointed by them during the period of such management.
Yes. Revenue, in this case, I rely upon the revenue. The word revenue is because the,
Commissioner Ing Bharat
in the terms of under the Bombay Public Trust Act, the properties, all the properties, it is not directly
you'll have to show us something to that. Well, criminal court antu Allah charity.
Civil court to.
Civil court to Allah.
So only
civil court agbodu, if you show us.
Yes.
A revenue court agbeku.
Yes.
Civil court, revenue court or criminal court. One of them it has to be for 108 to apply.
Yes.
Otherwise, your main trust is on 108.
108, that is the third submission regarding, even if they say that.
108 trust iradrinda,
yes,
there could not have been a
yes, they have
application made for tenancy nor could be considered.
And even if the trustees cannot have no power authorized to lease or someone to be inducted in the land for tenants. That is, I am trying to convince that point. Because if otherwise the Supreme Court.
When did the order of the charity commissioner cease to operate? 8565?
Then the page number annexer, the Supreme Court order.
The Supreme Court order is in pursuit of suit in OS 19 of 78.
Yes, thereafter.
Which is much subsequent.
Yes, till then, it was in the hands of the panchas. Therefore, I request your lordship kindly see.
The complaint 412 of 1965 dispose aglilva.
Disposal ante enu ellu record nalli ellu idu madlilla. That is
412 did not get disposed at all. So dispose agbeku.
Alla record alli
Records are not there, my lord. That I asked him, any records are there, trial court record. Now, instead of wasting time.
Because all these
land tribunal record. I asked him whether records are there, just I wanted to look into it.
But that is not disputed by.
Even otherwise, even though receiver is there, he cannot dispossess me because I am a tenant right from 1966-67. It is only for management, not taking over possession of the property.
Document to show you are a tenant.
Pardon?
There is no document except the notice of
No,
23.
sir, I'll convince this one. The order is very clear. I will convince.
ಇವಾಗ ರೆಕಾರ್ಡ್ಸ್ ಬೇಕಾ ಬೇಡವಾ?
Records
ಎಲ್ಲ argument ಆದ್ಮೇಲೆ records
ನಾನು ಅದಕ್ಕೆ ಕೇಳಿದೆ records ಬೇಕು.
Time waste ಬೇಡ.
No, I wanted to actually, Manas, I wanted to.
Records back. Otherwise, my lord, the receiver could not have taken the, my lord, the possession 1986 also, because the
Records ಬೇಕಾ?
ಬೇಕಾ?
It is his main submission that your lordship, the land tribunal cannot convert the form of 7 into form of 1.
There is a notification to that.
That's circular. But that circular is not.
No, sir. Land tribunal based on circular, Manas, converted form number 7 into
circular
form of
ಅಂತ
1.
dash ಬಿಟ್ಟಿದ್ದಾರೆ. Operative portion lordship
ಗೊತ್ತಿಲ್ಲ,
just
circular ಇರ್ಬೋದು
dash
ಮಾತ್ರ.
ಬಿಟ್ಟಿದ್ದಾರೆ.
ರೆಕಾರ್ಡ್ಸ್ ಬೇಕಾ ಬೇಡವಾ ಹೇಳಿ. ಬೇಡ ಅಂದ್ರೆ ವಿಲ್ ಗೋ ಹೆಡ್ ವಿತ್ ಇಟ್ ರೈಟ್ ನೌ. ರೆಕಾರ್ಡ್ಸ್ ಬೇಕು ಅಂದ್ರೆ there is no point in.
Not necessary, so far as my concern, not necessary. Not necessary, because the Supreme Court, my lord, has directed.
ಪ್ರಕಾರ ಬೇಡ, ನಿಮ್ ಪ್ರಕಾರ ಬೇಕಾ ಬೇಡವಾ?
ಬೇಕಾಗುತ್ತೆ, because circular is maybe in ಬೇಕಾಗುತ್ತೆ. Otherwise I'll argue.
Only circular ಬೇಕಾ, records ಬೇಕಾ?
Records ಇದ್ರೆ ಒಳ್ಳೆ ಸಮಯ. And because there are notices issued by Assistant Chartered Commissioner to pay the rent to the MUD.
To you.
Yes, that is also reflected in the order. That is also reflected in the order.
That is
And the trust people who have paid in the land tribunal, before land tribunal, have admitted that I am a tenant.
Okay, ಇವಾಗ records ಯಾರ ಹತ್ರ ಇದೆ?
ಅದಕ್ಕೆ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡ್ತೇನೆ ನಾನು. Trustees, whether trustees have power to, my lord.
Records, whose records are required now?
Government. Land tribunal records.
ಒಂದು records ಬೇಕು, next whose records? Charity Commissioner records ಬೇಕು.
ಅಲ್ಲ, ಅದರಲ್ಲಿ ಎಲ್ಲ ಇದೆ.
ಅದ್ರೊಳಗೆ ಎಲ್ಲ land tribunal ಮುಂದೆ ಎಲ್ಲ ಇರುತ್ತೆ. Entire records.
ಎಲ್ಲ ಇದೆಯಾ ಅಲ್ಲಿ?
ಇರುತ್ತೆ.
ಇಲ್ಲ ಎಲ್ಲ ಇದೆ.
Probably all records.
ಇವ್ರಿಗೆ ಹೇಳಿದ್ರೆ ಆಮೇಲೆ ಅದ್ರಲ್ಲಿ ಇಲ್ಲ ಅಂತ ಇನ್ನೊಂದು ಬರುತ್ತೆ. After arguing for some time, both the councils submit that the records are required. Hence, the learned AGA is directed to secure the records of the land tribunal, as also the proceedings before the Assistant Charities Commissioner in complaint number 412 of 1965.
And 50 of 1965-66.
ಅದೇನದು?
ಅದು same, another trustees, different trustees.
And 50 of 1965-66.
Yes.
ಇನ್ನೇನಾರು ಬೇಕಾ?
One submission I want to make. Last occasion, when I have cultivated the land, this honorable court passed an order that 40% I have to deposit before the court, 60% of income I have to take, because I am cultivating the land. I have complied with the order of the court. This time I made an application for cultivation of land, because the sugar factories take the sugar cane from the land. I will deposit 40%. That same order may be continued for this year also.
Order dated?
Yes.
ಯಾವ್ದ್ರಲ್ಲಿ ಆಗಿದೆ ಆರ್ಡರ್?
First matter.
ಅದರಲ್ಲಿ harvest.
This is the order.
Lordship, not harvesting.
Say that they are in possession to harvest the crop. To cultivate, the wordings may kindly be seen.
2509, order dated?
15/12/2023. All the parties were heard, and now this order came to pass. Condition order is passed. I have deposited 40% of the amount which is paid by the Renuka Sugars. Nirani Sugars.
So far as possession is not.
ಇಲ್ಲ ಬೇಡ, ನಾ ಪೊಸಿಷನ್ ಕಲ್ಟಿವೇಶನ್ ಕೇಳ್ತಾ
ಅಲ್ಲ, cultivation ಬರೋದಿಲ್ಲ.
This application was made by us for cultivation. Well, same condition also I will comply with again.
Who has grown it now?
ಅಲ್ಲ, ಸೇಮ್ ಕಂಡೀಷನ್ಸ್ ಸಿವಿಲ್ ಆರ್ಟ್ಸ್ ಕ್ಯಾನ್.
ಸೇಮ್ ಕಂಡೀಷನ್ಸ್ ಹೇಳಿದ್ರೆ who has grown it ಅಂತ.
ಇಲ್ಲ, ನಾ ಡೆಪಾಸಿಟ್
ಅಂತ ಬಂತು ಅಷ್ಟೇ.
ಅಲ್ಲ, ನಾನು ಡೆಪಾಸಿಟ್ 40% because we are receiving the amount from the sugar factory. 40% I will deposit before this court, and for 60% I will take it.
Because of 24 has been filed seeking for permission to cultivate the land. ಇವಾಗ ಇದೆಯೋ ಇಲ್ಲ?
ಇಲ್ಲ, ಕಲ್ಟಿವೇಶನ್ ಮಾಡ್ಬೇಕು ಈಗ, ಮತ್ತೆ ಅವರು ಅಬ್ಜೆಕ್ಟ್ ಮಾಡ್ತಾರೆ
ಅಂದ್ರೆ ಕಷ್ಟ ಆಗುತ್ತೆ.
ಅಲ್ಲಲ್ಲ ಕಲ್ಟಿವೇಶನ್ ಮಾಡಿ ಕ್ರಾಪ್ ಕೊಡ್ತೀನಿ ಅದು ದಿ ಶುಗರ್ ಫ್ಯಾಕ್ಟರಿ ವಿಲ್ ಟೇಕ್ ಇಟ್.
Cultivation ಕೊಟ್ರೆ possession.
ಲಾಸ್ಟ್ ಟೈಮ್ ಆಲ್ಸೋ
Harvest.
ಲಾಸ್ಟ್ ಟೈಮ್ ಆಲ್ಸೋ ದಿಸ್ ಇಸ್
Last time it was, the petitioner claimed that they are jointly cultivating the land in question along with legal representative deceased contesting respond number 1. Respond number 2 claims to be the owner of the property.
that is their contention also ultimately court permitted me.
Status quo. Admittedly, the crop is ripe for harvesting. ಯಾರು cultivate ಮಾಡಿದ್ದಾರೆ ಅಂತಿಲ್ಲ.
ಅವ್ರು ತುಂಬಿಲ್ಲ ನಾನ್ ತುಂಬಿದ್ದೇನೆ ಅಮೌಂಟ್ 60%.
ಕೊಟ್ಟಿಲ್ಲ cultivating right.
But I am cultivating, Master. Land Tribunal order is there, Master. Right
Item
from 1967.
item number
I am
5 and 6, Your Lordship, the observation by the dishonorable court. The fact that the court has not given any
It not go
finding
waste, my lords.
as to the lawful cultivation and possession of the disputed property by any of the parties to the proceedings is once again reiterated.
Unnecessary waste ಆಗುತ್ತೆ.
It doesn't.
ಮಾಡ್ಬಿಟ್ಟು court ಗೆ deposit ಮಾಡಿ.
ಅಲ್ಲ, if Lordship can pass an order saying that I
100% deposit in court.
ಅಲ್ಲ ನಾನು ಕಲ್ಟಿವೇಶನ್ ಮಾಡಿ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಮಾಡಿ 100%. let them cultivate that.
Very honest, Your Lords, I can take 60%. If they succeed, they can take away the entire amount.
ನೀವು ಯಾರಿಗೆ?
No, it's same. That 1 minute.
ಇನ್ನೊಬ್ಬರು ಎಲ್ಲಿಂದ ಬಂದು?
ಇಲ್ಲ, sorry.
Same order will continue.
Same order, Master.
I-1024 has been filed for permission to
And
cultivate the land
may I request?
by respond number 1, A to D, 1,
E8.
2, 4 to 8. This court has already considered a similar issue while its order dated 15/12/2023 by imposing certain conditions. In that view of the matter, I have the considered opinion that the said order would equally apply to IA 1 of 2024 and compliance with the condition imposed therein would have to be made by all the concerned parties.
Same conditions, ma'am.
It is again, once again made clear that this court has not expressed any opinion as regards who is in possession and who is entitled to cultivate the land. ಯಾವಾಗ ಬರುತ್ತೆ records?
ಅಲ್ಲ 17th ಇಲ್ಲ ಇದೆ ಹತ್ರ ಇದೆ ಫೋನ್ ಮಾಡಿದ್ರೆ ಬರುತ್ತೆ ಅದು ಜಸ್ಟ್
Released on 20th at 2:30 PM.
Please.
Please, Lords. In this case, I appear for respondent. Lords, I seek 2 weeks time to secure instructions. Lords, I'm awaiting instructions in the matter.
1 week.
And counsel for respond number 4 and 5 seeks fund is granted 2 weeks time to obtain instruction, make a submission, released on 24th.
Please.
21. Ready? 21.
Ready.
Ready.
Paso.
22. Shivraj Maloli.
On the last occasion, on 29/1/2025, Lordships order. To secure instructions and to make submission whether indeed a suit has been filed, and if such a suit has been filed, to place on record the plain written statement and other things are concerned. In the impugned endorsement, there is a reference with regarding to suit having been there. But as per the documentation which has been received in the morning, I have gone through that. There is no such reference with so far as filing of suit is concerned. But the grievance of the respondents herein is that, my lord, the present petitioners claiming right itself is illegal. Since, my lord, in the year 1952 itself, my lord, that property has been declared in the name of the police department, and it has been utilized by them for the construction of quarters and substation. Since from 1952, my lord, we are in possession of the property. Now, as per Annexure A, that is the copy of the sale deed which they are claiming their right, my lord.
Annexure?
Yes, annexure A, my lord. Page number 11. 12. This is in the year 2006. So, my lord, my respectful submission that I will place before the lordships with regarding to the titleship and ownership having been transferred in the by the government of Mysore itself.
1952.
Howdu. They are all part of the records. May I pass on the proceedings and the government orders which have been passed, please? Side in the ನೋಡೋಣ. All the side flaps which have been tagged, my lord, those are the documents wherein, my lord, we have been put in possessions and mutations have been effected by the then government of Karnataka, Mysore itself.
Property details ಎಲ್ಲಿದೆ?
ಇದೆ ಎಲ್ಲ ಡೀಟೇಲ್ಸ್ ಇದೆ. Except side flaps documents can be gone through, my lord. And we have paying property tax since 1952 also, and up to 2023 also we have paid the tax receipts and about 3 lakhs and order insofar as the entire extent of land is concerned. We are disputing this sale deed which has been entered as per annexure A.
ನಿಮ್ಮ police station le police complaint register ಆಗಬೇಕು.
ಅಲ್ಲ ಅದಕ್ಕೇನೆ ಮತ್ತೆ. So, my lord, these are the documents and now, so, yes.
And AGA 6 fund is granted.
Yes, 2-3 days time.
A week's time to file a statement of objections. Objections, if any, to be filed on or before 19th, relist on 21st.
Please. Lord, a common statement of objection will be filed in all the, please.
Seeking mandamus, my lords, directing response. 2, my lord, 2 and 3. My lords, the petitioner herein, my lords, have rendered.
Respond number 2.
My lords, respond number 2, Vijay Balgerimat appears, my lords.
Shri Vijay Balgerimat accepts notice for respond number 2.
2, my lords.
1 and 3. Yes.
My lords.
Registry document is named as such.
My lords, the petitioner herein, my lords, have rendered.
In number.
Please, my lords, the taxpayer identification.
My
The
lord,
respond number 2 have forwarded, my lords.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ though the PDO has forwarded an application, that application has been submitted through GST, but they have to submit the application through VAT for securing TIN and TAN number. If the PDO submits tomorrow itself, my lord, we are ready to consider, and TIN and TAN number will be provided to the petitioner herein.
Annexure G, page 122, my lords.
ನೀವು ಯಾವ ಫಾರ್ಮ್ ಅಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್
ಇವರು ಅಪ್ಲಿಕೇಶನ್ ಇವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ, ಬಟ್ PDO, it is the PDO who has to forward us. It is through GST ಮುಖಾಂತರ ಮಾಡಿದ್ದಾರೆ ಅವರು ನಮಗೆ.
ಏನ್ ನಿಮ್ PDO ದಿನ ಒಂದು 5 ಡಿಫರೆಂಟ್ ವೆರೈಟೀಸ್ ಬರುತ್ತಪ್ಪ.
And we have also intimated to them by issuing an endorsement stating that through GST ಬೇಡ VAT ಮುಖಾಂತರ ಕಳಿಸಿ ಅಂತ ಹೇಳಿ.
They are overly competent.
By virtue of this, my lords, they are respond number 3 is trying to recover, my lords, the amount from us, my lords. But art in page 122, my lords.
ಅವ್ರು ರಿಕವರಿ ಮಾಡ್ತಾರೆ, ನಮ್ಮನ್ನ ನೋಡ್ಕೊಳ್ಳಿಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ ಫಾರ್ಮ್ ಫಾಲೋ ಆಗಲ್ಲ. Why has he given it in a wrong form? Doesn't he know in what form he has to give? Again, one more action against this PDO now. Petitioner is before this court. One opportunity before action is taken. Shri Vijay Kumar Balgerimat seeks for 2 days time to obtain instruction, make a submission as to why the form which had been submitted by the petitioner for issuance of TIN number has been forwarded to the third respondent
Please.
under the
GST,
GST Act
yes.
and not in terms of the VAT Act, which it was required to be done. Relist on 17th at 2:30 PM.
Please.
24 PM Nadaf.
Pray for weeks time is to take necessary steps in respect of respond number 4 and 9 years. And carry out amendment also.
LRs of 4 and 9, process fee.
Weeks time may be granted.
Six fund is granted 2 weeks' time to make payment of necessary process fee in respect of unserved respondents, file application to bring the legal representative of deceased respondents, as also to carry out amendment of the cost titles. If needful is not done by 4th March, the petition will be liable to dismiss for non-prosecution, released on 7th March.
Please, grateful.
25 Santosh Raut.
Password.
26 Guru Baswaraj SM.
In the pendency of the above matter, petition number 2 expired on setting aside abatement Kedelapa.
On the IA file, I was under impression Lord, the petition number 1 is survived. So that is the reason I did not file it. Abatement to
26 counsel for the petition 6 fund is granted.
Week time, Lord. Next week.
Week's time to file necessary application, set aside abatement in respect of petition number 2.
Next week
Released
date
on
may be
20th February.
27 SM Kalwat.
Preemptive order ಇದೆಲ್ಲ preemptive ಇದ್ರೆ ಹೇಳಿ. None appears for the petitioner. 2 weeks' time is granted to the petitioner to make payment of necessary process fee and file application to bring the legal representative of deceased respondent number 2 on record. If needful is not done by 4th March, petition will be liable to dismiss for non-prosecution, relist on 7th.
28 NL Bhatkurki.
Please.
Report.
Please.
Sikidya?
I filed my objection also.
You filed objection.
Please.
Yes.
The respondents herein have filed a suit for declaration and injunction claiming easement by way of prescription manner. That wherein respondents herein have claimed a right of way by way of prescription at MNO plain and sketch map, my lord, in my land. The plaintiff respondents land bearing RS number 6/1/1A1C. And my land is at survey number 31/2. The case of the respondent is that they have purchased the property, that is RS number 6/1 in the year 2006.
MNO ಎಲ್ಲಿದೆ page 19 ಅಲ್ಲಿ?
MNO, my lords, that southern side, my lords, at RS number 31/2.
MNO.
Yes.
Yes.
That they have filed an application under order 39 rule 1 and 2.
The MNO access to RS number 6/1A/1C.
Please.
Yes.
That they have filed an application for a temporary injunction. And said application is rejected by the trial court. Challenging the same, they have preferred appeal, wherein the appellate court reversed the order of the trial court and said that they have produced one sketch issued by village accountant. That is, in that time, it is available, then the court can rely on that document. But it has no
validity in the eye of law because it is not issued by competent authority as held by the trial court, and which is contrary to the village map.
So commissioner was appointed for what
Yes,
purpose?
commissioner was appointed by the by this honorable court that coordinate bench, my lord, that to ascertain whether there is a road.
Hmm.
Lord, so that report is against me because I say that that passage is used me because I have another land and it is by the side of the road. To cultivate my land, I am using that road passage because he is claiming right by way of easement by way of prescription, my lord. As per section 15 of the Easement Act, my lord, it should be more than 20 years uninterrupted use by the person because they have purchased land in the year 2006. So therefore, there is no question of easement by prescription. And moreover, my lords, in their own affidavit, they say that very recently they have purchased this land.
Buddhu Saab, Ganesh Saab, Maul Saab. This is Sri Shail Matspati is somebody else.
Yes. And even, my lords, the commissioner sketch is looked into that plaintiff is having another land in at southern side from same survey number, that is 6/1/4, my lord.
What is the extent of 31/2?
3 acres, 30 gunters.
And what is the extent of 32/2? 32/3?
Thirty-one bar two is 3 acre 30 gunta, my lord. And
31/2 ಎರಡು ಇದೆಯಲ್ಲಪ್ಪ.
ಹೌದು.
ಒಂದು belonging to plaintiff 1 to 3 31/2.
Please.
ಅದೆಷ್ಟು extent? Land of defendant number 1 to 5 in 31/2, what is the extent? Land of plaintiff number 1 in 32/3 and land of defendants in survey number 32/4. ನಾಲ್ಕು extent ಏನು?
For plaintiff, my lord, 3 acre, 30 guntas.
ಯಾವುದು?
In 31/2, my lords.
31/2 belonging to plaintiff.
Please, my lords.
Is 3 acres?
3 acres, 30 guntas.
32/3 belonging to plaintiff 1. ಎಲ್ಲ ಲ್ಯಾಂಡ್ ಕ್ವಾಲಿಟಿ ಸೇಮ್ ಇದೆ ತಾನೆ, ಫರ್ಟಿಲಿಟಿ ಎಲ್ಲ ಅಕ್ಕಪಕ್ಕದಲ್ಲೇ
Almost
ಇದೆ,
similar.
Most similar.
Almost.
ನೀರು ಎಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿ ಇದೆ ಎಲ್ಲ. If you exchange your property, all of them seem to be same property size.
Since I have constructed house in that property, man. Lord, sir, problem is not that, man, because in 6/1, my lord, the commissioner has shown a way.
You have constructed house in 31/2.
Please, ma'am.
Not in 32/4.
Yes, ma'am.
32/4, if you exchange with 31/2, situate on your northern side.
Please. I will inquire, my lords, because I will take instructions.
ನಾವು ಅನ್ಕೊಂಡು 31/2 with 32/3 ಮಾಡ್ಬೋದು, ಇಲ್ಲ 32/4 with 31/2 ಮಾಡ್ಬೋದು.
I will inquire, ma'am, because this is, they are claiming right in my land, that's the problem.
ಅವ್ರಿಗೆ ನೀವು ಅಲ್ಲಿ ಎಕ್ಸ್ಚೇಂಜ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ರೆ 32/4 ಅಲ್ಲಿ ಅವ್ರ ರೈಟಿಗೆ ಸಿಗತ್ತೆ, ಇದು ಮಾಡಿದ್ರೆ ಅದು ಸಿಗತ್ತೆ, ಯು ವೋಂಟ್ ಲೂಸ್ ಎನಿಥಿಂಗ್.
I will inquire, ma'am, I will inquire.
And both of you will get one consolidated piece instead of this.
I will inquire, ma'am.
Ideally 32/4, if it can be exchanged with 31/2.
I will verify it, ma'am.
The extent is the same.
Because, my lords, there is some litigation regarding other things, my lords, that's all.
ಇದಾದ್ರೆ ಅವ್ರಿಗೂ ಒಂದು ಕನ್ಸಾಲಿಡೇಟೆಡ್ ಲ್ಯಾಂಡ್ ಸಿಗತ್ತೆ, ನಿಮ್ಗೂ ಕನ್ಸಾಲಿಡೇಟೆಡ್ ಲ್ಯಾಂಡ್ ಸಿಗತ್ತೆ. ಬಿಟ್ಸ್ ಅಂಡ್ ಪೀಸಸ್ ಎಲ್ಲರೂ ಎಲ್ಲೆಲ್ಲೋ ಇದ್ದೀರಾ. The extent is the same.
I will verify, my lord, I will verify.
And it can be done.
Please.
Same extents and other things is.
Sketch ನೋಡಿದ್ರೆ ಒಂದೇ ತರ ಇದೆ, ಲ್ಯಾಂಡ್ ಆರ್ ನಿಯರ್
I
ಬೈ.
think all same, my lords, because it's one area. I will verify.
ನೀವಂತೂ ಒಪ್ಲೇಬೇಕು.
I will
You will
take
get a better
instructions.
land.
But my lords, according to the report, there was existence of road, my lords, on the said land.
ನಿಮ್ ಲ್ಯಾಂಡ್ ಇಂದಾನೆ ಎಲ್ಲಾದ್ರೂ ಹೋಗ್ಕೊಳ್ಳಿ, ಅವ್ರು ಯಾರು ಕೇಳಲ್ಲ. You will be owning 32/4.
I'll take instructions.
To arguing for some time, both the councils seek for and are granted a week's time to obtain instruction, make the submission as to whether inter-se exchange of lands could be made between the plaintiffs and defendants so as to consolidate the lands and to resolve the dispute between them.
Please.
Relist on 20th February.
Please.
Please.
29, Gurlingeshwar.
I filed the withdrawal memo, man. Matter has been settled before the
this
trial
court
court.
seeking for the following reliefs. A memo dated 11/2/2025 has been filed, signed by the counsel for the petitioner, which reads as under. Accepting the submission of counsel for the petitioner that the dispute between the parties have been settled,
Settlement.
the petition is dismissed as withdrawn.
Please.
30, Srikanti Patil.
This I request one time, Your Lordship. I will file objections.
Respond number 1 has expired. As such, a memo has been filed to treat respond number 2 and 3 as the legal representative of deceased respond number 1. Accepting the said memo, respond number 2 and 3 are treated as legal representative of deceased respond number 1. Counsel for the petitioner to carry out necessary endorsement in the cause title. You are appearing for 4 and 5.
Yes, Your Lordship.
3 ಗೆ notice ತಗೊಂತೀರಾ?
Yes, sir.
3.
Respond number 3.
3 is Nilopant.
Ilopant is for 2.
2. Shakuntala.
3 ಗೆ ಅವ್ರು ತಗೊಂಡ್ಬೇಕಾ?
Yes. 3 is I don't know, Your Lordship.
Issue notice.
I filed a memo, my lord, in respect of respond number 1.
Copy is not given.
Number 3 ಏನು ಹೇಳಿ? Process fee.
Okay.
Counsel for the petitioner is granted a week's time to make payment of necessary process fee in respect to unserved respondent number 3.
Please.
If needful is done by 19th February, registry is directed to issue notice to respondent number 3 returnable by 21st April. Needful is not done by 19th February, relist on 24th for dismissal.
31, Vivraj C. Patil.
Your Lordship, the amendment was carried out in open court, Your Lordship, on 23rd.
This 32-1 amendment.
There was a typographical error in interim prayer paragraph. I was filed, I were allowed, and that amendment was carried out in open court, Your Lordships.
What is 32-1? Office objection. Company seal to be affixed. On wakalat and affidavit to be furnished.
It's
Not amendment.
Please, I'll do it, Your Lordship.
Not for amendment. Counsel for the petitioner seeks one is granted.
1 week's time, Your Lordship. I'll do it.
Week's time. Last time was week's time to comply with the office objection. Relist on 24th February.
Your Lordship, there is an interim order in operation.
There is no interim order. Interim order last time extended. Interim order earlier granted is extended till next day.
Obliged.
32, C. Hiremat.
Which is sought for a typed copy of entire order sheet. Impugned order is typed one.
Accepting the council's submission that the impugned order is typed and the other portion will not be relied upon by the petitioner, office objection seal number 21 is overruled. Yes.
This petition is filed by the plaintiff wherein the counter IA for rejecting the counterclaim has been rejected by the trial court.
So counterclaim is taken on record.
Yes, my lord. Because separate suit is already filed in the same court.
Where is the counterclaim?
OS 167, my lord. Synopsis is like
Page number. ಏನಂತಿದೆ counter suit for?
I have filed suit for rectification of sale deed, stating that my sale in sale deed survey number 55 be substituted by 33. Here filed suit for declaration of ownership over survey number 155.
Counterclaim.
Separate suit is filed. In my suit, he has filed also filed a counterclaim seeking ownership over survey number 150.
Where is the counterclaim?
Counterclaim is at page numbers 27 to 30.
Written statement.
Abolish and
To the
next,
counterclaim.
ಅದರಲ್ಲೇ sorry ma'am, ಇದು rejoinded to counterclaim. It is 18 to 26. Page number 18 to 26 is the WS with counterclaim.
ಇಲ್ಲ. Counterclaim ಎಲ್ಲಿದೆ?
Page number 22.
This is the written statement.
ಇದು ನ್ಯಾಯಾಲಯದವರು ಪ್ರತಿವಾದಿಯ ಎದುರು ಕ್ಲೇಮ್ ಅನುಬಂಧದಲ್ಲಿ ತೋರಿಸಿದ ಪ್ರಕಾರ ತಾಲೂಕು ಪೈಕಿ ಲಕ್ಷ್ಮಣಪುರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 52/1 ಮಾಲೀಕರು ಅಂತ ಠಾರೈಸಬೇಕು ಅಂತಿದೆ.
ಸೂಟ್ ಎಲ್ಲಿ?
ಸೂಟ್ is at page number 33. 33. Prayer at page number 36. ಪ್ರಾರ್ಥನೆ ಮೆಹರ್ಬಾನ್ ನ್ಯಾಯಾಲಯದವರು ವಾದಿಯ ಅನುಬಂಧದಲ್ಲಿ ತೋರಿಸಿದ ಪ್ರಕಾರ ಲಕ್ಮಾಪುರ ಗ್ರಾಮದ ಜಮೀನು ಸರ್ವೆ 52/1 4 ಎಕರೆ ಮಾಲೀಕರು ಅಂತ ಠಾರೈಸಬೇಕು.
Who are the parties there? ನಿಮ್ಮಲ್ಲಿ ಬಸಪ್ಪ, you are the plaintiff.
Yes.
ರಂಗವ್ವ, ಬಸವರಾಜ್, ಶೋಭಾ. ಅಲ್ಲಿ ಬಸವರಾಜ್, ರಂಗಪ್ಪ, ಶೋಭಾ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ. ಅಗೇನ್ಸ್ಟ್ ಬಸಪ್ಪ, ಫಕೀರಪ್ಪ, ಸಿದ್ಧಲಿಂಗಪ್ಪ, ಆನಂದಪ್ಪ.
Please.
The parties are different.
Some other parties, joint owners are there.
So they can maintain that.
But since they are filed separate to it, that will be clubbed along with this and ಇದರಲ್ಲಿ ಬೇಡ ಅಂತ.
You can seek for clubbing of 167 with this.
ಅಲ್ಲ ಬಟ್ ಇದರಲ್ಲಿ ಕೌಂಟರ್ ಕ್ಲೇಮ್ ಬೇಡ.
ಇಲ್ಲ ಒಂದೇ ಅಲ್ವಾ ಅವ್ರು ಕೋರ್ಟ್ ಫೀ ಕೊಟ್ಟಿದ್ದಾರೆ ಎಕ್ಸ್ಟ್ರಾ ಇನ್ನೇನಂತೆ you
ಡಬಲ್
can seek for clubbing of 167 with 30
ಸೇಮ್ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಎರಡು ಸೂಟ್ ಕೌಂಟರ್ ಕ್ಲೇಮ್ ಅಂಡ್ ಸೂಟ್ ಪೆಂಡಿಂಗ್ ಆಗ್ತದೆ.
ಅದಕ್ಕೆ 167 ಕ್ಲಬ್ ಮಾಡಿ ಇಟ್ ವಿಲ್ ಹ್ಯಾಪನ್ ಟುಗೆದರ್. ಅವ್ರು ಕೋರ್ಟ್ ಫೀ ಕೊಡಕ್ ರೆಡಿ ಇದ್ರೆ ಯಾಕೆ ಆರ್ ಯು ಕಮಿಂಗ್ ಇನ್
ಬಟ್ ಮೇಲೆ
ಡಿಕ್ಲರೇಷನ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that an application in IA number 9 filed under section 151 of the Code of Civil Procedure by the petitioner who was the plaintiff in OS number 13 of 2015 seeking for rejection of the counterclaim filed by the respondents herein has been dismissed while order date 11/1/23. His submission is that the counterclaim which had been sought for in OS number 131 of 2015 has been separately sought for by the respondents, by defendants therein in OS number 167 of 2015, pending on the file of the principal civil judge and JMFC, Badami. And as such, the same counterclaim could not have been sought for in the written, along with the written statement in OS number 131 of 2015. Having gone through the papers and the orders which have been passed, it is clear that the parties in OS number 167 of 2015 are different from that in OS number 131 of 2015, in as much as there are additional parties in the said suit. The counterclaim having been filed would have to be considered on merits and necessary orders passed. The said counterclaim cannot be rejected on the basis of an application under Order 8, Rule 6C, the matter requiring trial. Insofar as the submission of counsel for the petitioner that there will be multiplicity of suits, it will always be open for the petitioner's hearing to file necessary application for same quota berena for clubbing of both the suits and for conduct of a common trial, since both the suits are pending before the same court. And as such, I am the considered opinion that there cannot be any infirmity found in the order of the trial court in the present matter. The petition stands dismissed, reserving the aforesaid liberty.
Please.
Make a submission. Still number 82, my lords, permitted, withdraw it.
82.
2.
Petitioner is before this court seeking for the following reliefs. The memo dated 12/2/25 has been filed, signed by the counsel for the petitioner and the GPA holder of the petitioners who has filed the above petition, which reads as under: accepting the said memo and the submission of counsel for the petitioner, petition is dismissed as withdrawn. You have the 82, na?
Please, 82.
Yes.
Much.
ಯಾವುದು 36 ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ರೆ ರೆಸ್ಪಾಂಡ್.
Yes, ma'am.
Needful is not done by the petitioner. Counsel for the petitioner seeks for and is granted 2 weeks time finally to do the needful. If needful is not done by 25th, released on 4th March for dismissal.
I'm moving a memo, my lord. I had invited to, I had moved a memo in quarter number 6. Later, the classification was changed in the office. It was LB now. Matter comes before this court. There's some urgency in this matter.
ಏನು urgency?
my land is being acquired by the government and they're constructing a road over my land without issuing notification or without intimation.
Tomorrow, serve it on the.
It's already
Who is
served.
constructing?
Government, my lord, KRDIL, KRIDL.
ಯಾರು ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್? CV ಅಂಗಡಿಗೆ ಸರ್ ಮಾಡಿ. ಯಾವ್ದ್ರಲ್ಲಿ? 36 entry model. Tomorrow.
Serial number 35, your lordship. 35, your lordship. Weeks of time, your lordship, to comply with all the office objections.
Counsel for the petitioner seeks for and is granted 2 weeks time finally to comply with office objection. In preemptive order ಇದೆಯಾ? ಇಷ್ಟೊಂದು 4th time ಬೇರೆ ಇದೆ.
Kindly,
If
last
needful
chance,
is
your
not
lordship.
done by 25th, relist on 4th for dismissal.
Interim order may be extended.
Interim order earlier granted is extended till next day.
My lord, serial number 34.
Interim without notice. Put 35, put it. Interim order illa. It could not be. No interim order. Yes,
With your lordship's permission, my lord.
Yes.
Serial number 34. Respondent number 12 and 13 were required to file their affidavit. They are government officials, my lord. I don't know.
34 paper the petitioner. Department of Administrative challenge by the civil court.
Intimation ಮಾಡಿದ್ವು information ಬಂದಿಲ್ಲ my lord. Respondent 16 and 17.
Shall appear before virtual video conferencing ಅಂತಿದೆ. ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ bailable warrant ಹೋಗುತ್ತೆ. We'll come back and.
ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ವಾರಂಟ್ ಮಾಡ್ತೀನಿ ಅಂತ
Serial number 83.
Dharwad bench matter, 230 matters, 109. NP Vivek Mehta.
Presenting the compromise petition.
Looks very small. Petitioners have no right. Petitioners have no separate right in the property.
No, my lord.
All respondents.
ಹೌದು. They are the purchasers of the property. Their suit is for specific performance for refund of earnest money.
Your 58 of 2007 is for partition.
Please, my lord.
Now this you are filing in 180 of 2007, which
Please,
is
my
for
lord. That
specific
suit has been decreed and FDP proceeding. They have agreed, my lord.
So FDP will also get closed now.
Closed.
Because undivided interest is sold to the petitioners. So 180 of 2007 will also come to an end.
Please, my lord.
FDP in ಬೇರೆ ಯಾರು ಪಾರ್ಟೀಸ್ ಇದ್ದಾರಾ?
ಇಲ್ಲ. FDP ನೀವು ಹಾಕಿದ್ದೀರಿ. FDP ಬೇರೆಯವರು ಪಾರ್ಟೀಸ್ ಇಲ್ಲ.
FDP is filed by respond number
Govindas LRC.
3 to 5. They have filed a partition suit.
So now FDP will also get closed. Who are the respondents?
Respondents are.
Everybody is here?
Everybody is here, my lord.
Sure.
Stick their photos and with Aadhaar card.
Attendance ತಗೊಂಡಿದ್ದೀರಾ?
ಎರಡು ಸಲ ರಿಹರ್ಸಲ್ ಮಾಡಿದ್ದೀನಿ.
ರಿಹರ್ಸಲ್ ಮಾಡಿ. ಏನ್ ರಿಹರ್ಸಲ್ ಮಾಡಿದ್ರಿ?
Make sure, my lord, doubly sure. There are 28 members ಆಗ್ತಾರೆ ಅವರು. Respondent number 6 is died.
Deleted ಅಂತಿದೆ.
ಹೌದು, deleted. He has no legal representatives, my lord. ಅದಕ್ಕೆ we are handing over the demand draft to drawn in individual according to their share, my lord. And I would also affixed a copy, Xerox copy of
All this total comes to 52 lakhs.
please, my lord. And I had given the DDs to them, my lord.
Who is the youngest of the respondents?
Youngest respondent.
Srimati Radha.
Radha, my lord.
ಯಾರು ರಾಧಾ?
Srimati Radha.
Radha, daughter of Krishna Patil. Radha wife of Abhishek.
ಎಲ್ಡೆಸ್ಟ್ ಕೇಳೋದು ಬೇಡ, ಹೆಂಗೆಸ್ಟ್ ಕೇಳೋಣ. ಬರಮ್ಮ ಮುಂದೆ ಬಾ.
ಮೇಡಮ್ ಈ ಕಡೆ ಬನ್ನಿ.
ಏನ್ ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆಯಾ?
ಮೈಕಲ್ಲಿ ಮಾತಾಡಿ.
ಎಲ್ಡೆಸ್ಟ್ ಕರಿಬೇಕಾ? ದೊಡ್ಡವ್ರು ಹೇಳಿದ್ದು ಒಪ್ಕೊಂಡಿದ್ದೀರಾ? ಯಾರು ಎಲ್ಡೆಸ್ಟ್ ಕರೀರಿ ಹಾಗಾದ್ರೆ, ಇವ್ರು ಬೇಡ. ಆಗಿದ್ರ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಏನಂತ
ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಕಾಂಪ್ರಮೈಸು? ಏನಂತ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಕಾಂಪ್ರಮೈಸು?
ಅದೇ ನಮ್ಗೆ ಎಷ್ಟು
ನಿಮಗೆ ಕೊಡಬೇಕಾದ ಅಮೌಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ನೀವ್ ಹೇಳ್ಬೇಕು, ಮಟ್ಟಿ ಅವ್ರು ನೀವಲ್ಲ. ಲೀಡಿಂಗ್ ಕ್ವೆಶ್ಚನ್ ಆಗಿ ಹೋಗುತ್ತೆ. ಅದಕ್ಕೆ ಹೆಂಗೆಷ್ಟು ಅರ್ಥ ಆಗಿದೆ ಅಂದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ.
ಎದ್ರ ಬಗ್ಗೆ ಅಮೌಂಟ್ ಕೊಡ್ತಾ ಇದಾರೆ?
ಜಾಗದ್ದು.
ಎದ್ರದ್ದು ಯಾವ್ದು ದುಡ್ಡು ಕೊಡ್ತಾ ಇದಾರೆ?
ಭಯಪಡ್ಬೇಡಿ.
ಎದಕ್ ದುಡ್ಡು ಕೊಡ್ತಾ ಇದಾರೆ ಅವರು?
ಜಾಗದ್ದು.
ಯಾವ ಜಾಗ?
ಜಾಗ ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
ಅದ್ರದ್ದು ಅಮೌಂಟ್ ಕೊಡ್ತಾರೆ. ನಮ್ ತಾಯಿದ್ದು ಬರ್ಬೇಕಿತ್ತು, ಹಂಗ ಅಷ್ಟೇ ಗೊತ್ತು. ಹಾಗೆ
ಎಲ್ಲ ಅವ್ರಿಗೆ ಕೊಡ್ತಾ ಇದ್ದೀರಾ? ಎಷ್ಟು ದುಡ್ಡು ಕೊಡ್ತಾ ಇದ್ದಾರೆ?
ಗೊತ್ತಿಲ್ಲ.
ಗೊತ್ತಿಲ್ಲ. ಎಲ್ಡೆಸ್ಟ್ ಯಾರಿದ್ದಾರೆ ಅವ್ರನ್ನೇ ಕರಿ. ಹೂ ಇಸ್ ರೆಪ್ರೆಸೆಂಟಿಂಗ್ ದೆಮ್? ಹೂ ಇಸ್ ದ ಲೀಡರ್?
Number 4 my lord. 5. Respond number 5.
ಏನಂತ ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆ?
ಏನಂತ ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆ?
ಇದು ರಾಜಿ ಅಂತ ಆಗೈತ್ರಿ. ಆಮೇಲೆ ಗವರ್ನಮೆಂಟ್ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಪ್ರಕಾರ ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆ.
ಗವರ್ನಮೆಂಟ್ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಪ್ರಕಾರ ಚೆಕ್ ಕೊಡ್ತಾರೆ. ಕ್ಯಾಶು? ಕ್ಯಾಶು ಕೊಡ್ತಾರಾ?
51 ಲಕ್ಷ ಚಿಲ್ಲರೆಗೆ ಆಗಿದೆ.
ಸೇಲ್ ನಂಬರ್ 109.
ಸರಿ.
The above writ petition had been filed challenging the orders passed on 12/1/2025 allowing the amendment of the written statement in the suit in OS number 180 of 2007, which had been filed by the petitioners for specific performance of an agreement of sale. While the said suit was pending, another suit in OS number 58 of 2007 had been filed for partition and separate possession amongst the respondents who are the joint family members. The said suit having been decreed, FTP proceedings and FTP number 12 of 2015 had been taken up. The parties have now arrived at a settlement whereby all the respondents together have agreed to sell their respective undivided interest as determined in the preliminary decree in OS number 58 of 2007 in favor of the petitioner's purchasers. A compromise petition has been filed which reads, a memorandum of compromise petition has been filed which reads as under. The petitioners and respondents are all before this court personally and are identified by their respective counsels. Their photographs have been affixed on the compromise petition and their Aadhaar cards countersigned by each of the parties having been annexed to the compromise petition. On inquiry, the respondents submit that they have agreed to sell their respective share in the suit secured property to the petitioner's purchasers along with certain others who are not parties to the present suit for a total consideration of rupees 52,00,000,000 at the rate of rupees 4,00,000,000 per acre. The plaintiffs petitioners also confirm the said compromise which has been entered into. In that view of the matter, the compromise being lawful and aiding the settlement between the parties, the submission made by all the parties that there is no undue influence, coercion or duress brought on any of them for the purpose for entering into the said compromise. The said compromise petition is accepted. In furtherance of the acceptance of the compromise petition, I pass the following order. The suit in OS number 180 of 2007, pending on the file of the civil judge and JMFC Shiggaon, is disposed in terms of the above compromise. The civil judge and JMFC Court Shiggaon is directed to draw up a formal compromise decree in terms of the above compromise petition. The proceedings in FDP number 12 of 2015 would also have to come to an end since the undivided interest of all the parties are being sold to the petitioners, and therefore there would be no requirement for division of the property by metes and bounds in the FDP proceedings. The FDP court, the court seized of FDP number 12 of 2015 would have to take into consideration the above compromise petition and pass necessary orders as per the above observation.
Handed over.
Compromise decree, compromise petition may kindly be transferred to the trial court.
The registry is directed to transfer the original of the compromise, transmit the original of the compromise petition by retaining a copy thereof to the so-and-so Shiggaon.
Not I delivered the entire.
ಇವಾಗ ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
ಅವ್ರ
ಅದೇ ಇನ್ನೂ ಒಂದು ತಗೊಳ್ಳಿ.
Usually we have drawn the according to their.
Though in the compromise petition it is stated, ಇಲ್ಲ ಹೇಳಿದ್ದೀರಾ ಕೊಡ್ತೇನೆ. The demand drafts, copies of which are annexed to the compromise petition, have been handed over to the counsel for the respondents, who confirms receipt thereof and undertakes to distribute the same amongst each of the respondents as per their entitlement. Orders, ಎಲ್ಲರದು orders.
ಸಹಿ ತಗೊಳ್ತೀವಿ.
110, Harsh Desai.
My lord, the petitioner has established a resort, my lord, in Bagalkot.
You already established a resort.
Yes, long ago.
On KDB acquiring the land and allotting it. Now 5 to 10 are the, yes, who appears for the KDB?
I appear for KID.
Yes, you have to comply with the order. Dated 14/11.
But we have filed statement of opposition. Government need to establish that the documents lies in the name of the government. Now it is the contention that the land is in the name of the government.
14/11/24. Order ನೋಡಿದ್ದೀರಾ? ಯಾರು ಮಾಡ್ಬೇಕು ಇದು? Respond number 1 and 4 state are required to place.
My lord, pursuant to that order,
Yes.
the state has filed its statement of objections.
You filed.
Yes, my lord. And
What have they said there?
they have said it's a government land.
The acquisition notification is of the year 2004.
Yes.
And the order of the land tribunal was?
81, 1980.
And there's no change in the records.
My lords, after that, my lords,
Hmm?
that order has been set aside, my lords. That order has been set aside by an order of this honorable court, my lords. It was remanded. Then 2004, one more order was passed. That also has been set aside by the division bench of this honorable court. And then, my lords, in 2023, my lords, order which I produced as annexure R8, my lords.
That is also under challenge?
No, my lords, that is not.
That is attained finality.
That has attained a finality.
That is R5 which is produced along with the statement.
State has produced that order also.
Page 23.
However, my lord, so far as this survey number is concerned, the proceedings, my lord, which were initiated in 1981, they stand confirmed.
You acquired it as government land. You have not paid compensation to anybody. You have to pay compensation to them.
No. No, this was under the Land Reforms Act. The earlier owner, my lord, he declared them as excess lands and he surrendered saying that they are tenanted lands. After his death, his legal representatives, my lord, my case is that they have misinterpreted in taking advantage of the name found in the record of rights and contended that it is a private land. When a demand was made, my lord, by KIADB for complying with the interim order of this court in MFA, and an amount of 4 crores was demanded from me, from the beneficiary, my lord. That is when I found the records that the land till today stands in the name of the government. And hence I have submitted a representation, my lord, both to the government as well as.
Worried that you will have to pay the compensation.
So I submitted a representation both to KIADB as well as the state that this is the, my lord, fraud played on the authorities and it must be unearthed. Since they did not take any action, my lord, I have filed this writ petition. Questioning the land acquisition only insofar as this survey number is concerned.
You are the beneficiary of the acquisition.
Yes.
You don't want this land.
My lord, only insofar as that survey number is concerned. About 30 acres, my lord, is granted to me. Out of that, my lord, this land measures one.
It will go back to them.
Lord, if it goes back, my lord, I have no objection at all. But only, my lord, land measuring
1 acre 38 guntas.
1 acre 38 guntas in survey number 109/28. Land measuring 1 acre 38 guntas. But that is anyway, my lord, at the side of the resort, it is not.
So you don't want the land?
Not really.
You want the land?
My lords, no, my lords, having taken possession, my lords, in the year 2005, they admit in their writ petition, my lords, that resort has been set up in the year 2013. Notification challenged is of the year 2003. After a lapse of 20 years, my lords, now, my lords, they are questioning the notification.
At least you will get the land. Otherwise, we are not going to give you any compensation. You have to fight it out with the state. The state cannot now ask them to pay compensation after having acquired it in the year 2003, stating that it is a government land. The mistake has been committed by a
No,
state,
my
you will
lords,
have to go
it
against
is
the
not
state.
a government land for the reason in the year 2023, my lords, that declaration which was filed by the owner, that has been adjudicated and an order has been passed by
So
the tribunal, my lords.
2003 is a notification,
Please, my lords.
free from all encumbrances. Once the acquisition notification is complete,
Please.
it will vest with the KIDB free from all encumbrances.
Yes, my lords, with the KIDB.
Insofar as the petitioner is concerned.
My lords, the petitioner, my lords, he is claiming to be the beneficiary. My first submission, my lords, he is not a beneficiary. It is only the KIDB, my lords, which is the beneficiary. He is only a allottee, my lords. He is an allottee. For that, my lords, I am relying on the decision of the apex court, which says, my lords, such writ petition challenging the acquisition at whose instance the land was acquired is not maintainable, my
You
lords.
want the land or you want the
Compensation.
compensation?
Compensation.
So then you follow it with them.
But
We'll reject your contention. You don't need to pay any compensation.
If I'm not required to pay, my lord, that is the end of.
You fight it out amongst yourselves.
KIDB is the beneficiary. It has been allotted to the petitioner. Unless and until the beneficiary records this amount, ultimately it is the.
As
ultimately
rightly
it is the state.
contended, they are not the beneficiary. Beneficiary is the KIDB. They are only the allottee. Allotment has been done, everything has been completed. Your option is either to concede to this or you agree to pay the compensation. You can't have both.
Both cannot be done as a way at concede. But insofar as the passing of the notification that is by the petitioner in the present situation is concerned, in fact, we have taken a stand that it is a government land. And thereafter, my lord, about nearly 3 proceedings have been taken place before the land tribunal. Ultimately, insofar as survey number 109 part 226.
28.
There is no observations in 23 land tribunal order in so that survey number.
That is between you. Now, what do you want to do? You want the acquisition to continue or you want the acquisition to be quashed?
No, the acquisition. Now already it has been acted upon.
Do you oppose the prayer at Roman 1? Or you concede to it?
Lord, at this stage it cannot be quashed.
So you are opposing.
Lord, in view of this,
In the statement of objection.
If you are opposing it, then compensation has to be paid by you. They cannot be made liable. Whatever the compensation, both of you will determine. They won't be liable to pay.
it is already
Or
determined.
your
my lords.
option is, let this be quashed, take the land and give it back to them. So that there is no money which flows from you. There are only two options. ಇವಾಗ ಮತ್ತೆ ಇನ್ನೊಂದ್ಸತಿ ಕೇಳಿ ದುಡ್ಡು ಕೊಡ್ತಿರೋ ಲ್ಯಾಂಡ್ ಕೊಡ್ತಿರೋ ಅಂತ.
Insofar as what the lordship's clarification, by tomorrow I will give the clarification.
Give you Monday, get proper instructions. I will give you more.
My lords, one submission. Compensation, my lords, is already determined by the reference court against which the KIDB has preferred an appeal before the division bench. In that, my lords, 50% of the amount has been deposited and we have been permitted to, my lords, withdraw that amount also, my lords.
no, I'm sorry, my lord, that liberty to withdraw the amount is stayed.
My lords,
That has not been stayed, Your Lordship. So far the division bench order is concerned, Lord, there is no interference by this order.
I produced a copy of the order, my lords, at
It is
Annex
as-
R1.
R1.
It is as simple as this. When it was government land, it was acquired and allotted to them. They cannot be made liable to pay compensation other than what, on the basis of what you are claiming. Whatever the value was fixed as government land, that is the basis on which they took it. They would be liable to pay only that amount.
My lord, what I respectfully.
If you are going to insist and the state is going to insist them to pay the compensation as per the present value, they having come forward saying, I don't want it.
My lord, if he doesn't want, my lord, it is between the my lord KIDB and my lord those persons are concerned. Lord, our is, Lord, the compensation has been determined by, Lord, by the reference court, and that amount has been deposited, and the division bench
Mr.
have permitted
Patil, now
to
if
withdraw
they,
the amount.
if we are going to quash the acquisition notification insofar as that land is concerned, it's not going to be acquired. Where's the question of compensation?
Lord, so far as us is concerned,
Your land will come back to you.
please,
Your land will come back to you. You use your land.
no, I don't, my lord, already land has been taken, possession has been delivered to him.
It will be
He has
given
no
back
right-
to you. It will be given back to you.
Lord, I don't want land, my lord, I want compensation. Division bench has held that. It will go through
Then you approach them for acquisition separately.
Please.
Then you approach them for acquisition separately. By Monday, you let us know.
Tuesday.
A peculiar situation has arisen
Tuesday.
in the present matter. Inasmuch as nearly 30 acres of land having been acquired have been allotted to the petitioner, including 1 acre 38 guntas in survey number 109/28, situated at Gadankeri village, Bagalkote Taluk and district. Subsequently, the respondent number 5 to 10 have succeeded in a proceedings filed before the land tribunal and have been declared to be entitled to the aforesaid land of 1 acre 38
No,
guntas.
this land is not mentioned in the order. That is my case.
You want, are you contesting that order? ನೀವು ಎಲ್ರೂ
Lord, the land tribunal has not granted it back to them.
But
in
you are
any-
asking for the quashing of the
Yes,
notification.
I am asking.
On
for
that
question.
ground, that they have come forward and you don't want to pay
No,
compensation.
on the ground that it is the government land. That is my ground.
Respondent number 5 to 10 and now come forward claiming that certain rights have been granted in their favor in respect of the aforesaid land in survey number 109/28. And since the KDB has now caused a demand for compensation to be paid to the respondent number 5 to 10 at the enhanced rate and not calculating the compensation as government land, the petitioners are not interested in retaining the land and have as such sought for the relief of quashing of the acquisition notification in respect of the said land. Learned AGA submit that the acquisition being completed, the question of quashing the notification insofar as survey number 109/28 would not arise. Shri F.V. Patil, learned counsel appearing for respondent number 5 to 10 would submit that respondent number 5 to 10 are not interested in getting the land back, but are only interested in compensation. The stand taken by all the three sets of parties has given rise to the above peculiar situation. Inasmuch as the petitioner cannot be made liable to make payment of compensation of the land, towards the land, which the petitioner is not willing to take in view of the change in circumstances being that earlier the land was shown to be government land with a particular valuation and now a claim for compensation is being made by respondent number 5 to 10. The respondent number 5 to 10 cannot also insist on the acquisition being completed and award and compensation to be awarded. It is therefore for the state to make its stand clear as to whether the state wishes to continue, wishes to make compensation, make payment of compensation to respondent number 5 to 10 without calling upon the petitioner to make payment of any amounts in furtherance of the acquisition notification issued, or whether the state is not willing to make payment of compensation, which would require the acquisition notifications to be quashed in respect of the land in survey number 109/28. Relist on 18th at 2:30 p.m.
My lords, in the preliminary notification, it is not shown as government, nowhere, my lords, it is shown as government land, as it is being pleaded, my lords. It is always shown as the land belonging to the petitioner, and later,
Now
my
they
lords,
don't want
as.
the land, madam. You don't want the land. Nobody wants the land.
Allah.
Let us give it to the government.
No, my lords,
No, both of you cannot be arguing like this. One of you choose who is going to argue.
sorry, my lords.
Once you stop, Mr. Patil argued, let him continue.
Just what I want to bring it to also is their assertion that not it's a government land is factually incorrect.
That is why let the government take a stand whether they will pay the compensation.
Statement of objection, we have clearly stated that since 1974.
It's a government land.
Lord, it is not so from records.
So then go to civil court, Mr. Patil.
No, that doesn't arise for simple reason. One aspect, Lord, I want to bring it to Lord, that Lord, this is a land belonging to us, Lord, has been established by the records. Even before the land tribunal also, it has been that I am the owners of the land. Lord, this has been, Lord, acquired at the instance of, Lord, the petitioner's hearing. Lord, having acquired and, Lord, paid the compensation and deposited the compensation, developed the resource, and subsequently say that I don't want this land, Lord, it does not lie.
The submission of Sri Harsh Desai, that the extent of, that in the event of the state not going ahead with the acquisition, and the acquisition notification being quashed, the petitioner would hand over the land in survey number 109/28, free of any construction, to the state. He is placed on record. There won't be any development, it will be clean.
111, Prashant F. Gowder.
I have concluded my arguments.
Lord, the last date of hearing.
Yes.
I had not produced the email withdrawing the resignation of the private respondent. If I may produce the same. Page number 2, my lords, the bottom portion. I would like to request you to withdraw the resignation letter dated 6/8/2020 sent to you. Sir, you are aware that it was a sudden call from the HR section on 23/7/2020 stating that an early retirement letter has to be sent within the hours of intimation. In such a situation, one is forced to comply with the authorities even if they have been mentally affected by such sudden, drastic and inhumane calls taken by the superiors. I have an age-old mother to look after, and losing the job during the pandemic has affected my mental well-being. I would appreciate if taken into consideration of my service and provide me an opportunity to continue my work with the organization. I assure you that I would spare no pains to deserve your confidence if you provide an opportunity to work under your kind supervision. This email, my lords, has been sent on 8th August 2020. That is 2 days after my resignation letter was obtained.
So this is one.
Please.
What about others? Only one of them is withdrawn.
This is with respect to the first petition, my lords. With respect to other petitions, Mr.
You are appearing in only one.
In only one petition.
Others, Mr. Hegde, you are appearing.
Yes, others. First case is, my lord, got to resignation 11101114.
Second matter.
106038. Mr. Abhishek Patil is appearing and he has filed the memo.
Yes.
Have you withdrawn your resignations?
Yes, my lord, I have also produced some documents along with my memo. The issue starts with, my lord, Tribunal 1114. Yes. Immediately, my lord, when the issue of resignation and there was one more word used, my lord, in the applications, that is early retirement. That was construed as, my lord, resignation by the employer. early retirement, my lord, in the worst scenario could be treated in a situation where VRS scheme exists, some benefit. That is earlier, my lord, the superannuation period is fixed for a particular age. If he wants to go early, my lord, that is VRS, voluntary retirement, before he attaining the age of superannuation. Now that was considered as a resignation in this case. In my two cases, my lord, the application reflect.
Show us your letters.
Yeah, my lord, first case is, my lord, resignation. The present case, what my lord is holding. 1011 my lord may take it first. Let us not get into confusion.
So 1114 ಅಲ್ಲಿ ಏನು?
Idral resignation.
Withdraw ಮಾಡಿದೀರಾ?
Withdraw, my lord, he has sent a mail. He has sent a mail, my lord, subsequently.
Page?
After the acceptance. After the acceptance. My lord, now kindly see, my lord, before going to that, kindly take, my lord, Annexure D, page 28.
Yes.
The argument was immediately on resignation, it was accepted. Page 28, what they say is, my lord, I am putting forward this letter with is for opting myself to resign from your esteemed organization on my personal reasons, so kindly so and so. Kindly come to next letter, my lord, what the management informs. Further to your letter dated 28/7/2020, your resignation is hereby accepted and you will be relieved from the services of the organization with effect from 30/9/2020. Before that, my lord, all the documents got signed and the issue was taken up even before the Honorable Chief Minister, who in turn refers to the, my lord, Labour Commissioner. Then, my lord, we made a request to the Labour Commissioner also. The issue is not, they have kept quiet. And it was, my lord, in the portal of Prime Minister also, they have made out a grievance. Then the Labour Commissioner was informed of
What was
this.
the documents mistake?
This is, my lord, the resignation.
So that is why it was urgent for you to show us the documents. The dates are relevant. Show us the document with the dates. Ready idira ilvo?
Yes, my lord, I will point out, my lord, one, along with the counter statement, my lord, they say that along with the counter, which I have filed this to this petition, I have produced one document, my lord, where
Yes.
he has informed that, my lord, based on his performance,
Has been rated as fair.
Fair. My lord, the second, my lord, what point which I have raised is, there was no reason for me to resign at all. It was taken, my lord, in order to reduce the workforce. Then it was brought to the notice of various authorities, then it's sent.
You received the settlement. You received the settlement. All the amounts have been calculated.
Yes, they have been got signed before my relieving date was fixed in their own letter.
You received the amount. Vapas kotra?
Yes, vapas kodlilla.
Vapas kodlilla. Resignation letter withdraw madadra? Madlilla. Resignation letter kotri or accept madadru ದುಡ್ಡು ತಗೊಂಡ್ರಿ ಸುಮ್ಮನೆ ಇದ್ರಿ.
We brought to the authorities, my lord, it was forcibly taken.
ಆಮೇಲೆ you raised the issue.
Yes.
So the money is being utilized by you.
Yes, that is paid, that was remitted to our accounts.
And you use that money.
Yes, my lord, even otherwise.
You should have said, no,
yes.
No, I never resigned. You are misinterpreting my letter. You have forced my letter. Take back your money and take me back and ಹೇಳ್ಬೇಕಾಗಿತ್ತು.
ಅಂತ ಒಂದು ಕನ್ಸಿಸ್ಟೆಂಟ್ ಇದಾಗಿ ಬರೀಲಿಲ್ಲ ಅವರು. ವಾಟ್ they said was brought to the notice of the government, my lord, they are all workers. Suddenly it has come in the COVID period. Then they said, my lord, this is the way we have been harassed.
Not workmen.
They have protested.
They're all educated people. These
They
are
have
all educated
protested.
people.
They have protested.
But you retained the money with you. See, you can't take the benefit and say, I won't take the you should have returned back the benefit.
Lord, for that, my humble submission is, my lord, even if assume that I have been terminated from services in the COVID period without notice, my lord, am I not entitled for, unless it is for a moral turpitude? Definitely I am entitled for the benefits of statutory benefits like gratuity and PF. They have not paid any extra amount.
If you are terminated, there's no problem.
Yes.
If you are resigned, we don't know what has happened, but the documents only read. That's why we have been asking, show us any document to the contract. We'll have to go by documents.
Yes, document and
new document to us.
exactly correct. What is weighing in the mind, my lord, I can,
we can
understand.
pass the orders.
Yes.
On presumption, we can't pass an order.
My humble submission is, my lord, the whole scenario as such, it was not happened to one or the two persons. En masse, my lord, they have taken a letter either by way of a resignation, or in such cases, my lord, where I am pointing out, it was taken as early retirement, which is unknown to either.
ಒಂದೊಂದೇ petition ತೋರಿಸಿ, ಇದರಲ್ಲಿ ಏನಿಲ್ಲ 114 ಅಲ್ಲಿ.
Idರಲ್ಲಿ he has taken it, my lord, he contends that it has before.
This is a resignation.
Resignation.
114 is a resignation.
Resignation.
905.
905, my lord, that is termination.
905. Termination, my lord.
That is
my lord,
that I will argue separately, my lord. 905 and 111.4. These two cases are termination.
905 and 909.
Yes.
Are different.
That is separate.
905.
All the remaining 7 cases, my lord, are resignation.
908.
908 to termination.
908 to termination.
Yes.
Page?
909, my lord.
908.
111.2 is termination. 111.4 is termination. The remaining 7 cases are resignation only.
Now we are asking about 908, 11.3.
908, sir.
Resignation. First case resignation.
Nimd argument ಆಯ್ತು Mr. Brunel. Let Mr. Hegde
908 termination, sir.
908 ಏನು?
Termination, sir.
Page?
Really. Next, sir, yes. Termination letter ಹಾಕಿಲ್ಲ. ಇದು ಟರ್ಮಿನೇಷನ್ ಸರ್. ಇದು
ಪೇಜ್ ನಂಬರ್ ಹೇಳಿ.
ಅದು ಟರ್ಮಿನೇಷನ್ ಲೆಟರ್ ಹಾಕಿಲ್ಲ ಅವರು. ದೇ ಹ್ಯಾವ್ ಕ್ವಶ್ಚನ್ ದಿ ಅದೇ ಅಲ್ಲ ಕೇಸ್ ನಂಬರ್ ಹೇಳಿ ಸರ್ ನೀವು ಕರೆಕ್ಟ್.
ಕೇಸ್ ನಂಬರ್ 101,905 101,909.
ಅದರಲ್ಲಿ ಪೇಜ್ 51, my lord, is the points of disputes referred. 10908 ಅಲ್ಲಿ.
Yes. ಹೇಳಿ. Which point?
ಅದರಲ್ಲಿ
the common order 4222.
That is on points of dispute what they have produced is totally different. That is
Shri Basuraj P ಮತ್ತು ಹನುಮಂತ ರಾಜು. ನೀವು ಯಾರು? Who is the respondent? ಇದು N Devraj.
ದೇವರಾಜ್ ಇವರ ಹೆಸರು.
So this annexure N is not related to Devraj.
Yes, ದೇವರಾಜು ಸಂಬಂಧಪಟ್ಟಿದ್ದಿಲ್ಲ, ಅದು ಯಾವುದೋ ಬೇರೆ ಹಾಜರು ಮಾಡಿದ್ದಾರೆ.
Yes.
That my lord may dealing it, my lord.
What is the order passed by?
Prayer is F ಅಂತ ಹೇಳ್ತಾರೆ. F is not pertaining to.
This termination of services, page 29. Subramanian. This termination, 908 is also termination of service.
Oh.
Page 29, nodi, para 5, last line.
ವಜಾಗೊಳಿಸಿರುವುದು ನ್ಯಾಯಸಮ್ಮತವೇ ಅಂತ.
908, it is resignation, my lord.
Please see page 29, para 5, last line.
ಎಲ್ಲ
ಈ ಕಡೆ ಇರ್ಬೋದು, ಆ ಕಡೆ ಇರ್ಬೋದು, ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರಕಾರ. ಇದು ಟರ್ಮಿನೇಷನ್.
My lord, 908, your lordship may kindly turn to page 32 of the writ petition, my lord.
Yes. 32 is a notice.
Page 32. This is resignation only.
32 in 908.
The 101908 of 2022. This is resignation, my lord.
Illappa.
In page 32, annexure D.
G, which is a notice issued by the labor court.
And your lordship may kindly turn to page 34. Page 34. I have accepted resignation and relieved him on 39/2020.
Nodi.
ಅವ್ರು ಬಹುಶಃ ನಂಬರ್ ತಪ್ಪು ಬರ್ಕೊಳ್ಳಿ.
29 para 5 ನೋಡಿ.
101,908, Devraj, this number.
ನಿಮ್ ಕ್ಲರ್ಕ್ ತಪ್ಪು ಬರಿಬೇಕು ಸರ್ ನಂಬರ ಒಂದೇ ದಿವಸ ಫೈಲ್ ಮಾಡಿದಾಗ.
No, this is Devraj's termination.
Yes, because that led to, my lord, my mistake also. I have withdrawn some number, some writ petition, which was different function. Then I sought for recall. It was filed on the same day. There are 6 petitions.
Yes.
Rangu ಆಗ್ತಾವ sometimes.
Yes, my lord. This
ಕೆಲಸ
is
ಮಾಡಿ ಸ್ವಲ್ಪ
termination.
ನೋಡ್ಕೊಳ್ಳಿ. will go to the
Correct,
next
Devraj,
matter.
termination, correct. Correct, my lord.
Termination.
Termination.
So ಅದು side gidi. 905, 908 termination. 909.
101099 ತಗೊಳ್ಳಿ.
ಇದು termination ಅಲ್ವಾ?
ಇಲ್ಲ 909, my lord.
909 ಬೇರೆ.
ಇದು early retirement. Neither
That is
resignation
resignation
not
only.
Early retirement. Page,
early retirement.
1009, resignation only.
page,
Page, my lord, 32. What they have produced.
this is early retirement.
Early retirement.
Early retirement.
911.
Nine 11 resignation, my lord.
Yes, sir, on the Noor Ahmad.
Page 35.
Page 30.
Nine one two.
912 also, my lord, resignation, Annexure C, page 28.
Your early retirement.
Annexure C, page 28. And acceptance, Annexure D,
ಇದು
page
early
28.
retirement, ಇದು resignation.
Early retirement. Page 29.
28. Clear my PF, gratuity, leave encashment, bonus, LTA, pension and other allowances. Nine one five.
915, it is also resignation, my Annexure C, page 26.
20.
Acceptance, Annexure D, page 27.
Nine one five resignation.
Yes. 920 is also resignation.
Nine
Annexure D,
two
page 31.
920.
Annexure D, page 31. Acceptance of resignation, Annexure D, page 32.
Gorpadana.
So now there are three sets. One is resignation, two is early retirement, three is termination.
Early retirement also resignation only, my lord. They said early retirement.
Early retirement.
That is the word used by them. There is no early retirement. I did not frame any voluntary retirement scheme.
Early retirement.
He wanted to retire early on his own. That is voluntary.
My instruction was, my lord, during the pendency of
There is no voluntary retirement scheme. There are only two, resignation and termination. Two cases are termination. In the case of termination, my lord, the
Yes.
First case, my lord, may I shortly, my lord, I will conclude it. The question is, my lord, it was projected as it was a resignation tendered by me. And the date was notified as relieving. Is 30/9/2020. Resignation was dated 28/7/2020.
Which matter?
First time, my lord, 101114 of 2022. My lord may take that file, my lord. One by one.
ಅವರು ಕೊಟ್ವಲ್ಲ ನೋಡಕ್ಕೆ ಅವರು ಕೊಟ್ವಲ್ಲ ನೋಡಿ
ಇವಂದು ಹರಿ ಹರಿ ಹರಿ
Yes, 1114.
Yes. Lord, kindly take page 28, my lord. This is my resignation that has been projected by them. That is dated 28/7/2020.
Yes.
Then, my lord, the next letter, which immediately, my lord, it was, kindly take, my lord, it was addressed not to my head where I was working. It was addressed to the, my lord, Human Resource Development, JSW, Vijayanagar. It was not routed through my head of the department. Then, my lord, next is the acceptance, and kindly take note of, my lord, the which was effective, what they say, relieving from 30/9/2020.
Yes.
So therefore, there could not have been any cessation of work even anterior to that date, which was fixed by them. So therefore, my humble submission is the query put by this honorable court saying that you have signed on other records. That is even prior to my cessation of work. That is, my lord, 24/9 and others. The document got prepared. Annexure J
Yes.
and other documents, my lord, the next documents K, they were all, my lord, even prior to my cessation of work. Employer is under no obligation to pay anything unless the work is, my lord, the relationship of master and servant ceases. According to them, you will be relieved. Your services will come to an end as per your letter on 30/9/2020. What was the reason for the employer to take it? So therefore, my lord, the allegation made by the workers saying that it was obtained under a duress assumes importance. In the wake of, my lord, the representation being given and the newspaper article which was published in the newspaper and the complaint which was written to the Prime Minister portal, which has made the labor, my lord, department to swing into an action. So therefore, all these disputed questions of facts, which, my lord, we have to prove it before the court. So therefore, one of the contentions raised by them was, I was not coming under the category of a workman. So therefore, the reference made by the government has to be nipped at bud by quashing the same. That is what the request made by them in the present petition. Now, my lord, so therefore, my first submission is, even assuming that, my lord, taking a statutory benefit which even the employee otherwise entitled to, not for the misconduct of moral turpitude. My lord, they have not given anything extra. It was the benefit earned by the process of his service rendered to the employer, what they have paid. Any extra amount has not been paid. So therefore, in the wake of allegation that, my lord, it was obtained under a duress during the COVID period. So therefore, my lord, it requires an adjudication at the hands of the learned labor court by leading appropriate evidence. Even, my lord, the points of disputes, what they have referred to the labor court, as could be seen from the points of disputes itself, annexure T, the burden was fastened on the employee himself to prove that whether he falls under the category of that workman or not.
Yes.
If that issue is answered against me, my lord, all the issues, my lord, become redundant. It need not be answered at all. So therefore, instead of, my lord, nipping at the bud, let them have the opportunity of saying before the learned judge for where it was referred to. If it was considered as a preliminary issue also, we have no objection for that.
Yes.
And my lord, the factual report where the government has the labor commissioner after the process of conciliation, my lord, kindly have a cursory look at
Yadu?
the factual report which was produced at annexure, my lord. Yes, page number 53 is the typed version, my lord, according to my copies, my lord.
Yes.
I believe it is correct. The this is the, my lord, may skip that first second para. ಅರ್ಜಿಯನ್ನು ಅರ್ಜಿದಾರರು ನೋಂದಾಯಿಸಿಕೊಂಡು 4/12/20 ನಡೆಸಲಾದ ಜಂಟಿ ಸಭೆಯ ಅರ್ಜಿದಾರರು ತಮ್ಮ ದೂರಿನ ಬಗ್ಗೆ ವಿವರವಾಗಿ ತಿಳಿಸಿದ್ದು ಅದನ್ನು ನಡವಳಿಯಲ್ಲಿ ದಾಖಲಿಸಿರುತ್ತದೆ. ಆ ಪ್ರಕಾರ ಅರ್ಜಿದಾರರು ತಾನು 3/8/99 ಜೂನಿಯರ್ ಇಂಜಿನಿಯರ್ ಆಗಿ ಸೇವೆ ಸಲ್ಲಿಸಿ 6 ತಿಂಗಳ ಅವಧಿಯಲ್ಲಿ ನಂತರ ಜೂನಿಯರ್ ಇಂಜಿನಿಯರ್ ಆಗಿ ಕಾಯಮಾಗಿರುತ್ತೇನೆ. ತದನಂತರ ಅಸಿಸ್ಟೆಂಟ್ ಮ್ಯಾನೇಜರ್ ಹುದ್ದೆಯಲ್ಲಿ ಗ್ರೇಡ್ L 9ರ ವಾರ್ಷಿಕ ಸೋಗಳ ವೇತನದ ಮೇಲೆ ಕೆಲಸ ನಿರ್ವಹಿಸುತ್ತಿದ್ದು 28/7/21 ಕಾರ್ಯನಿರ್ವಹಣೆ ಕಡಿಮೆ ಇದೆ ಎಂದು ಒತ್ತಾಯಪೂರ್ವಕವಾಗಿ ರಾಜೀನಾಮೆ ಪತ್ರ ಬರೆಸಿಕೊಂಡು 30/7/20 ಕೆಲಸದಿಂದ ಬಿಡುಗಡೆಗೊಳಿಸಿ 1/8/20 ಕೆಲಸದಿಂದ ತೆಗೆದುಹಾಕಿರುತ್ತಾರೆ. ನನ್ನನ್ನು ಪುನಃ ನೇಮಿಸಿಕೊಳ್ಳಬೇಕೆಂದು ಸೇವೆಗೆ ಪರಿಹಾರ ನೀಡಲು ಕೋರಿರುತ್ತಾರೆ. ಅರ್ಜಿದಾರರ ದೂರಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಆಡಳಿತ ವರ್ಗದವರು 6/3/21 ವಿಚಾರಣೆಯಂದು ಸಂಕ್ಷಿಪ್ತವಾಗಿ ಲಿಖಿತ ಹೇಳಿಕೆ ಸಲ್ಲಿಸಿ, ಅರ್ಜಿದಾರರು ಮ್ಯಾನೇಜರ್ ಅಥವಾ ಆಡಳಿತಾತ್ಮಕ ಹುದ್ದೆಯಲ್ಲಿದ್ದು ಮಾಸಿಕ 8,000 ರೂಗಳಿಗಿಂತ ಹೆಚ್ಚು ಸಂಬಳ ಪಡೆಯುತ್ತಿದ್ದರೆಂದು, ಆದ ಕಾರಣ ವಿವಾದಗಳ ಕಾಯ್ದೆ ಅರ್ಜಿದಾರ ವರ್ಕ್ಮನ್ ಪದ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುವುದಿಲ್ಲ ಎಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ಆದ ಕಾರಣ ಅರ್ಜಿಯನ್ನು ವಜಾಗೊಳಿಸಬೇಕೆಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ಅರ್ಜಿದಾರರು ದಿನಾಂಕ 15/3/21 ಆಡಳಿತ ವರ್ಗದ ಆಕ್ಷೇಪಣೆಗಳಿಗೆ ಪ್ರತಿ ಹೇಳಿಕೆ ಸಲ್ಲಿಸಿ, ತಾನು ದಿನಾಂಕ ಆಗಸ್ಟ್ 1999 ನೇಮಕೊಂಡು 21 ವರ್ಷಗಳ ಸೇವೆ ಸಲ್ಲಿಸಿದ ನಂತರ ಅಸಿಸ್ಟೆಂಟ್ ಮ್ಯಾನೇಜರ್ ಹುದ್ದೆಗೆ ಬಡ್ತಿ ಹೊಂದಿ ಫೀಲ್ಡ್ ಆಪರೇಟರ್ ಆಗಿ ಕೆಲಸ ನಿರ್ವಹಿಸುತ್ತಿದ್ದಾಗಿ, ತನ್ನ ದಿನನಿತ್ಯದ ಕೆಲಸವೆಂದರೆ ಫೀಲ್ಡ್ ಇನ್ಸ್ಪೆಕ್ಷನ್, ಚೆಕಿಂಗ್, ಯಂತ್ರೋಪಕರಣಗಳ ದೋಷಗಳನ್ನು ಪರಿಶೀಲಿಸುವುದು, ಲೋಡಿಂಗ್ ಅನ್ಲೋಡಿಂಗ್ ಚಟುವಟಿಕೆಗಳು ಹಾಗೂ ಸದರಿ ವಿಷಯಗಳ ಬಗ್ಗೆ ಹಿರಿಯ ಅಧಿಕಾರಿಗಳಿಗೆ ವರದಿ ಮಾಡುವುದು ಮತ್ತು ಹಿರಿಯ ಅಧಿಕಾರಿಗಳು ಹಾಗೂ ಆಡಳಿತ ವರ್ಗದವರ ನಿರ್ದೇಶನದಂತೆ ಕೆಲಸ ನಿರ್ವಹಿಸುವುದಾಗಿರುತ್ತದೆ. ಆದ ಕಾರಣ ತಾನು ಕೈಗಾರಿಕಾ ವಿವಾದಗಳ ಕಾಯ್ದೆಯಡಿ, ಇಲ್ಲಿ ವರ್ಕ್ಮನ್ ಕ್ಯಾಟಗರಿಯಲ್ಲಿ ಬರುತ್ತೇನೆಂದು, ಕೈಗಾರಿಕಾ ವಿವಾದಗಳ ಕಾಯ್ದೆಯಡಿ ನೌಕರನೊಬ್ಬನು ನೌಕರರ ನೇಮಕಾತಿ ಮಾಡುವ ಅಧಿಕಾರ ಹೊಂದಿದ್ದರೆ, ನೇಮಕಗೊಂಡ ನೌಕರಿಗೆ ಸ್ವತಂತ್ರವಾಗಿ ತರಬೇತಿ ನೀಡುವುದು, ಸಭೆ ನಡೆಸುವುದು ಮೊದಲಾದ ಆಡಳಿತಾತ್ಮಕ ಕೆಲಸಗಳನ್ನು ನಿರ್ವಹಿಸುತ್ತಿದ್ದರೆ ಮಾತ್ರ ಕಾಯ್ದೆಯಡಿ ಆತನನ್ನು ವರ್ಕ್ಮನ್ ಆಗುವುದಿಲ್ಲವೆಂದು, ಆದರೆ ಆಡಳಿತ ವರ್ಗವು ತನಗೆ ಅಂತಹ ಜವಾಬ್ದಾರಿ ನೀಡಿರಲಿಲ್ಲವೆಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ಕೋವಿಡ್-19 ಅವಧಿಯಲ್ಲಿ ಯಾವುದೇ ನೌಕರನ್ನು ಕೆಲಸದಿಂದ ತೆಗೆದುಹಾಕಬಾರದೆಂದು ಸರ್ಕಾರದಿಂದ ಆದೇಶವಿದ್ದರೂ ಸಹ ಆಡಳಿತ ವರ್ಗದವರು ಆದೇಶವನ್ನು ಪಾಲನೆ ಮಾಡಿರುವುದಿಲ್ಲ. ಆಡಳಿತ ವರ್ಗದವರು ತನಗೆ ನಿವೃತ್ತಿಗೊಳಿಸುವ ಪೂರ್ವದಲ್ಲಿ ನೋಟಿಸ್ ನೀಡಿರುವುದಿಲ್ಲ ಹಾಗೂ ತನಗೆ ಮಾನಸಿಕವಾಗಿ ಹಿಂಸೆ ಮಾಡಿ ತನ್ನಿಂದ ಒತ್ತಾಯಪೂರ್ವಕವಾಗಿ ನಿವೃತ್ತಿ ಪತ್ರವನ್ನು ಪಡೆದಿರುತ್ತಾರೆ. ಈ ಕುರಿತಂತೆ ಗೌರವಾನ್ವಿತ ಸೇವೆಯಲ್ಲಿ ದೆಹಲಿ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಸೋ ಅಂಡ್ ಸೋ ಅಂತ ಎಲ್ಲ ಮಾಡ್ತಾರೆ. Then my lord, skip that paragraph, my lord, some judgment is referred. ದಿನಾಂಕ 4/12/20, 16/2/21 ವರೆಗೆ ನಡೆಸಲಾದ ಜಂಟಿ ಸಭೆಗಳನ್ನು ಅರ್ಜಿದಾರರ ದೂರು ಇತ್ಯರ್ಥವಾಗದ ಕಾರಣ ಹಾಗೂ 16/2/21 ಸಭೆಯಲ್ಲಿ ಅರ್ಜಿದಾರರು ಸಲ್ಲಿಸಿದ ಪ್ರತಿ ಹೇಳಿಕೆಗಳ ಆಧಾರದ ಮೇಲೆ ಅರ್ಜಿದಾರರ ದೂರನ್ನು ಕೈಗಾರಿಕಾ ವಿವಾದವೆಂದು ಪರಿವರ್ತಿಸಿ ದಿನಾಂಕ 6/3/21, 5/7/21 ವರೆಗೆ 4 ಸಂಧಾನ ಸಭೆಗಳನ್ನು ನಡೆಸಲಾಗಿರುತ್ತದೆ. ಸಂಧಾನ ಸಭೆಯಲ್ಲಿ ಅರ್ಜಿದಾರರು ಈ ಹಿಂದೆ ಸಲ್ಲಿಸಿದ ಪ್ರತಿ ಹೇಳಿಕೆಗಳನ್ನು ಉಲ್ಲೇಖಿಸುತ್ತಾರಲ್ಲದೆ ತನ್ನ ಬಾಕಿ ಉಳಿದಿರುವ ಸೇವೆಗೆ ಅನುಗುಣವಾಗಿ ಸೂಕ್ತ ಪರಿಹಾರ ಕೊಡಿಸಬೇಕೆಂದು ಕೋರಿರುತ್ತಾರೆ. ದಿನಾಂಕ 5/7/21 ನಡೆದ ಸಂಧಾನ ಸಭೆಯಲ್ಲಿ ಆಡಳಿತ ವರ್ಗದವರು ಅರ್ಜಿದಾರರ ವಿವಾದ ಸಂಬಂಧಿತ ಲಿಖಿತ ಹೇಳಿಕೆಯನ್ನು ಸಲ್ಲಿಸಿ, ಲಿಖಿತ ಹೇಳಿಕೆಗಳಲ್ಲಿ ಅರ್ಜಿದಾರರ ಅಸಿಸ್ಟೆಂಟ್ ಮ್ಯಾನೇಜರ್ ಮತ್ತು ಆಡಳಿತಾತ್ಮಕ ಮೇಲ್ವಿಚಾರಕ ಸ್ವರೂಪಗಳ ಕೆಲಸಗಳನ್ನು ನಿರ್ವಹಿಸುತ್ತಿದ್ದು, ಶಿಫ್ಟ್ ಇನ್ಚಾರ್ಜ್ ಆಗಿಯೂ ಸಹ ಕೆಲಸವನ್ನು ನಿರ್ವಹಿಸುತ್ತಿದ್ದು, 15,000ಗಳಿಗಿಂತ ವೇತನ ಪಡೆಯುತ್ತಿದ್ದರಿಂದ ಕಾಯ್ದೆಯ ಪದದ ವ್ಯಾಪ್ತಿ ಅಡಿ ಬರುವುದಿಲ್ಲವೆಂದು, ಅಲ್ಲದೆ ಅರ್ಜಿದಾರರು ತನ್ನ ಕೆಲಸಕ್ಕೆ ರಾಜೀನಾಮೆ ನೀಡಿದ್ದು, ರಾಜೀನಾಮೆ ಅಂಗೀಕರಿಸಿ ಉಪಧನ PF ಸೇರಿದಂತೆ ಆತನ ಸೇವೆಗೆ ಪೂರ್ಣ ಮತ್ತು ಅಂತಿಮ ಸಂದಾಯ ಮಾಡಲಾಗಿರುತ್ತದೆಂದು, ಆದ ಕಾರಣ ಅರ್ಜಿದಾರರ ಅರ್ಜಿಯನ್ನು ವಜಾಗೊಳಿಸಬೇಕೆಂದು ಕೋರಿರುತ್ತಾರೆ. ಉಭಯತ್ರನ್ನೊಳಗೊಂಡಂತೆ ನಡೆಸಿದ ಸಂಧಾನ ಸಭೆಗಳಲ್ಲಿ ಪರಸ್ಪರ ಚರ್ಚಿಸಲು ಹಾಗೂ ವಿವಾದವನ್ನು ಬಗೆಹರಿಸಿಕೊಳ್ಳಲು ಸಾಕಷ್ಟು ಕಾಲಾವಕಾಶ ಮತ್ತು ಸೂಕ್ತ ಸಲಹೆ ಮತ್ತು ಮಾರ್ಗದರ್ಶನವನ್ನು ನೀಡಲಾಗಿರುತ್ತದೆ. ಆದಾಗ್ಯೂ ಉಭಯತರ ನಡುವೆ ಯಾವುದೇ ಸೌಹಾರ್ದಯುತ ಒಪ್ಪಂದಕ್ಕೆ ಬರಲಾಗಿರುವುದಿಲ್ಲ. ಉಭಯತ್ರರು ತಮ್ಮ ನಿಲುವುಗಳಿಗೆ ಬದ್ಧರಾಗಿರುವುದರಿಂದ ಒಪ್ಪಂದ ಏರ್ಪಡದೆ ಸಂಧಾನ ವಿಫಲವಾಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಈ ಪ್ರಕರಣವನ್ನು ಮುಂದುವರಿಸಿಕೊಂಡು ಹೋಗುವುದರಿಂದ ಯಾವುದೇ ಪ್ರಯೋಜನವಿಲ್ಲವೆಂದು ತೀರ್ಮಾನಿಸಿ ಸಂಧಾನ ವಿಫಲತೆಯನ್ನು ಮುಕ್ತಾಯಗೊಂಡಿದೆ ಎಂದು ಪರಿಗಣಿಸಿದೆ. ಕೈಗಾರಿಕಾ ಕಾಯ್ದೆಯಲ್ಲಿ so and so. This report was forwarded to the government. Government, by exercising its administrative power, by reference dated, my lord, 7/1/2022, fastening, my lord, proving of whether he falls under the category of a workman or not, referred the issue to the, this is how, my lord, before the conciliation officer, during the conciliation proceedings were on, my lord, the management, though contended in this petition that they do not fall under this category of a workman and there is a voluntary resignation, this and that, they did not place any material except contending that he is drawing more than salary fixed in the definition, so therefore they do not fall under the category. Their work chart, or if they have taken any decision, if they have issued any memo, prima facie, at least to show it to the authority that this matter doesn't require any reference, it has to be closed here itself. There was nothing which was available before the authority. Even what they have placed before this court, they were not available before the authority at all. So therefore, we cannot find fault with the authority in making a reference, that too fastening my lord, framing the first point of disputes against us, though there were no materials. Now, my lord, the next question that would arise for consideration in the cases of reference is whether the the conciliation machinery provided under the Act, under Section 12 or 10 as the case may be, can usurp the power of the labor court. The courts have held, my lord, I am referring to two judgments or three judgments of the Honorable Division Bench, where consistently, my lord, the view of the court is whether he falls under the category of a workman or not, notwithstanding his designation and salary. It is a pure question of fact which has to be adjudicated based on the evidence which will be placed before the adjudicating machinery. The government cannot usurp the power of the labor court. Then the labor court, the existence of the labor court becomes redundant. The role of the conciliation is whether a possibility of any settlement could be arrived at, whether there is a prima facie case for a reference. These are all the two things which are adjudicated or which has to be seen by looking at the papers which were forwarded before the authority during the conciliation proceedings. They cannot go beyond, my lord, what has placed before them. So therefore, my humble submission is, my lord, this is a case where the authorities have found, based on all the records which were available before the conciliation, the complaint made by the workers, not one, several workers, agitations made, report of the DC, and representation made to the DC, and representation made to the Prime Minister portal during the COVID period.
Where are those documents, Mr.
My lord, they were, I have placed it, my lord, along with memo. These are all the.
Show us those documents. Again, ಮೂರು ಸತಿ ಕೇಳಿ ಆಯ್ತು.
ನಾನು ಹಾಕಿದ್ದೀನಿ, ನಿನ್ನ ಮೆಮೋ ಜೊತೆಗೆ ಹಾಕಿ.
ಎಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ ತೋರಿಸಿ.
ಫಸ್ಟ್ ಕೇಸಲ್ಲಿ ಹಾಕಿದ್ದೀನಿ.
ಯಾವ್ದ್ರಲ್ಲಿ 114 ಅಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ?
ಹಾ, ಮೆಮೋ ವಿತ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಂತ.
Memo dated?
Dated, my lord, yesterday it was filed, 11/2.
Yesterday it was filed. 11/2 ಇದೆ. Yes. Take us through the documents.
First is, my lord, it has agitation has come in the newspapers. Then, my lord, the very first letter.
The date is 1/9/2020. Yes.
This is, my lord, 31/8/20.
Last date for this one was 39.
39.
So 39. Before that only.
Yeah. Then, my lord, 31/8/2020, my lord, which was the representation sent through a district deputy commissioner to the Honorable Chief Minister, where, my lord, they have made out a grievance. Typed copies next, my lord. Next, second.
ಇದೇ ಫಸ್ಟ್ ತೋರಿಸಬೇಕಾಗಿದೆ.
ಇಲ್ಲ, ಇದನ್ನೆಲ್ಲ ಅಲ್ಲ ಅಥಾರಿಟಿ ಮುಂದೆ ಅವ್ರಿಗೆ ಗೊತ್ತಾದ್ಮೇಲೆ ಇದ್ರಲ್ಲಿ ಸ್ವಲ್ಪ ರಿವರ್ಸ್ ಗೇರಲ್ಲಿ ಹೋಗಿದ್ದಾರೆ ಅವರು. ಯಾಕೆಂದ್ರೆ ಫಸ್ಟ್ the last one is, my lord, the letter, the email sent by the petitioner in the file which my lord is holding. It was sent on, my lord, 9th August 2020. 30/9/2020 was, my lord, really my relieving date. 17, page number 17.
Yes.
Date 9th August 2020.
This was issued on 9th August.
ಸ್ವಲ್ಪ ಬುದ್ಧಿವಂತರೆಲ್ಲ ಸ್ವಲ್ಪ ಕಳಿಸಿದ್ದಾರೆ, ಆ ತರ ಮಾಡಿದ್ದಾರೆ. ಕೆಲವರು ಅವರಿಗೆ ಪತ್ರ ಬರ್ಕೊಂಡಿದ್ದಾರೆ.
ಯಾವಾಗ್ಲಿಂದ ಹೇಳ್ತಾ ಇದ್ದೀವಿ, ತೋರ್ಸೋದ್ ಬಿಟ್ಟು ಎಸ್.
This court is familiar with all those judgments, my lord. ಕೋಟಾ ಜಿಲ್ಲೆ ಅದು ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದೀನಿ ನಾನು ಕಾಪಿನ ಮೊದಲೇ. My lord, Industrial Disputes Act so and so. Kindly come to my lord, paragraph 18. So, wherein it was held that inter-alia, that if a person is mainly doing supervisory work and incidentally or for a fraction of time also does some clerical work, it would have to be held that he is employed in a supervisory capacity, and conversely, if the main work is of a clerical nature, the mere fact that some supervisory duties are also carried out incidentally or as a small fraction of work done by him will not convert his employment as a clerk into one supervisory capacity. This court, considering the several cases of employees, including the sales engineering representatives and district sales representatives, held on the material placed before the industrial tribunal that both these classes of employees do not come within the meaning of expressions. Then, my lord, in para 24 also, my lord, referring to the
24 and 26.
26.
My power Mazdoor.
My power is a division bench judgment, my lord, where kindly take, my lord, page 207 anta idrallu right hand column paragraphs alli ಎರಡನೇ ಪೇಜ್ ಅಲ್ಲಿ ರೈಟ್ ಹ್ಯಾಂಡ್ ಕಾಲಮ್, my lord, to the same effect judgment of Supreme Court in so and so. Item number A, B, C, D, E, F, G ಅಂತ notify ಮಾಡಿ. My lord, got it?
Nageshwara BS.
To the same effect, Nageshwara, on the basis of various pronouncements made by the apex court and this court, it can safely be held that making of a reference is obligatory upon the appropriate government where the existence of apprehension of an industrial dispute is prima facie established. Second, in exercise of its power, the appropriate government exercise the administrative function and not a judicial or quasi-judicial function. The appropriate government is not empowered to decide the merits of industrial dispute under the garb of giving reasons for refusal to make a reference. Appropriate government cannot decide the disputed questions of fact. The dispute regarding the existence of a dispute between the employer and the employee and their relationship cannot be adjudicated, as no period of limitation is prescribed for making. My lord may skip that. The question of law sought to be adjudicated cannot be determined by the government under deciding the question of making a reference under section 10 of the act. So therefore, my lord, the categorical distinction made by this court is, if there is a prima facie case made out by the employees or in the dispute which was brought before the conciliation, the government, if prima facie finds that there is an existence of industrial dispute or there is apprehended dispute, it can make a reference. The refusal is an exception to it.
Yes.
In order to show that, my lord, whether he falls under the category of a workman or not, it is a pure question of fact which has to be adjudicated by a competent labor court under the reference. Kindly take, my lord, para 10 of the judgment. Because designation and the salary of a person is not a decisive factor, my lord, he may be a glorified clerk many times.
When we are dealing with orders matters.
So long back, my lord, whether the pilots are coming under the category of in Mathur aviation case.
Come to the point.
the question as to whether particular person was a workman or not is a pure question of fact, which is normally not to be interfered by this court in exercise of its jurisdiction, unless such a finding is shown to be perverse or based on no evidence. The Supreme Court so and so, so and so. Lord, this has to be decided, placing the abundant or the relevant materials before the labor court.
Yes.
To oust, my lord, or non-suit a person who claims to be a workman. So therefore, my lord, the government has rightly put the burden on these persons to show that whether you fall under the category of a workman or not in the wake of their contention raised. No doubt, no documents were placed before the conciliation officer. Of course, therefore, in that background, my lord, it was fastened on us. As a matter of fact, they should have approached to change the points of dispute.
Repetition bad. Yes, Mr. Subramanian, what about the other two termination cases?
My lord, just 5 minutes by way of reply, my lord. My lord, my specific submissions before your lordship is, the government is required to form an opinion after subjective satisfaction that need not be adjudicated by the labor court. It is a settled legal position. And to refer the matter for adjudication, two preconditions are very much required: that government has to form the prima facie opinion as to whether he is a workman or not, and the government has to form the prima facie opinion whether a industry is in existence or not. Of course, it is an industry. I am not disputing that. Here, what my specific cases all are holding managerial posts. They are getting a substantial amount of salary exceeding 1 lakh per month. Be that as it may. Therefore, the settled legal position is government has to form prima facie opinion. I am not saying that the government has to adjudicate. Otherwise, simply referring the matter means that need not be routed through appropriate government. Government has to form prima facie opinion as to whether he is a workman or not, whether the dispute is in existence or apprehended. These preconditions need not be adjudicated. Whether these preconditions have been complied with the appropriate government or not, that is the question for your lordship's consideration. If your lordships is the order of reference, first, government says they have formed the prima facie opinion. Second, if it comes to points of dispute, whether he is a workman or not, I have not formed any opinion. You decide that. Whether that type of reference would stand, my lord, I have already furnished the place 2 judgments on record, judgment of this honorable court only. Government has to form an opinion. That need not be an adjudication. Therefore, this settled legal position need not be adjudicated by the labor court. That is totally abject in this case. Next, the settled legal position in the case of resignation is the moment it is accepted, you stand terminated. I have produced the judgment. Here, resignation is given. I did not accept any resignation immediately. I have relieved them only after 1 month. Even till today, they have not submitted any application for withdrawal of the termination, resignation. That is the only crux of the matter. This is the settled legal position. The moment it is accepted, there are instances, the judgments I have already placed on record, on the very same day resignation has been accepted. Supreme Court said, yes, it is fine. You want to go. What is wrong if the management accept the resignation? I did not do that also. I waited more than 1 month and I have relieved them. And afterwards, they have only filed a declaration form. Kindly, your lordship, in second matter, kindly come to page 32, my lord. Page 32. This is the declaration given by the resigned officer. Illinois. Item number, this is while claiming a provident fund. Item number 8, date of leaving service 4/9/2020. He himself specifically states, it is not his case that I have forced him to resign. Next, my lord. Kindly come to page 33. Declaration. Last. The member declares that he has not been employed for 2 months certified that the particulars are true to the best of my knowledge. In case the amount is used for any other purpose other than stated in column 10, I am liable to return the entire amount with penal interest. This is the declaration given before the statutory authority. This is the declaration given under the format prescribed under the statute.
Yes.
Yes. Next, my lord, I will take your lordship to page 34. Non-employment certificate, self-declaration by the member or claimant. I do hereby solemnly affirm and sincerely state.
You have shown us all this. We have marked everything.
Huh?
ನೀವು ಇವಾಗ ಏನೇನು ಓದ್ತಾ ಇದೀರೋ ಆಲ್ರೆಡಿ ಓದಿದಿರಿ ನೀವು.
ಓದಿದ್ದೀನಿ. ಅವ್ರು ಹೇಳಿದಕ್ಕೆ ಫುಲ್ ಏನೇನೋ ಅಲಿಗೇಷನ್ ಮಾಡಿದ್ರಲ್ಲ ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಅಲ್ಲ, ಮೈ ಸಬ್ಮಿಷನ್ ಇಸ್ if they have not
your reply ಅಲ್ಲಿ you will have to only make your submission on the documents that they have produced. The documents that they have produced along with the memo dated 11/2.
Memo.
Those
memo,
are the additional documents.
My lord, memo. Last page 17 may kindly be perused. The email account that you tried to reach does not exist. Please try double checking the recipient's email address for types or unnecessary spaces. In fact, this has not been received by me. This has not been received by me. But because of subsequent developments, my lord, letter becomes insignificant. Because of the subsequent declaration made and the settlement obtained. This is totally immaterial.
To which email was it? Now, rajshekhar.patanshatti@jsw.in, vinod.novel@jsw.in, sushil.novel@jsw.in, gautamk.pandey@jsw.in, rajesh.nayak@jsw.in, vijay.sinha@jsw.in. ಈ ಜನಕ್ಕೆ ಕಳಿಸಿದ್ದಾರೆ.
Email ಬಂದಿಲ್ಲ. Assuming that it is assuming that I have received, my lord. Because of subsequent declaration, whether this document could be acted upon.
What do you have to say as regards the newspaper article and the
Yes, all
the
these
employees
documents,
forum having made all these allegations against you on 31/8/2020 that you are forcing people to resign?
My lord, your lordship may kindly come to page 14. This is letter dated 31/7/2021 after having taken all settlements.
ಯಾವ 31/7?
Ink page 14, ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಬಳ್ಳಾರಿ ಜಿಲ್ಲೆ. ಇದೆಲ್ಲ ಬೇಕಾಗಿಲ್ಲ, ಅವ್ರು ರೆಸಿಗ್ನೇಷನ್ ವಿತರಣೆ ಮಾಡಿದ್ರೆ ಆಗ್ತಾ ಇತ್ತು.
14 ಹೇಳ್ತಲ್ಲ. Come to the newspaper article at 1/9/2020. 1/1/2020.
31 ಇವರು ಇದರಲ್ಲಿ
1/1/2020.
ಇವರು ಹಾಕಿರೋ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಲ್ಲಿ
page 1. Page 1.
Page 1, my lord.
1/1/2020. Page 2, 31/8/2020.
Yes, my lord, I have referred to the subsequent documents wherein they have declared they have tendered a resignation and this information is correct. If that information is found to be incorrect, I am liable for action under in accordance with law. That is the declaration, subsequent declaration. So in view of that, even first time they have produced
of the document at page 1 and 2 of this memo, why should not we now at the present?
Now they are filing this.
These are all public documents which are available in newspaper at that time, not today. It's not a newspaper publication of today. It's the publication of 1/1/2020 that you are forcing people to resign. Again on 31/8/2020, the employees forum has given a representation that you are forcing people to resign in COVID time. Though there was a instruction to you not to remove anybody from service.
Now, my lord, my submissions to your lordship is first time I am seeing these documents. In any case, my lord, assuming these documents are correct, because of these documents, kindly turn to page 34 in the petition. Page 34. This is the declarations. This is as good as affidavit. I, M.R.E., son of so and so, declare that that I was an employee of JSW, bearing PF account and left the job on 39/2020. He declares.
Yes.
Left the job on 39/2020. And last count. In case my above declaration is found to be false, I undertake to return the pension in full with the interest as declared by EPF organization, and I am liable to pay.
What is the date of this declaration?
This is 24/9/2020, my lord. Next page it is there.
So if it
35.
is- How can he give a declaration 24/9/2020 that he left the job on 30/9/2020?
No, he has given declaration. He has given declaration.
You are the one producing it, Mr. Subramanian.
My lord?
You are the one producing it.
No. It is easy. They are not disputing that. My lord, settlement of account, they are not disputing.
Today, the issue is whether you force them to resign or not, or should we accept that the resignation is voluntary? If on the basis of your submission, we come to a conclusion that it's voluntary and it has not been revoked or resigned it, you are right. But if we are to come to a conclusion today that there is a possibility that you have forced them to resign and their resignation was not voluntary and they had no option on the basis of all these documents.
By virtue of their subsequent declaration, my lord, whether it could be said they have taken all the benefits about 3 years ago.
Subsequent 1/1/2020 is the representation given by the workers that you are trying to force them to resign.
But in the
resignation is dated 28/7/2020 after 6 months.
My lord,
The
they have
representation of the workers union is dated 31/8/2020. All are contemporary.
But they that could be adjudicated again. And moreover, whether he is a workman or not,
that we'll consider. What about this termination matters?
Termination also, my lord, I request your
Termination
lordship.
matters, you can't have any argument. It
My
has
lord?
to go.
Huh?
Termination, it has to go to the ID.
No, my lord, I am only, my lord, I will not argue much on this point. I am only requesting your lordship to take up 101905 of 2022.
905 and 908 are termination.
Of 2022. Kindly see the order of reference made by the government.
Page?
Here also, page 30. In the preamble, my lord.
Yes.
In the preamble, government forms an opinion that dispute is in existence. Kindly come to point 1.
Yes.
Whether he is a workman or not. Yes, it is contrary to the preamble. Which is contrary to that a defect is there, number 1. Number 2, now my lord, I am relying only on one judgment. Well, page 42. Page 42. Page 42 is the Supreme Court judgment in Indian Tea Association. Kindly come to para 9, my lord. Para 9, in page 44. Before making a reference under section 10 of the Act, the appropriate government has to form an opinion whether an employee is a workman, and thereafter has to consider as to whether an interstate dispute exists or is apprehended. In the present case appeal, we find that the state government rightly approached the question whether respondent number 1 was a workman. Unless this condition is satisfied, no reference can be made. From the order of the state government, we find that while deciding the question, whether the respondent number one was a workman, it took into consideration the salary and allowances of respondent number one drawn at the relevant time, and also the nature of work. Respondent number one, who has appeared in person, did not dispute the salary and allowances as indicated in the order of the government, but urged that his responsibilities were neither supervisory nor managerial in nature. Para 13, my lord. Respondent number one has not been able to show that while passing the above administrative order, state government took into consideration any irrelevant or foreign material. We therefore hold that the above administrative order was passed by the state government after taking into consideration material available on record, and it could not be faulted. Here, that's how the state government had to have proceeded with the matter. The state government did not form an opinion. Forming of an opinion is a must. That is lacking in all these cases. Even in the resignation case also. Next, my lord. It is not an adjudication at all.
Yes,
Next. Kindly come to page 39, my lord. This is a Rahman Industries Private Limited case, para 3.
Yes.
Para 3. We find force in the submissions made by the learned counsel in the scheme of the Industrial Disputes Act 1947. It is not as if the government has to act as a post office by referring each and every petition received by them. The government is well within its jurisdiction to see whether there exists a dispute worth referring for adjudication. No doubt, the government is not entitled to enter a finding on the merits of the case and decline reference. The government has to satisfy itself after applying its mind to the relevant factors and satisfy itself to the existence after applying its mind and the relevant factors satisfy itself to the existence of dispute before taking a decision to refer the same for adjudication. Only in case on judicial scrutiny, the court finds that refusal of the government to make a reference of the dispute is unjustified on irrelevant factors, the court may issue a direction to the government to make a reference. Therefore, my respective submissions to your lordship is, these are the only 2 termination cases. The remaining are resignation cases.
Yes.
And also the question is whether the government, without forming an opinion, can refer the matter. In all the 9 cases, my lord, they're all holding managerial post. I had taken up a specific contention that they are not workmen under ID Act. Therefore, you have no jurisdiction to refer the matter for adjudication. That has not been considered at all.
Yes.
I am placing these 2 judgments for all the 9 cases. For all the 9 cases. Resignation is secondary. In the case of resignation, when admittedly they have not withdrawn the resignation, whether they can still maintain that the resignation has been, they're all holding managerial posts. It is not as if they're unskilled workers or semi-skilled workers. And they have given declaration, affidavit before the statutory authority saying that I have tendered resignation. And if my declaration is found to be false, I could be prosecuted. This is the declaration given by the responsible managerial officials. In spite of that, what adjudication is required? They are not disputing the document. They say, yes, we have received the amount, but it is under force. If such contentions were to be taken up at this stage, I cannot accept any resignation. Therefore, I request your lordship to consider all this facts. And in the case of voluntary retirement, also there are few cases where they make allegations like force. Supreme Court held, if you say that management has compelled you to opt for voluntary retirement, first refund the amount with interest. Refund the amount. Then only your application petition will be claimed whether to process it for reference or not. That is the precondition put by the Supreme Court in number of cases. After taking the entire amount, after 2 years, if they raise the dispute, my lord, I cannot settle any matter.
Cases that been held, in which cases the refund with interest been directed as a precondition?
This arising out of, my lord, if the VRS benefits are extended.
Ramesh Shankal,
ಅದು VRS ಸ್ಕೀಮ್ ಅಲ್ಲಿ ಅರೈಸ್ ಆಗುತ್ತೆ. ನಾವೇ ಅದರಲ್ಲಿ ನಾವು ಸಫರರ್ಸ್ ಆಗಿದ್ದೀವಿ. VRS ಕ್ವೆಶ್ಚನ್ ಮಾಡಿದಾಗ.
VRS
VRS ಅಲ್ಲ ಇದು.
VRS refund. VRS addressing.
ನೀವು ಕನ್ಫ್ಯೂಸ್ ಮಾಡಬೇಡಿ ಅಂದೆ. VRS ಅಲ್ಲ ಇದು.
Your lordship is confused. ನಾನು ಮಾಡಕ್ಕೆ ಹೋಗಲ್ಲ ಕೋರ್ಟ್ಗೆ.
ನೀವು ಏನ್ ಮಾತಾಡಿದ್ರು ಮಾತಾಡ್ಕೊಳ್ಳಿ, ನಮ್ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಡೋರ್ಗು ನೋಡಲ್ಲ.
ಇಂಕ್ ಪೇಜ್ 89 ಮೇಲೆ ಇದು ಸೈಟೇಷನ್ಸ್ ಅಲ್ಲಿ.
ಯಾವ್ದ್ರಲ್ಲಿ ಫೈಲ್ ಮಾಡಿರೋದು?
ಇದರಲ್ಲಿ 10114/2022
ಅದ್ರಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ರೆ.
ಲಾಸ್ಟ್ ಟೈಮ್ ಐ ರೆಫರ್ ಟು ದೋಸ್ ಜಡ್ಜ್ಮೆಂಟ್ಸ್. ಅದರಲ್ಲಿ ರೆಫರ್ ಮಾಡಿದೆ. ಅದರಲ್ಲಿ
ನಾಟ್ ಝೋನ್ ಟೆಕ್ನಿಕಲ್ ಇದು ಕೊಟ್ಟಿದ್ರಿ. ಇನ್ ಯಾವ ಜಡ್ಜ್ಮೆಂಟ್?
ಪ್ಯಾರಾ 21 ಮೈ ಲಾರ್ಡ್, ಇಂಕ್ ಪೇಜ್ 95 ನೋಡಿ. ಇದು ತಗೊಳ್ಳಿ, ಕೊಡಿ, ತೋರ್ಸು.
ಇಲ್ಲ
ಮೊನ್ನೆ ನಾ ಕೊಟ್ಟೆ.
ಅದು which judgment you want to refer to? ಯಾವ judgment you want to refer?
ಅದರಲ್ಲಿ ಜಡ್ಜ್ಮೆಂಟ್ ನಾನು ಇದು ಕೊಡ್ತೀನಿ, ರೆಫರ್ ಮಾಡ್ತೀನಿ. ತ್ರಿವೇಣಿ ಲಾಸ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅದು ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ. ಅದರಲ್ಲಿ
ತ್ರಿವೇಣಿ
ಲಾಸ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಮೇಲೆ ಪೇಜ್ ಕೊಡ್ತೀನಿ ನಾನು.
ಪೇಜ್ 95.
Page 95, para 21 my lord. Para 20 ನಾನೇ ಆರ್ಗ್ಯೂ ಮಾಡಿದ ಈ ಕೇಸನ್ನು. Reference is quashed in this case.
Yes. anything else, Mr. Hegde? Astella?
VRS, my
ಅವರು
lord,
ಒಂದು-
refund, my lord, in cases where VRS benefits are opted by the employee. There are certain benefits prescribed apart from terminal benefits, what they are legally entitled to. It was given, extra benefits are given under the VRS scheme. And immediately thereafter, my lord, management floats one more scheme which is attractive. If the employee wants to, my lord, challenge, I have been given the VRS benefit on lesser side, it should have been given in the present scheme. In that scenario, my lord, courts have held, you must refund the amount with entire interest, then only we will consider. It is not that case, my lord, I have not given any pie.
Not in case of resignation, receiving the benefit.
Retirement Allah. If any amount is paid
ರೆಸಿಗ್ನೇಷನ್
under
ಅಮೌಂಟ್
scheme,
ರೆಸಿಗ್ನೇಷನ್ ಗ್ರಾಚ್ಯುಟಿ ತಗೊಂಡಿಲ್ಲ ಅವರು, ಪ್ರಾವಿಡೆಂಟ್ ಫಂಡ್ ತಗೊಂಡಿಲ್ಲ ಎಲ್ಲ ಮೈಲಾಡ್
Third, Sri.
ಗ್ರಾಚ್ಯುಟಿ ಒಂದೇ ಒಂದ್ ಸರ್ ಲಾಸ್ಟ್ ಸಬ್ಮಿಷನ್ ಮೈಲಾಡ್
ಹೇಳ್ಬಿಡಿ.
ಗ್ರಾಚ್ಯುಟಿ ತಗೊಳ್ಳೋದು ಯಾವಾಗ ಸಬ್ಸೆಕ್ಷನ್ 1 ಆಫ್ ಸೆಕ್ಷನ್ 4 ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಕೈಂಡ್ಲಿ ರೆಫರ್ ಟು ಸಬ್ಸೆಕ್ಷನ್ 1 ಆಫ್ ಸೆಕ್ಷನ್ 4 ಪೇಮೆಂಟ್ ಆಫ್ ಗ್ರಾಚ್ಯುಟಿ ಆಕ್ಟ್ ಇಲ್ಲ ಇದನ್ನೇ ಕೊಟ್ಬಿಡ್ತೀವಿ ಸಾಕು. Subsection 1 of section 4.
Yes.
is it 2013 ಅಲ್ಲ ಇದು?
Section 4 of Gratuity Act. Gratuity shall be payable to may I forward this one?
Yes. We got
Gratuity shall be payable to an employee on the termination of his employment after he has rendered continuous service for not less than 5 years on his superannuation or on his retirement or resignation or on his death or disablement due to accident. They have claimed gratuity under subsection 1 of section 4, declaring that they have resigned. Statutory ಇದರಲ್ಲಿ ಇದು ಮಾಡಿ ನನಗೆ ಇದು ತಪ್ಪು ಇದೆ ಅಂತ ಹೇಳಿದ್ರೆ.
Third, Sri Abhishek Patil, Learned Counsel for the petitioner in WP number 106038 of 23, Sri Ravi Hegde, Learned Counsel for the respondents, for the private respondents in all the other matters, as also the reply argument of Sri Subramanya, Learned Counsel for the petitioner, reserved for judgment.
Lord,
Judgment
one
is
more-
out well.
He'll dictate ಮಾಡಕ್ಕಾಗಲ್ಲ.
Lord, one more judgment which I have passed on.
Interim order may kindly be continued.
Interim order earlier granted is extended.
Lord, that is 2003 SEC. My lord, page 588, Narsingh Pal versus, my lord, I have passed on, my lord, I will furnish you a copy of it.
When did you
2003 SEC, page
When did you
588.
pass on?
Lord, I will get the printout and give it, my lord.
You will
Citation I have.
pass on.
I may pass.
I have passed on and.
No, no, I will.
Passed away and.
Para 13, my lord, in a situation where a question arose before the court, an employee was retrenched and he has encashed all the check which was the amount which was payable. Para 13, my lord. The Honorable Apex Court observes merely encashing of the check of his retrenchment compensation. That doesn't mean that he has bartered away his constitutional rights. That's what the observation of the Honorable Apex Court. Notwithstanding, my lord, whether the statutory dues are paid, encashment doesn't debar me from the challenging of their action.
May I clarify, my lord?
Citation 2003.
That was because department inquiry was not held. It was
may-
punitive in
may-
nature, termination of service.
My lord,
The encashment of any benefit which debar the workman from challenging their action. And in case of allegation of forcible resignation.
One of the circumstances, court came to that conclusion mainly on the reason that it's a punitive action taken without holding a department inquiry. The services have been terminated, which could not have
Of
been.
the,
so
yes, yes.
This additional
Exactly
thing
correct.
also was rejected.
Additionally, it was also.
May I clarify, my lord? My lord, there are to come within the definition of workman, my lord. You must fall within the exception.
ಹೇಳಿದ್ದೀರಾ ಎಷ್ಟು
ಇವಾಗ retrenchment, it is on account of the act of the employer. It is by way of punishment. ಅದರಲ್ಲಿ ಸೆಟಲ್ ಪೋರ್ಷನ್ ಇದೆ. ಇದು ರೆಸಿಗ್ನೇಷನ್, ಇದು ವಾಲಂಟರಿ ರೆಸಿಗ್ನೇಷನ್. ಆದರೆ there is no dual relationship at all.
Word you enough in this matter.
Much obliged. Grateful.
So much arguments are not required for this matter. Yes. Next.
12, Suraj Bedaki.
Note.
Hello, I appear for the petitioners.
706 of 2023. Your Lordship.
112. Yes.
My lord, last time I submitted.
Yes,
with
Mr.
reference to my lord, last time, my lord, I submitted with reference to the Baburam case, class para 44, regarding two issues. One is, my lord, the fraudulent applications. That have produced some five petitions, my lord, that I submitted the memo. Next, my lord, the last four sentences of the same judgment, same paragraph, says that, my lord, the compensation need not be given where there are differences in nature, quality, and situation in comparable land. On that, my lord, I would like to, my lord, refer to one judgment, the case of, my lord, because they also, in all the reference cases, LAC, the petitioners, my lord, they didn't have led evidence regard to the land situation, the crops, what they have grown, everything that is on record as exhibits. Whereas in this case, the SLO has gone only on the basis of only ground saying that it belongs to the same notification. That's all, nothing more. So, my lord, they have not, the petitioners have not, the respondents have not proved that similarly situated, similarly placed like the petitioners in the LAC, wherein they are referring to, my lord. This connection I'd like to refer to one Supreme Court judgment, my lord, in 2011 12 SCC.
Yes.
Page 220, 220.
Where is the copy of the judgment?
I'm given to Mr. Veliki. Only one small para I refer to.
Your instructing counsel is not here. Yes, para?
Para 34, my lord.
2011 12 SCC 220 para 34.
Para 34, my lord.
Yes.
It has been further held by the Supreme Court State of JK versus Hindustan Forest Company, wherein it was held that the onus is on the plaintiff to positively establish its case on the basis of material available, and it cannot rely on the weakness or absence of defense to discharge the onus.
Yes.
In this case, Lordship was pleased to ask me a question saying that you have not proved, they have not proved. My humble submission is positively they have to prove. Burden cannot be shifted on me. That's one humble submission. And my lord, in regard to the submission, my lord, the SLO has referred to, my lord, Mr. Veliki have submitted.
Yes, Korea. Judgment code 2011 12 SCC 220. Which other judgment you want to refer to, Mr. Ravi? Same judgment.
Same judgment.
2011 12 SCC 220.
Communication, I don't have. I'll get
The Tandil Yes, anything else?
My lord, in this connection, my lord, for the Lordship's convenience, I have also, my lord, referred to one argument merits of the case, where I have referred in each petition, which is the para numbers and page numbers I have referred to, my lord. for it, Lordship is convenience, on same point. You know, Mr. Balaki must be. Page number 2, Lordship may take.
Yes.
Case number 1000706/2023. Then I refer to SLA award SLA reference page number. Lordship's immediate reference are given on the same point. I don't want to take your Lordship's time on this.
Yes.
And all the petitions have given this paginations.
So everything is dry land.
Yes, madam. And it is so said so in the LAC order, bore is there, irrigation is going on, but here dry land.
Dry land and no bore wells.
Yes, madam.
Yes, you want to refer to 2011-12 SCC, another para for what purpose?
Same 34.
Only para 34.
34. It starts from the paragraph.
We'll see that, para 34. Anything else?
That's it.
Yes, Mr. Patil.
Lord, may I request you, Lordship, kindly take writ petition number 1000706 of 2023.
Mic on ಮಾಡ್ಕೊಳ್ಳಿ. Speak in the mic so that. Yes, 706.
1000706 of 2023. Lord, may I request you, Lordship, kindly page, Lord, 19 of the writ petition. Page 19. My lord will kindly get it, note 26 acres, 05 guntas.
Yes.
Of my lord, Mavinatop village, my lord, was acquired for the purpose of my lord, irrigation project by invoking urgency clause.
Yes.
Lord, that is also, my lord, pleaded in the writ petition. Your lordship should kindly, my lord, page 5, para 5 of the writ petition, your lordship should kindly.
Yes.
In so far as the village is situated in and around Mavinatop village, Hirikeru Taluk, Haveri district, the state government issued a preliminary notification under section 4(1), read with section 17(4) of the Land Acquisition Act, invoking the urgency clause stated dated 2011-2002, which was gazetted on 2/1/23, seeking to acquire large tracts of agricultural lands of about 19 acres, 14 guntas, including the scheduled property. Lord, this is what they have stated. Lord, thereafter, your lordships will kindly, after invoking the urgency clause, my lord will kindly, my lord, get it annexure B, the award.
Page.
Page, my lord, 13, my lord. It is dated, note 22/6/2005. Down below, your lordships will kindly get in the same page.
Yes.
ಆದೇಶ, your lordships will kindly. ವಿಶೇಷ ಭೂ ಸ್ವಾಧೀನ ಅಧಿಕಾರಿಗಳು ತುಂಗಾ ಮೇಲ್ಗಂಡೆ ಯೋಜನೆ ರಾಣೆಬೆನ್ನೂರು ಇವರು ಸಲ್ಲಿಸಿದ ಕರಡು ಐತೀರ್ಪು ಮೊತ್ತ 14,34,164 ರೂಪಾಯಿ ಮಾತ್ರ ಭೂಸ್ವಾಮ್ಯಕ್ಕೆ ಒಳಪಟ್ಟ ಜಮೀನುಗಳ ಮೌಲ್ಯವನ್ನು ಪ್ರತಿ ಎಕರೆಗೆ 35,000 ರೂಪಾಯಿ ಖುಷ್ಕಿ ಮತ್ತು ರೂಪಾಯಿ 52,500 ರೂಪಾಯಿ ರಂತೆ ನಿರ್ಧರಿಸಿದ್ದನ್ನು ಶೇಕಡಾ 30ರಷ್ಟು ಪರಿಹಾರ ಧನ ಸೇರಿ ವಾಡಿಕೆಯ ಪ್ರಕಾರ ಎಲ್ಲ ಕರಾರುಗಳನ್ನು ಅನುಷ್ಠಾನಗೊಳಿಸುವ ಹಾಗೂ ಚಿಕ್ಕ ಪುಟ್ಟ ಲೋಪದೋಷಗಳೇನಾದರೂ ಇದ್ದಲ್ಲಿ ಅವುಗಳನ್ನು ಅನುವರ್ತಿಸುವ ಹಾಗೂ ಈ ಕೆಳಗೆ ನಮೂದಿಸಿದ ಕರಾರುಗಳನ್ನು ಅನುವರ್ತಿಸುವ ಷರತ್ತಿಗೆ ಒಳಪಟ್ಟು ಕರಡು ಆಯ್ಕೆಗೆ ಮಂಜೂರು ನೀಡಲಾಗಿದೆ. The award was approved. And also, my lord, it was sent to the Deputy Commissioner for approval. Lord, thereafter, your lordship kindly.
Sriram.
Page, note, annexure C, page 55.
Computer Page?
Page 55, annexure C, my lord. Out of these persons, my lord, the land losers, Lord, LAC, Lord, 183 of 2007, connected with LAC 184 of 2007 and 333 of 2008 came to be filed, Lord, before the principal civil judge, Lord Hirekerur. And exercise page 55, Your Lord.
Yes.
Yes. My Lord will kindly, Lord, after referring, Lord, next page, Lord, page 57. Lord, the lands, Lord, that is 183. Your Lordship will kindly get it in page 3. 183, LAC number, Lord, land survey number 58/1B plus 45, 58/1 plus 1B, 45 PK, 75/2A, 75/1D. Lord, in respect of these lands, Lord, the reference court, Lord, formulated the points, Lord, at page 58.
Yes.
It formulated the points, Lord, at page 58. Whether all the petitions are in time, whether the compensation grant, my Lord, page 58, Your Lord.
Yes, yes, we got it. Sorry. 58/1B. Yes. Yes.
My Lord will, page 58, Your Lordship will kindly. Points for consideration down below. Whether all the petitions are in time, whether compensation granted by the respondents is adequate and legal. Lord, what order or award? My Lord will kindly, page, Lord, 62.
Yes.
Order. Petitions filed under section 18 of the Land Acquisition Act are hereby allowed in part with cost. Market value of the property involved in LAC 183 and 184 of 2007 and 335 of 2008 is fixed at rupees 2,40,000 per acre. Petitioners are entitled to all statutory benefits as per the Land Acquisition Act and also as per the decision reported in 2001 SAR Civil SC page 799 Sundar versus Union of India.
That they refer to LAC 60 of 06.
Please, please.
And 63 of 06. Where is that order?
Yes. Referred and Lord, entire compensation was paid.
Where is that order of LAC 60?
LAC.
How is that applicable to this?
Huh?
Exhibit P7 LAC 60 ಅಂತ ರೆಫರ್ ಮಾಡ್ತಾರೆ.
ಅದೇ. One nimisha.
This they say is dry land
Yes.
at page 61, para 1.
My lord will kindly, my lord, 183, 184 and 335, my lord, page 57, your lordship got it.
Hmm?
Lord, in all these,
ಇಲ್ಲಿ ಅಲ್ಲಿ ರೆಫರೆನ್ಸ್ ಅಲ್ಲಿ ಒಂದು ಎಕ್ಸಿಬಿಟ್ LAC 60 2006 judgment where is that number regarding nature of lands
yeah, my lord will kindly discussion page 61, my lord, your lordship.
Yes.
The para, my lord, your lordship, kindly as per the award which is with respect to the properties involved in this petition, it is clear that the properties, though they are dry lands and they were irrigated, and the property involved in LAC 183 and 184 of 2007 is the irrigated lands with the help of borewell, and property involved in LAC 335 of 2008 is irrigated through the tank situated nearby the land. Hence, these properties should be considered as a irrigated lands. The petitioners have produced the CC of the award passed by this court in LAC 60 of 2006 and other clubbed cases which are marked as per Exhibit P7, which are with respect to the lands pertaining to the Aladakatti village of Hirekeru Taluk. The said documents marked by consent in the present case. The properties involved in those petitions are also acquired for Upper Tunga project. The court, while fixing the market value, has taken into consideration the cotton crop was grown in the said lands and the compensation was fixed on the capitalization method. The respondents have not contended that any appeal is filed against the award relied on by the claimants. No documents were produced by the respondents in that regard. It is also pertinent to note those documents are marked by consent in the present petition. Hence, in view of the decision reported in ILR 2004, Karnataka, page 2371, SLO versus Fakirappa.
What is the award in LAC number 60 or 06, Mr. Patel?
My lord, this LAC 60, my lord, that has been marked as Exhibit P7.
P7 Kodi.
P7.
Idya ನಿಮ್ಮ ಹತ್ರ ಕಾಪಿ ಇದೆಯಾ?
ಇಲ್ಲ ಸರ್, ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
You'll have to show us that copy.
But in fact, it is
based on 183 as it is based on something else.
Please.
So we'll have to look into that. ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ?
LAC 60 ಇದು
ನಿಮ್ಮ ಹತ್ರನೂ ಇಲ್ಲ. ಯಾಕೆ?
Records, my lord.
Award copy ilwa? You made a detailed comparison between that. Yes, Mr. Ravi, where is the award in LAC 60? You made a comparison. So you must be having an award copy to do the comparison.
I compared between 183 and 60, I'm not.
Yes. Yes, go ahead, please.
My lord, your lordship. The respondents have not brought on record any evidence to show that, my lord, I am reading, my lord, page 62. Evidence to show that the lands involved in the present petitions are in any way differs from the lands involved in the award relied on by the claimants. Apart from this, the AGP has also submitted on inquiry that no appeal is pending against the said award. In
So
the
they
present
wanted a
petitions,
negative fact to be proved.
Please.
Negative fact to be proved. Respondent to show that it's different.
Apart from this, the
Is it
AGP
not
has
on the-
also submitted.
Is it not the burden on the claimant to prove that it is the same?
Of course.
ಇದು ಉಲ್ಟಾ ಹೆಂಗ್ ಆಗ್ತಾರೆ?
ಅಲ್ಲ, ಇದ್ರೊಳಗೆ just I will read this portion. Apart from this, the AGP also submitted on inquiry that no appeal is pending against the said award. In the present petitions, except the land involved in LAC 60 of 06 and in other cases, the lands are dry lands. Hence, I am of the view that the market value of the properties involved in these petitions are also have to be valued at rupees 2,40,000 per acre in acre is the just and reasonable compensation. Hence, I answer point number 2 in negative. In view of the above discussion made above, In view of the discussions made above, I proceed to pass the following order. Petitions filed under Section 18 of the Land Acquisition Act are hereby allowed in part with the cost. Market value of the properties involved in LAC 183 and 184 of 2007 and 335 of 2008 is fixed at rupees 2,40,000 per acre. Petitions are entitled to all statutory benefits as per the Land Acquisition Act and also as per the decision reported in 2001 SAR Civil SC page 719 Sundar versus Union of India. Lord, draw the decree accordingly. Lord, this order was passed. Lord,
This
kindly,
order
Lord,
on the face of it is bad. One he says it is dry land. That land was irrigated land with borewell. But he considers it to be the same. The burden of proof is shifted to the authority and not the claimant.
my Lord, what I respectfully submit for your lordship and consideration is this. Here, my Lord, your lordship should kindly that they have referred all these documents. So far as, my Lord, this LAC 183 of 07 connected to 184 and 185 of 2018. My Lord, this award, my Lord, was satisfied by the authorities. They have satisfied the award and they have made a my Lord, a payment of compensation. My Lord, immediately thereafter, your lordship should kindly.
Yes.
Page 65, my Lord. LAC 183 of 2007. Page 66, your lordship should kindly.
Yes.
Petition filed under Section 18 of the Land Acquisition Act is hereby allowed in part with cost. Market value of the property is fixed at rupees 2,40,000 per acre. Petitioners are entitled to all statutory benefits as per the Land Acquisition Act and also as per the decision reported in 2001 SAR Civil SC page 799 Sundar versus Union of India. My Lord, this was the order passed by the civil judge. Lord, pursuant to that, Lord, your lordship should kindly, Lord, the entire amount was, Lord, paid to the claimants.
Where is the document to show that it's been paid?
Please. My Lord will continue, my Lord. Exhibit P1, page, my Lord, 63.
63 is the order.
63, down below, my Lord, your lordship.
Award accordingly.
Ado.
Payment agide anta ellide.
Payment was done, my Lord, your lordship should kindly, my Lord, that I will point out. Payment was done.
Repeated thrice payment has been done without demur, without challenge. Where is the document? These are all big statements, not a off-the-cuff statement. So when you make that statement, you need to be able to substantiate it.
My Lord, from the petition itself, I will point out. Lord, according to my instruction, Lord, the payment was done, my Lord. I will, my Lord, come to, my Lord.
Until you produce the document, we won't accept it. Next.
Please. This payment was done. Lord, thereafter, your lordship should kindly. My Lord will kindly Page 69, my lord.
Yes.
Page 69. Before the Deputy Commissioner and Land Acquisition Officer, Haveri District, Haveri, my lord, Annexure D. My lord, the respondent herein, my lord, the Basappa, my lord, files an application under section 28A of the Land Acquisition Act, my lord. Lord, in para 4, my lord, as per the request of the landowners, the matter have been referred to the Principal Civil Judge Senior Division Court, Ranebenur, and the same was registered as a LAC 183/2007, connected with 184 of 2007 and 335 of 2008. Thereafter, the said cases are decided by the Eternate Court at Hirekeru after considering the matter and award of rupees 2,40,000 rupees per acre compensation for the acquired irrigated lands on 9/7/2010, and also petitioners are entitled to all statutory benefits as per the Land Acquisition Act, and also as per the decision reported in AIR 2001 SAR civil cases Sundar versus so and so, 30% solicium, 12% additional market value, and 15% interest. The judgment and decree passed in LAC number 183 of 2007, connected with 184 of 2007 and 335 of 2008 on 9/7/2010. The certified copy of the same is produced along with the application. The applicant is entitled to same award under section 28A of the Land Acquisition Act, and also this application may kindly be predetermined. The applicant is filed an application well within time. Hence, it is most humbly prayed that the compensation at the rate of rupees 2,40,000 rupees per acre, along with the statutory benefits as per the Land Acquisition Act, and also as per the decision reported in AIR 2001 SAR civil cases so and so, that is 30% solicium, 12% additional market value, and 15% may kindly be awarded for the acquired land RS number 75/2A, an extent of 2 acres 4 guntas, and 75/2C 8 guntas of Mamintop village in Hirekeru. Otherwise, this applicant will be put to irreparable loss and injury. Hence, this application. My lord, this application was made, my lord, on 29/2010. My lord, within my lord, a period of, my lord, of 45 days, my lord, this application was made. My lord, thereafter, your lordships will kindly. Annexure E, page 71, my lord. This is from the office of my lord, Special Deputy Commissioner, Special Deputy Commissioner Office. My lord, here, my lord, your lordships will kindly. Page 78, my lord, your lordships will kindly. Sorry, before that, my lord. Page 76, my lord.
Yes.
Para 5, my lord. ಅರ್ಜಿದಾರರು ಕಲಂ 28 ಇದರ ಅರ್ಜಿಯನ್ನು ಮೊದಲ ಸಾರಿ ಸಲ್ಲಿಸಿರುವ ಹೇಗೆ? ಈ ಪ್ರಕರಣದ ಮನವಿದಾರರು ಕಲಂ 28A ದಲ್ಲಿ ಪ್ರಥಮ ಬಾರಿಗೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು ಇರುತ್ತದೆ. ಮನವಿದಾರರು ಈ ಕಾರ್ಯಾಲಯಕ್ಕೆ ನ್ಯಾಯವಾದಿಗಳಾದ ಶ್ರೀ BC ಪಾಟೀಲ್ ಇವರ ಮುಖಾಂತರ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದಾರೆ. ಅರ್ಜಿಯ ವಿಚಾರಣೆ ಮುದ್ದತ್ತು 24/9/2013, 30/9/2013, 7/1/2016, 21/1/2016, 4/11/2017, 15/11/2017 ನೇಮಿಸಲಾಯಿತು. ಎಲ್ಲ ಷರತ್ತುಗಳ ಪ್ರಕಾರ ಹಿರೇಕೆರೂರು ದಿವಾಣಿ ನ್ಯಾಯಾಲಯದ ತೀರ್ಪಿನ ಪ್ರಕಾರ ಹೆಚ್ಚುವರಿ ಪರಿಹಾರಧನ ಪಡೆಯಲು ಮನವಿದಾರರು ಅರ್ಹತೆ ಹೊಂದಿದ್ದು, ಪ್ರತಿ ಎಕರೆಗೆ 1,87,500 ರಂತೆ ಪುನಃ ನಿಗದಿಪಡಿಸಿ ತಿದ್ದುಪಡಿ ಕಾಯ್ದೆ 1984 ಪ್ರಕಾರ ಎಲ್ಲ ಸೌಲಭ್ಯಗಳನ್ನು ಸಂದಾಯ ಮಾಡಲು ವಾದ ಮಂಡಿಸಿರುತ್ತಾರೆ. ಆಧರಿಸಿದ ತೀರ್ಪು your lordship kindly they relied on this LAC number 183, 184 and 335 your lordship. Thereafter your lordship kindly ಈ ಮೇರೆಗೆ ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ಹೆಚ್ಚಿದ ಪರವಾನವನ್ನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಜಮಾ ಮಾಡಲು ಮುಖ್ಯ ಆಡಳಿತ ಅಧಿಕಾರಿಗಳು ಕರ್ನಾಟಕ ನೀರಾವರಿ ನಿಗಮ ನೇಮಿತರು ಸದರಿ LAC ನ್ಯಾಯಾಲಯ ನಿಗದಿಪಡಿಸಿರುವ ಪರಿಹಾರದ ಮೇಲೆ ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸಬಾರದು ಎಂದು ತಮ್ಮ ಪತ್ರ ನಂಬರ್ ದಿನಾಂಕ 8/7/2000 ಪೂರ್ಣ ಪ್ರಮಾಣದ ಹಣ ಬಿಡುಗಡೆಗೊಳಿಸಿ ಸದರಿ ಪ್ರಕರಣವನ್ನು ಸಂಪೂರ್ಣ ಮುಕ್ತಾಯಗೊಳಿಸಲು ಕ್ರಮ ಕೈಗೊಳ್ಳುವಂತೆ ನಿರ್ದೇಶನ ನೀಡಿದ್ದಾರೆ. ಹಕ್ಕು ದಾಖಲೆ ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಿಸಿ ಈ ಹಿಂದೆ ಈ ಜಮೀನಿಗೆ ಸಂಬಂಧಿಸಿದ ಪರಿಹಾರಧನ ಪಡೆದುಕೊಂಡಿದ್ದಾರೆ. ವಿವರ ಈ ಕೆಳಗಿನಂತೆ ಇದೆ. ರೀಸನ್ ನಂಬರ್ 75/2, ರೀಸನ್ ನಂಬರ್ 75/2 5 ಎಕರೆ ಭೂ ಸ್ವಾಧೀನವಾದ ಕ್ಷೇತ್ರ, ಟೋಟಲ್ ಮಲೋಡ್ ಒಟ್ಟು 2 ಎಕರೆ 12 ಗುಂಟೆ. ಈ ತೀರ್ಪು ಪ್ರಕಾರ ಪರಿಹಾರ ಪಡೆದುಕೊಂಡವರು ಪ್ರಕರಣಕ್ಕೆ ಮಾವಿನತೋಪ ರೀಸನ್ ನಂಬರ್ 75/2 ಗುಂಟೆ ಕ್ಷೇತ್ರಕ್ಕೆ ಒಟ್ಟು 2 ಕ್ಷೇತ್ರಕ್ಕೆ ಪರಿಹಾರವನ್ನು ಶ್ರೀ ಬಸಪ್ಪ ಹನುಮಂತಪ್ಪ ಬನ್ನಿಕೋಡ್ ಇವರು ಪಡೆದುಕೊಂಡಿರುತ್ತಾರೆ. Thereafter your lordship will kindly ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾಮಲ್ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಹಾವೇರಿ ಇವರಿಂದ ಹಿಂದಿರುಗಿಸಿದ ಪ್ರಕರಣಗಳ ತೀರ್ಪು ಅನುಮೋದನೆಗೆ ದಿನಾಂಕ 29/8/2001 ಮಾನ್ಯ ವಿಶೇಷ ಜಿಲ್ಲಾ ನ್ಯಾಯಾಧಿಕಾರಿಗಳು ಭೂ ಸ್ವಾಧೀನ ಪುನರ್ವಸತಿ ಮತ್ತು ಪುನರ್ನಿರ್ಮಾಣ ಬೃಹತ್ ನೀರಾವರಿ ಯೋಜನೆಗಳು ಬೆಳಗಾವಿ ಇವರಿಗೆ ಸಲ್ಲಿಸಲಾಯಿತು. ಮಾನ್ಯ ವಿಶೇಷ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಬೆಳಗಾವಿ ಇವರು ಉಲ್ಲೇಖಿತ 8 ಪತ್ರದಡಿ 1 ಮತ್ತು 2ನೇ ಸೂಚಿತ ಪ್ರಕಾರ ಪ್ರಕರಣದ ನ್ಯೂನತೆಗಳನ್ನು ಸರಿಪಡಿಸಿ ಕೂಡಲೇ ಪ್ರಕರಣ ಸಲ್ಲಿಸಲು ಸೂಚಿಸಿರುತ್ತಾರೆ. ಮೇಲ್ಕಂಡ ವಿವರಿಸಿದ ಸಂಗತಿಗಳನ್ನು ಕಡು ತೀರ್ಪಿನಲ್ಲಿ ಚರ್ಚಿಸಿ ಈಗಾಗಲೇ ರಚಿಸಿದ ಮೂಲ ತೀರ್ಪನ್ನು ಆಧಾರವಾಗಿಟ್ಟುಕೊಂಡು ಖಂಡಿಕೆ 1ರಲ್ಲಿ ವಿವರಿಸಿದಂತೆ ಒಂದೇ ತೀರ್ಪು ರಚಿಸಲು ತೀರ್ಮಾನಿಸಲಾಯಿತು. Thereafter your lordship will kindly ಉದ್ದೇಶಿತ ಜಮೀನು ಡೌನ್ ಬಿಲೋ ಉದ್ದೇಶಿತ ಜಮೀನು ಕೆರೆಯಿಂದ ನೀರಾವರಿ ಸೌಲಭ್ಯ ಹೊಂದಿದೆ. ಕೋರ್ಟ್ ಆದೇಶದಿಂದ ನೀಡಿದ ಜಮೀನು 28A ಅರ್ಜಿದಾರರ ಜಮೀನು ಒಂದೇ ಗುಣಮಟ್ಟ ಹೊಂದಿದೆ. ಮೇಲ್ಕಂಡ ಸಂಗತಿಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿದೆ. your lordship will kindly ಡೌನ್ ಬಿಲೋ your lordship will kindly ವಿಶೇಷ ಭೂ ಸ್ವಾಧೀನಾಧಿಕಾರಿಗಳು ತುಂಗಭದ್ರಾ ಮೇಲ್ಕಂಡ ಯೋಜನೆ ರಾಣೆಬೆನ್ನೂರು.
ಅಷ್ಟೇ ಒಂದು ಲೈನ್.
Yes.
That is the only line.
That is the only line.
In all the things that you read, that is the only line.
Yes. Then my lord your lordship will kindly ಆದೇಶ
ಮತ್ತೆ ಅದೇ ಸೇಮ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಎಲ್ಲ
ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿಕೊಂಡು totally they are entitled to my lord your lordship will kindly.
So only reason is at page 77 last line.
Yes.
Yes.
That's also quashed.
That's also
quashed.
Kindly my lord.
That order
Has been quashed, my lord.
Which order has been quashed?
This whatever Mr. Patil referred to has been quashed at page 81. Lordship will get it.
This order has been quashed by way of merit petition before this honorable.
I will come to that. I will come to
No,
that.
then let him. Yes.
Lord, kindly my lord annexure F may kindly be.
Yes.
Lord, these orders were challenged by the Niravari Nigam, Karnataka Niravari Nigam Limited. My lord will kindly, my lord, totally, my lord, in all, nine writ petitions came to file. My lord. 9 writ petitions. My lord, your lordship, so kindly get to page 96. Writ petition numbers, internal page 96.
Yes.
My lord, admitted facts, my lord, your lordship, thereafter, the land loser respondents have submitted their applications for redetermination of compensation under section 28A of the Land Acquisition Act in terms of the details as found in the tabulation supra. My lord, then my lord, your lordship, next page, page 99. Para 6, questions canvassed, your lordship.
Yes.
Sri D.N. Nanjunda Reddy and so-and-so, learned counsel supporting so-and-so, submit the following 2 questions must be considered. My lord, this is the first question that was formulated by the court. And the second question, my lord, also, B was also formulated. Thereafter, my lord, your lordship, so kindly, page 113, operative portion of the order. Relevant page 114, my lord. The impugned endorsement, impugned annexure E and E1 dated 20/2/2020 and 13/2/2020 in each of these petitions stand passed and the proceedings restored to the Special Land Acquisition Officer for reconsideration. The petitioner and the landowners respondent shall appear before the Special Land Acquisition Officer without further notice on 21/3/2022, and the Special Land Acquisition Officer shall complete the proceedings expeditiously within the outer limit of 4 months from 21/3/2022. It is needless to observe that the petitioners and the landowners respondents shall cooperate with and assist the Special Land Acquisition Officer in expeditious disposal of the proceedings. My lord, this was done. Thereafter, note, without any loss of time, my client, my lord, filed annexure G. Written submissions. My lord, the relevant page 118. ಸದರ್ ಈ ಅರ್ಜಿಯಲ್ಲಿ ಕಾಣಿಸಿದ ಭೂಮಿಯು ಭೂ ಸ್ವಾಧೀನವು ಈಗಾಗಲೇ ಭೂ ಸ್ವಾಧೀನ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದ ಐತೀರ್ಪು ಪಡೆದುಕೊಂಡಿರುವ ಭೂಮಿಗಳು ಒಂದೇ ಉದ್ದೇಶಕ್ಕೆ ಮತ್ತು ಒಂದೇ ಪ್ರಾಥಮಿಕ ಅಧಿಸೂಚನೆ ಅಡಿಯಲ್ಲಿ ಅಂದರೆ ಕಲಂ 4(1) ಇರಬೇಕು. ಸದರಿ ಐತೀರ್ಪು ರಾಜಿ ಸಂಧಾನದ ಮೂಲಕ ಇತ್ಯರ್ಥ ಆಗಿರುವ ಪ್ರಕರಣಗಳನ್ನು ಪರಿಗಣಿಸಲು ಅವಕಾಶ ಇರುವುದಿಲ್ಲ. ಆದರೆ ಸಾಕ್ಷಿಗಳ ಮುಖಾಂತರ ಇತ್ಯರ್ಥವಾಗಿ ತೀರ್ಪು ನೀಡುವ ಪ್ರಕರಣದಲ್ಲಿ ಜಜ್ಮೆಂಟ್ ವ ಡಿಕ್ರಿ ಪ್ರತಿಗಳನ್ನು ಮಾತ್ರ 28A ಪ್ರಕರಣದಲ್ಲಿ ಪರಿಗಣಿಸತಕ್ಕದ್ದು. ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದ ತೀರ್ಪು ನೀಡಿದ 90 ದಿನಗಳ ಒಳಗಡೆ ಅದರಲ್ಲಿ ನ್ಯಾಯಾಲಯದಿಂದ ಅಧಿಕೃತ ಅವಾರ್ಡ್ ದೃಢೀಕೃತ ನಕಲುಗಳನ್ನು ಪಡೆದುಕೊಳ್ಳುವ ಆಗುವ ದಿನಗಳನ್ನು ಹೊರತುಪಡಿಸಿ ಸದರಿ ಅರ್ಜಿ ಸಲ್ಲಿಸತಕ್ಕದ್ದು. 28A ಅಡಿಯಲ್ಲಿ ದಾಖಲಿಸಿರುವ ಪ್ರಕರಣ 1 ವರ್ಷದ ಒಳಗೆ ವಿಶೇಷ ಭೂ ಸ್ವಾಧೀನ ಅಧಿಕಾರಿಗಳು ಇತ್ಯರ್ಥಗೊಳಿಸತಕ್ಕದ್ದು. Lord, this is also directions, and thereafter, Lord, your lordship should kindly that the written submission, Lord, we made that is go to know were eligible for the compensation, Lord, in view of the submissions, and the settlements, Lord, were referred. Lord, thereafter, your lordship should kindly annexure H, Lord.
Yes.
Annexure H. Page, Lord, 120. ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಧಾರವಾಡ ಪೀಠ WP ನಂಬರ್ 103903 of 21 ದಿನಾಂಕ 2/1/22 ಆದೇಶ ಪ್ರಕಾರ 28ನೇ ಅರ್ಜಿಯ ಮರುಪರಿಶೀಲಿಸಿ ಮರು ತೀರ್ಮಾನಿಸಲು ನೀಡಿದ ಬಗ್ಗೆ ಹಾವೇರಿ ತಾಲೂಕು ಬಾವಿನಕೊಪ್ಪ, Lord, they refers to the land. Lord, thereafter, Lord, all these writ petitions were referred. Lord, your lordship should kindly ಪ್ರಸ್ತಾವನೆ. Lord, then, Lord, your lordship should kindly ಆಕ್ಷೇಪಣೆ ವಿವರಣೆ your lordship should kindly English portion your lordship should kindly
ನಿಮ್ದು ಯಾವ್ದು ಆಕ್ಷೇಪಣೆ, which is your matter?
My lord, just. Lord, next ನೋಡಿ, ಆಕ್ಷೇಪಣೆಗೆ 2ಕ್ಕೆ ವಿವರಣೆ ಮಾಡಲು ಈ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ 28A ಅರ್ಜಿ ಕಾಲಮಿತಿಯಲ್ಲಿ ಅರ್ಜಿದಾರರು ಸಲ್ಲಿಸಿದ ವಿವರ ಈ ಕೆಳಗಿನಂತಿದೆ. ಮಾನ್ಯ ಸೀನಿಯರ್ ಸಿವಿಲ್ ಜಡ್ಜ್ ಮತ್ತು JMFC ಹಿರೇಕೆರೂರು LAC ನಂಬರ್ 183/07, LAC ನಂಬರ್ 184/07, 335/08 ದಿನಾಂಕ 9/7/2010, 9/7/2010. 28ನೇ ಅರ್ಜಿಯನ್ನು ಕಾರ್ಯಕ್ಕೆ ಸಲ್ಲಿಸಿದ ದಿನಾಂಕ 28/9/2010. ನ್ಯಾಯಾಲಯದಿಂದ ದೃಢೀಕೃತ ನಕಲನ್ನು ತೆಗೆದುಕೊಂಡ ದಿನಗಳು ಒಟ್ಟು 74, 28 ದಿವಸ. ನಿಕ್ಕಿ ದಿನಗಳು 46 days. ಇದನ್ನು 46 days ಲಾಟ್ ಇದು ಮೇಲ್ಕಂಡ ಪ್ರಕರಣಕ್ಕೆ ಪರಿಶೀಲಿಸಾಗಿ 28A ಅರ್ಜಿಯನ್ನು 90 ದಿನಗಳಲ್ಲಿ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಆಕ್ಷೇಪಣೆ 3ರ ವಿವರಣೆ 28A ಅರ್ಜಿದಾರರ ವಿವರ. 28A ಅರ್ಜಿದಾರರು ಈ ಹಿಂದೆ ಈ ಕಾರ್ಯಾಲಯದಲ್ಲಿ ಜನರಲ್ ಅವಾರ್ಡ್ ಪ್ರಕಾರ ಪರಿಹಾರ ಪಡೆದುಕೊಂಡವರೇ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದಾರೆ. ಅವರಲ್ಲಿ ಯಾರಾದರೂ ಕೋತಿ ಆದಲ್ಲಿ ಕೋತಿ ವಾಸಾದಾರರು ಮಾಹಿತಿ ಪಡೆದು 28A ಅರ್ಜಿಯನ್ನು ಸೇರ್ಪಡೆ ಮಾಡಿಕೊಳ್ಳಲಾಗಿದೆ. ಈ ಕೆಳಗೆ ಈ ಹಿಂದೆ ಪರಿಹಾರ ಕಂಡ ಮಾಹಿತಿ ಪ್ರಕರಣದಲ್ಲಿ ಲೆಕ್ಕಿಸಿಕೊಂಡಿದೆ ಹಾಗೂ ಜಮೀನಿನ ಹಕ್ಕಿನ ಬಗ್ಗೆ ದಾಖಲಾತಿ ಹಾಜರುಪಡಿಸಿದ್ದಾರೆ. ಆಕ್ಷೇಪಣೆ 4, ಖುಷ್ಕಿ ಮತ್ತು ನೀರಾವರಿ ಜಮೀನು ಕುರಿತು ಪ್ರಕರಣ ಸಂಬಂಧಿಸಿದಂತೆ ಮಾನ್ಯ ಹಿರಿಯ ದಿವಾಣಿ ನ್ಯಾಯಾಧೀಶರು JMFC ಅವರ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಹಿರೇಕೆರೂರು ಆದೇಶದಲ್ಲಿ ಈ ಕೆಳಗಿನಂತೆ ಆದೇಶ ನೀಡಿರುತ್ತಾರೆ. ದಿ ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ಆಫ್ ದಿ acquired number 183/07 connected with LAC 184/07, 335 of 2008, dated 9/7/2010. The 2 lakhs.
Same ಓದ್ತಾನೆ ಇದೀರಾ ಆಗ್ಲಿಲ್ಲ. Come to your submissions.
Just below. Thereafter, your lordship will kindly the ಮಾರುಕಟ್ಟೆ ಬೆಲೆಯನ್ನು 2,40,000 ರೂಪಾಯಿಗಳೇ ಫಿಕ್ಸ್ ಮಾಡಿದೆ ಅಂತ ಆಯ್ತು.
ಅದೇ ಅದರಲ್ಲಿ ಮಾಡಿ 2,40,000 ಇದು ಅಷ್ಟೇ.
While doing so, my lord, the authorities have taken into account, my lord, all the requisites, my lord, for my lord, granting a compensation.
ಏನ್ ತಗೊಂಡಿದ್ದಾರೆ ತೋರಿಸಿ.
My lord, page 128.
Yes.
ಪರಿಗಣಿಸಬೇಕಾದ ವಿಷಯ your lordship. 28A ಸಲ್ಲಿಸಿದ ಅರ್ಜಿಯನ್ನು ಪರಿಗಣಿಸಿದ ವಿಷಯಗಳು. ಅರ್ಜಿದಾರರು ಜಮೀನಿನ ಹೆಚ್ಚಿನ ಪರಿಹಾರಕ್ಕಾಗಿ ಭೂ ಶೋಧನೆ ಕಾಯ್ದೆ 18ರ ಪ್ರಕಾರ ದಿವಾಣಿ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ನಿವೇದನಾ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿ ಪರಿಹಾರ ಪಡೆದ ಜಮೀನುಗಳು ಒಂದೇ ಅಧಿಸೂಚನೆಯಲ್ಲಿ ಇರುವವೋ ಹೇಗೆ? ಮನವಿದಾರರು ಈ ನ್ಯಾಯಾಲಯದ ಐತೀರ್ಪು ಪ್ರಕಾರ ಪರಿಹಾರಧನ ಪೀಡಿತರೋ ಹೇಗೆ? 28A ಮನವಿದಾರರು ಈ ಒಳಗಾಗಿ ನಿವೇಶನ ಅರ್ಜಿ ಸಲ್ಲಿಸದೇ ಇರುವರೋ ಹೇಗೆ? ದಿವಾಣಿ ನ್ಯಾಯಾಲಯ ತೀರ್ಪು ನೀಡಿದ 3 ತಿಂಗಳ ಒಳಗಾಗಿ ಕಲಂ 28A ಪ್ರಕಾರ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುವೋ ಹೇಗೆ? ಅರ್ಜಿದಾರರು ಕಲಂ 28A ಪ್ರಕಾರ ಸಲ್ಲಿಸಿದ ಅರ್ಜಿಯು ಮೊದಲೇ ಸಾರಿಗೆ ಸಲ್ಲಿಸಿದೋ ಹೇಗೆ? ಈ ಮೇಲ್ಕಂಡು ವಿವರಗಳ ಬಗ್ಗೆ the complete discussions have been made and they have stated that application has been filed within 46 days. And also, my lord, compensation is also.
Where is the application of mind as regards the property being similarly situated?
My lord, kindly.
LAC 183, 184 and 335. Though the order is some 50 pages.
True, my lord.
The reasoning is only 1 line.
My lord, reasoning, my lord, ಪರಿಗಣಿಸಬೇಕಾದ 28ರಲ್ಲಿ ಪರಿಗಣಿಸಿದ ವಿಷಯಗಳು ಅಂತ ಹೇಳ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಅದು ಹೇಳಿದ್ದಾರೆ, ಬಟ್ ಅದನ್ನು ಪರಿಗಣಿಸದಲ್ಲಿ ಪರಿಗಣಿಸಬೇಕಲ್ಲ.
Next page, note 129. ಇಲ್ಲೇ ಇದು ಮಾಡ್ತಾನೆ ನೋಡಿ. ಮಂಡನೆಯಲ್ಲಿ ಮಾನ್ಯ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದ ಆದೇಶ ನೀಡಿದ ಜಮೀನು ಮತ್ತು 28A ಅರ್ಜಿದಾರ ಜಮೀನು ಒಂದೇ ಅಧಿಸೂಚನೆಯಲ್ಲಿ ಇದ್ದು ಒಂದೇ ಜನರಲ್ ಅವಾರ್ಡ್ನಲ್ಲಿ ನಮೂದಿದ್ದು ಕಾರಣ ಒಂದೇ ಅಧಿಸೂಚನೆಯಲ್ಲಿ ಬರುತ್ತದೆ ಅಂತ ವಾದ ವಿವರಗಳನ್ನು ವಿವರಿಸುತ್ತಾರೆ. ಕಾರಣ ನೀರಾವರಿ ಅಂಶ ಪರಿಗಣಿಸಿದೆ.
My lord, thereafter, my lord, your lordship should kindly, these, the Vishaya Sangati, Vishaya ಇದನ್ನ ಮಾಡಿಕೊಂಡು totally, my lord, your lordship ಹೆಚ್ಚು ಪರ್ಯಾದಿ 1,87,500 ರೂಪಾಯಿ per acre, my lord, this was fixed.
Yes.
Then, my lord, your lordship kindly, Vishaya 5. ಹಕ್ಕು ದಾಖಲಾತಿ ಪರಿಶೀಲನೆ, your lordship ಕೊಟ್ಟರು.
Yes.
Yes. ಹಿರೇಕೆರೂರು ತಾಲೂಕು ಮಾವಿನತೋಪ ಗ್ರಾಮದ ರೀಸನ್ ನಂಬರ್ 75/2A, ಕ್ಷೇತ್ರ 5 ಎಕರೆ 18 ಗುಂಟೆ, ರೀಸನ್ ನಂಬರ್ 75/2C, ಕ್ಷೇತ್ರ 9 ಗುಂಟೆ ಜಮೀನು ಮಾಲಕರಾದ ಬಸಪ್ಪ ತಂದೆ ಹನುಮಂತಪ್ಪ ಬನ್ನಿಕೋಟ್ ಸಾಕಿನ ಮಾವಿನತೋಪ ಅವರು ಇವರ ಜಮೀನಲ್ಲಿ ಭೂ ಸ್ವಾಧೀನವಾಗಿದೆ. ಈ ಹಿಂದೆ ಅವಾರ್ಡ್ ಪ್ರಕಾರ ಪರಿಹಾರವನ್ನು ಇವರೇ ಪಡೆದುಕೊಂಡಿದ್ದಾರೆ. 28A ಅರ್ಜಿಯನ್ನು ಸಹಿತ ಇವರೇ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. Lord, then Lord, your lordship should kindly, there, my lord, subject 6, my lord, they refer to all the writ petitions, and also they say that, my lord, your lordship should kindly, petitions is entitled to all statutory benefits as per the Land Acquisition Act, and also as per the decision reported in 2001 SAR so and so Sundar versus ಅಂತ ಆದೇಶ ನೀಡಲಾಗಿದೆ. And thereafter, Lord, your lordship should kindly, the total compensation that has been fixed.
ಅದು ಮಾತ್ರ ಚೆನ್ನಾಗಿ ಬರೆದಿದ್ದಾರೆ.
Please.
That is the only thing which is written properly.
Please. My lord, page 133.
Yes.
Next relevant page, my lord, 134.
ಆಯ್ತು, ನೋಡಿ ಆಯ್ತಲ್ಲ.
This has been, Lord, my respectful submission for you.
ಎಷ್ಟು ಹೋದ್ರೇನು ಅಲ್ಲಿ reason ಇಲ್ಲ.
Then, my lord.
There is no reason at all.
Please,
How
please.
much ever you repeat the same reading, it is the same
Reasons
thing.
ಇದೆ, ಇದನ್ನೆಲ್ಲ ಇದ್ರಾಗ ಮಾಡಿದ್ರಲ್ಲ. Just I read to your lordship.
Yes.
ವಿಷಯ 5 ಓದಿದ್ನಲ್ಲ.
ಹೌದು.
ವಿಷಯ 5 ಒಳಗೆ ಏನೈತೆ ಗೊತ್ತು, ಇದು ಲ್ಯಾಂಡು ಅವು ಲ್ಯಾಂಡು ಎಲ್ಲ ಸೇಮ್ ಇದೆ. ಆ ಪ್ರಕಾರ ಅವರಿಗೆ ಕಾಂಪೆನ್ಸೇಷನ್ ಕೊಡ್ಲೇಬೇಕಾಗುತ್ತೆ. ಇದು ಇರಿಗೇಟೆಡ್ ಫೆಸಿಲಿಟಿ ಇದೆ ಅಂತ ಹೇಳಿ.
ನಿಮ್ಮ ಪೆಟಿಷನ್ ಎಲ್ಲ ಹಂಗೆ ಒಂದು ರೀಸನ್ ಕೊಟ್ಟು ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ.
My lord, this is the last.
When you are appearing for the respondent, ಹಂಗೆ ಒಂದು ಆರ್ಡರ್ ಮಾಡ್ಬಿಡು.
ಆಗಿಲ್ಲ.
Yes.
Your lordship will kindly,
Come to the point, please.
One ನಿಮಿಷ. Lord, the total award amount, Lord, which I indicated, Lord. Your lordship. Lord, the first question, Lord, that has been raised, my lord, in the writ petition. Para 9. Thereafter, it is alleged that respondent number 3 has filed an application before the respondent number 2 is.
Now that you are coming to the point, we'll adjourn all the other matters and then take up your matter.
Please.
Everybody is waiting to go.
Serial number 42 taken tomorrow 2:30. Small matter. On 15th across 42 tomorrow at 2:30.
In urgency as to
On 15th, your lordship is posted for cross examination. That's what.
42 relist tomorrow at
Serial number
2:30 PM.
Serial number 24, your lordship. I seek apology, your lordship. Interim order earlier granted may kindly be extended.
24 interim order.
Serial number 71, my lords. The other side, the trial court advocate, the copy has been served, my lords. Tomorrow I will file the memo, my lord. Needful is being done. And here the advocate is appearing, my lords. They are filing.
71 ಏನ್ ಮಾಡಿದಿರಾ?
The my lords has directed to serve the copy to the trial court advocate.
Have you paid the process fee?
Please, ma'am. He is appearing for the respondent, contesting respondent.
You are appearing for this. So submit that you would be appearing for respondent number 1 and 5.
One is the contesting.
1. What about 5?
They are dependents. We are also dependents. They are not contesting party.
You have to
I'll pay.
make payment of process fee for 3, 1 and 5.
Dispensation memo, I'll file the dispensation memo.
You dismiss ಮಾಡ್ತೀವಿ ಆಮೇಲೆ ಹಾಕಿ. All preemptory orders are there and you are still making this kind of submission. Dismissed.
Serial number
71 ಯಾವ್ದು ಆಗಿಲ್ವೋ 50 to 71 ಯಾವ್ದು ಆಗಿದೆಯೋ ನಂಬರ್ ಕೊಡಿ, ಅದು ಯಾವ್ದಾಗಿದೆ. 65 65 16 tomorrow reach ಆಗಲ್ಲ. 16 relist 18th,
My lord, 49, my lord.
16 interim order.
My lord, 49, my lord.
Huh?
There is an urgency, my lord. Possession warrant has been issued, my lord.
49.
Please, my.
Relist on possession.
Possession warrant as issued by the executing court, my lord.
Wait madangidre madi.
Please.
So that will take.
Please.
Yes.
Serial number 34. 34.
54 dismissed.
34, man. 34.
34.
I am for the respondent, my lord.
Kindly have day after tomorrow, man. GMCPC, man.
16 and 17. AGA. Affidavit. Bailable warrant. ಬಂದಿದೆಯಾ ಇಲ್ವೋ? Bailable warrant. Despite the order dated 21/1/2025, affidavits have not been filed by respondent number 16 and 17. They have also not appeared through video conferencing as directed. In that view of the matter, issue bailable warrant to respondent number 16 and 17, returnable by 24th February, fixed at a sum of rupees 20,000. If on that day also there is no appearance on part of respondent number 16 and 17, non-bailable warrant would have to be issued.
Serial number 25, man.
Petition number 1 is my name.
Registries direct print the name of Shri Prashant F. Gowder as that appearing for the petitioner and delete the name of Shri Aruna Sham M as that appearing for the petitioner. He submits that petition number 1 is expired. He seeks for and is granted 2 weeks time to file necessary application to bring the legal representative to deceased respond petition number 1 on record. Shri Registry Director delete the name of Shri R.M. Kulkarni as that appearing for respond number 2 to 4. Since Shri Chetan Manoli has appeared for respond number 2 to 4. Yes.
Serial number 25, my lord. 25, my lord. Password matter. Short that regarding typed copy, I have made these submissions, my lord. It will be taken.
Take your submission. Next.
Serial number 92.
62 minutes, 62. I have given my submission to office objection. Those documents are filed for reference only, not for, I am not going to claim that those documents.
Counsel for the petitioner submit that you would not rely on the documents referred to in office objection at serial number 28 and 52/3, 52(3). As such, the office objection is overruled. You would not be entitled to rely on those documents. 62.1, accepting the memo filed by the counsel for the petitioner, notice to respond number 1 is dispensed with at the sole risk, cost and peril of the petitioner. Needless to say, respond number 1 will not be bound by any orders passed by this court. Relist on 24th.
Serial number 4.
65. And a memo of dispensation to the unserved respondent who are not contested before the trial court.
Counsel for the 65. A memo of dispensation has been filed seeking for dispensation notice to respond number 2A and B, 3, 5, 6 and 7. Accepting the said memo, notice to so and so is dispensed with at the sole risk, cost and peril of the petitioner. It is made clear that they shall not be bound by any orders passed by this court. Relist on 24th. Interim order earlier granted is extended till next.
Serial number 44.
My lord. Serial number 40, my lord. Office objections are already complied, my lord. Serial number 6 is regarding prayer to be clarified. And 22 typed copies are also.
3 is returned with the endorsement refused. Service is held sufficient, print so and so with the endorsement refused. Counsel for the petitioner submit that he has complied with the office objection. Registry to verify. 40.1. Wait,
Awaiting ಇದೆ ಸ್ವಾಮಿ.
Same 40.
ಅಲ್ಲ interim order is in.
Relist on Relist on 10th March. Interim order earlier granted is extended till next date.
Please.
Serial number
61.
61.
Needful done. R2 and I.
Counsel for the petitioner submit that process fee has been paid. Registry to verify if needful has been done. Issue notice to unserved respondents returnable by 24th April.
Serial number 80, my lord.
Serial number 55, my lord. Interim order. Serial number 55, my lord.
Yes.
Needful done, my lord.
Counsel for the petitioner submit that he has complied with the office objection. Registry to verify and relist on 17th February.
Interim order may be extended.
Interim order earlier granted
Notice
is
may be
extended till
dispensed till 7 to 10, my lord.
At the request, a memo has been filed seeking for dispensary of notice to respond number 7
7 to 10.
to 10. Accepting dispensed sole risk cost and peril will not be bound. Yes.
66.
Third motion.
54.
54.
44, my lords. I am appearing for a petitioner.
How the name?
44.
44.
For the respondent.
ಏನು?
44, my lords. There is office objection. I have given a submission. That, my lord, the entire order sheet of a trial court has been put.
Mentioning ಏನು ಹೇಳಿ?
Interim order extend ಆಗಬೇಕು. Submission accept ಮಾಡಿದ್ರೆ.
ಇವಾಗ submission paper ನೋಡಿದೆ ಹಿಂಗೆ accept ಮಾಡಿ. 44. Interim order earlier granted is extended released on 24th.
My lords, 84 on the interim order.
84. ನೀವು ಇಲ್ಲಿ 84.
ಹಾ, interim.
ನಿಮ್ದು ಎಕೋ ಬರ್ತಾ ಇದೆಯಲ್ಲ ಆ ಕಡೆ ಎರಡೂನು 84 ಏನು?
My lord, one submission, my lords.
22 matter.
ಈ matter ನಲ್ಲಿ the constitutional validity of proviso to rule 34 has been challenged and your lordship has directed them to file objections within 30th, which has not been filed, my lord. If at all that in
Already we have filed, but additional statement of objection.
ಯಾವಾಗ ಮಾಡ್ತೀರಾ? ಅವ್ರು ಕಾಪಿ ಕೊಡ್ಬೇಕು. ಯಾವಾಗ?
By Monday or Tuesday.
Monday ಕೊಡ್ತೀರಾ? Then 84 learned AGA submits that the additional statement of objection in respect to the challenge to the constitutional validity would be filed by 18 after serving a copy thereof on the counsel for the petition. Released on 21st.
My lord, the interim order next.
Interim order earlier granted is extended till next day.
My lord,
Serial number 18 ಹೆಂಗೆ ಮತ್ತೆ ಹಿಂಗೆ?
Serial number 90.
ಏನ್ ನಿಮ್ದೇನಿಲ್ವಾ? ಹಿಂದೆ ಹೋಗು.
my lord, previous
Service matter. I'm being.
Serial number?
91. 91.
ಹಾ.
Service matter was, your worship was pleased to dispose of matter for non-prosecution. Thereafter, they have recalled the applications and the matter is pending for consideration with respect to employment of mine is considered.
Yes.
May it be taken in fresh matter. This 21.
Is a 21 matter. It will come in the regular course. Next.
Serial number 67, lords. Serial number 67.
ಏನ್ ಹೇಳಿ?
Dismissal.
Dismiss.
Lords, made submission, lords. I have copy of manuscript of Annex A, lords. That is party's name, lords. That is already forthcoming in impugned order, lords. For that reason, I made counsel submission. Annex A is the manuscript portion is the amendment carried out portion. The name of the petitioner, lords, already forthcoming in impugned order, lords. For that reason, lords,
What is the objection at serial number 21?
manuscript portion of Annex A to be filed.
Typed copy of the manuscript
Please,
portion.
lord.
67 accepting the submission of the counsel for the petitioner that the manuscript portion would not be relied upon. Office objection serial number 21 is overruled. Relist on 24th. Interim order idea?
Please.
Interim order extend. Relist on 24th. Relist on 7th March. Interim order earlier granted is extended.
Serial number 66, my lords,
Hmm.
for petitioners. Regarding with respect to respond number 2 to respond number 5 minutes, I have paid the PF minutes already.
Hmm.
And regarding respond number 13 and 16 to 18, I have died, my lords. I have to take necessary steps, my lords.
Despite the earlier order, necessary application have not been filed. Hence, to bring the legal representative of deceased, respond number 13, 16 to 18 on record. The petition having been abated against them long ago, a formal order is passed dismissing the above petition against respond number 13, 16 to 18. Counsel for the petitioner submit that process fee has been paid. Registry is to verify if process fee is paid, issue notice to unserved respondents, returnable by 22nd April.
Please, my lord. Interim order, my kind.
Interim order earlier granted is extended.
Serial number 80, my lord. By oversight, the insurance company has made a party in this matter, my lord. It may be delete the insurance company.
You want time?
Please delete the name of insurance company, my lord. Respond number 2, my lord. Before the tribunal, my lord, insurance company is not a party. Insurance company also, before the tribunal, my lord, deleted the.
Mentioning ಮಾಡ್ತಾ ಏನು
File a memo, my lord.
ಮಾಡಿ ಮತ್ತೆ ಫೈಲ್ ಮೆಮೊ ಮಾಡಕ್ ಮೆನ್ಷನ್ ಏನು ಬೇಡ.
Taken up day after tomorrow.
It will come.
Serial number 50.
50. Yes.
Read out the amendment, your lordship.
What about the application?
Application, your lordship, the stated that the sole petitioner have died. Sole petitioner, no. There are more petitioners also. It may be abated.
So ಯಾವ petitioner?
Petition number 2, Your Lordship.
50. Petition number 2 has expired. Despite the order dated so and so, no application has been filed to bring the legal representative of deceased petition number 2 on record. As such, the petition insofar as petition number 2 is concerned is dismissed as abated. Counsel for the petitioner submit that the amendment has been carried out. Registry is direct verify. Relist on 10th March.
Serial number 93, my lords. Yeah, now turn 18th, my lord. Contempt application has been filed. My lords have heard the matter, demolition matter, my lord. Both of demolition matter. Now turn 18th, my lord.
93 released on 18th at 2:30 p.m.
Please, interim order kindly.
Interim order earlier granted.
Bill number 95, my lords. Writ of mandamus, my lords. It may kindly be taken in preliminary hearing matter. Any date may be fixed.
Next.
Land has been acquired.
ಅದೆಲ್ಲ ಬರಲ್ಲ.
Bill number 63, my lord. Office objection raised on the wakalat filed by the respondents, my lord. I am for the petition. Office objection raised on the wakalat filed by the respondents. Well, I am for the petition, my lord. It is the objection who has.
What is the submission?
It is the respondents who has to complain.
So we'll cancel the wakalat. 63, despite several opportunities have been granted, the office objection on the wakalat nama of respond number 3 to 5 has not been corrected. Elli our ಹೆಸರೇ print ಮಾಡಿಲ್ಲ.
ಶಿವರಾಜ್ ಬಳ್ಳೊಳ್ಳಿ.
ಶಿವರಾಜ್ ಬಳ್ಳೊಳ್ಳಿ 1 and 2. 3 to 5 ಯಾರು?
It is the objection raised on the wakalat matter filed by the respondents.
Of 3 to ಯಾರು ಫೈಲ್ ಮಾಡಿರೋದು?
ಶಿವರಾಜ್ ಬಳ್ಳೊಳ್ಳಿ.
1 and 2 ಗೆ 3 to 5 ಯಾರು? ಅವ್ರ ಹೆಸರು 63 registry is direct print the name of the advocate who has filed wakalatnama for respond number 3 to 5 in the above matter and released on 24th.
Interim order.
Interim order extended.
Bill number 70, my lord. 59, my lord.
ಎಲ್ಲ ಹೇಳ್ತಾರೆ 59.
Not taking of the steps against the respond number 5, my lord. He has allowed, madam. That's why I filed the affidavit. That person is still alive.
6 is alive.
Yes, madam. That's why I filed the affidavit.
ಯಾರು ಹೇಳಿದ್ದು ಸತ್ತೋಗಿದ್ದಾರೆ?
That endorsement has come before this court, my lord.
Post office ಇಂದ?
Yes.
59. The counsel for the petitioner submits that on verification, he has found respond number 6 to be very much alive. The petitioner was called upon to file an application to bring the legal representative of deceased respond number 6 on account of the endorsement received from the police post office. This court relies upon the endorsement received from the post office. In this matter, a person who is alive has been declared to be dead by the post office. In that view of the matter, necessary action would have to be taken by the Director General of Posts against the concerned postal employee and a report to be filed within 30 days from now. The Additional Registrar Judicial is directed to forward a copy of this order to the Director General of Posts, Southern Division, for necessary action. Counsel for the petitioner submit that he has made payment of process fee for respond number 2, 3 and 6. Registry to verify if needful has been done, issue notice to the unserved respondent returnable by 23rd April.
Interim order may kindly.
Interim order earlier granted is extended till next date.
Bill number 21, password.
57, my lord. Needful is done.
57 needful. Application file ಮಾಡಿದ್ದೀರಾ?
Today only I filed the application.
Counsel for the petitioner submit that he has filed necessary application to bring the legal representatives of respond number 5 to 7 in IA number?
IA number 1 and 2.
1 and 2, ಎರಡೇನಾ?
Yes.
5 to 7 and 3 ಬೇಡವಾ?
6 and 7 only have expired. 6, respond number 6 and 7 expired.
5 to 7 ಇದೆಯಪ್ಪ.
But already 5 is legal errors are in the record, my lord.
Issue notice on IA 1 and 2 of 2025, returnable by 24th April.
Interim order may kindly.
Interim order.
Serial number 21, my lord. 1992 order of land tribunal challenges this court after 32 years, which has attained finality after going to Supreme. They have again filed a writ petition. Because
Time illa, Mr. Patil.
recheck, it will not take more than 15 minutes, my lord. And
21 relist on 17th. Yes. ನೀವಿನ್ 3-4 ದಿನ ಬರಂಗಿಲ್ಲ ಇಲ್ಲಿ. 76, 77.
76, 79.
ಏನು ಅರ್ಜೆನ್ಸಿ ಏನು?
Land tribunal challenge.
No. Yes, Mr. Edward.
Serial number. Government has forfeited the land 79. And the last package of lawsuit direct the deputy the government will secure the record from the deputy.
Forfeiture ಆಗಿದೆ. 79 relist on 18th.
Serial number 47, my lords. The office objection is for typed copy of entire order sheet. Given a submission that the impugned order is in typed format.
47.
Yes, only that has to be, my lord, accepted.
Learned counsel for the petitioner submit that you would only be relying on the typed copy and not the manuscript. Hence, office objection serial number 28 is overruled. Relist on
Tomorrow, may I request?
19th.
Please.
Serial number 54, your lord. Needful
Serial
done.
number 38.
Yen needful done.
Process, I have paid the process.
Counsel for the petitioner submit that process fee has been paid. If registry to verify, if needful has been done, issue notice to respondents returnable by 23rd April.
With the kind leave.
Serial number 58, my lords. Annexure, my lords. Relevant portion already typed, my lords. Serial number 58, my lords. Annexure, my lords. Type relevant portion already typed, my lords. There is entire.
And counsel for the petitioner submit that she will only be relying on the typed portion of Annexure A and not the manuscript portion. Office objection serial number 28 is overruled. Relist on 19th.
Please. Serial number 46, my lord. Kindly be 2 days time for comply with. Yes, sir.
Counsel for the
Serial number.
For just a moment, please.
I'm sorry.
Are you interrupting from that time?
I'm sorry, my lord. I thought there is some disturbance here.
You thought wrong. Please wait. 46, you know.
2 days time for comply with office objection, my lords.
Learned counsel for the petitioner seeks for and is granted. 2 days time to comply with office objection. Relist on 19th.
Please.
My lord, serial number 37, my lord.
Yes.
My lord, I'm filing the amended cost title.
Counsel for the petitioner has filed the amended cost title and submit that he has carried out the amendment.
I'll carry out the amendment.
Carry out the amendment. And carry out the amendment during the course of day. Relist on 19th.
One submission, my
In
lords,
this
in the
matter, my lords,
matter.
I was directed to produce, my lords, the inspection report.
It
is regarding, my lords, the building which has been.
19th will.
It is ready.
Give it to him. 19th will come. Now we are only adjourning matter. ನೀವು ಮನೆಗೆ ಹೋಗಿ ಅಂತ ಆಫೀಸ್ಗೆ ಹೋಗಿ ಅಂತ ಹೇಳಿದ್ರೆ ನೀವು ಬೇಡ ಅಂದ್ರೆ ಇಲ್ಲೇ ಕೂತ್ಕೊಳ್ಳಿ. 102.
Please. I want to undertake to file wakalat for R1 to R4.
She is on to submit that you would be filing wakalatnama for
R1 to R4.
R1 to R4. ಬೆಳಗ್ಗೆ ಅಜ್ಜನ್ ಆಗಿದೆ.
Please.
But serial number 77.
Yes.
Lord, in this case, the respondent housing board authority has cancelled my allotment. Since
Cancelled?
how
2017.
Though I have paid the EMI amount also, now they have taken steps.
77 relist on 18th at 2:30 p.m.
Please.
Serial number 105, man. May I request for a date next week or a week after next?
Final hearing 2018. The request of counsel for the petitioner released on 24th. Yes.
May I request for extension of Interim?
Yeah, I will extend it.
Serial number 70, my lord. Needful done.
70?
Needful done, my lord.
17.
Please, my lord.
Counsel for the
70.
petitioner submit that needful has been done. Yen needful andre eno?
My lord, notice, please, my lord. PF2 R9.
That process fee has been paid. Registry to verify. If needful has been done, issue notice to unserved respondent. Returnable by 23rd April. Learned AGA accepts notice for respond number 12.
Please.
Please.
113, my lord. 113. Tomorrow or day after tomorrow.
That is with regarding to no confidence motion, yesterday's matter.
Wait, man, we will take it up. Further hearing.
Yes.
Urgent ilva?
Gentle. My lordship is already exhausted. Tomorrow, my lord.
And 13, no exhaustion. Inna FE Patil on kelbeku.
Ade, tomorrow.
113 relist tomorrow at 2:30 p.m.
Please.
Yes, who is on the VC?
May I make a mention, my lord, with a kind leave?
Yes, please.
Serial number 38, One of the respondent appears to have been dead. Kindly grant some 2 weeks time to verify and see to it that the necessary steps are
Counsel
taken.
for the petitioner seeks for and is given 2 weeks time to comply with the office objection and file necessary application to bring the legal representative of deceased respond number.
I think it is 4, my lord, but we need to verify.
If needful is not done by
2 weeks time.
If needful is not done by 28th February, relist on 10th March for dismissal.
Great.
Yes, Mr. Gunjal.
Under 106, my lord. The matter was posted for pronouncement of orders on
Pronounced and dismissed.
Okay.
Yes, Mr. Ramesh. Mr. Nitin.
Mood matter, my lords. Third list, second matter, my lords.
Mood matter, where area?
Construction, yes, my lords.
Mood matter.
Wait, please.
Arvind D. Kulkarni.
Please.
And for the petitioner, my lords, petitioner has joined the PG Ayurveda course in the year 2018 and 19. Petitioner has joined the PG Ayurveda course in the year 2018 and 19, my lords. After that, she attended the first year exam in the year 2019, my lords. And she failed in that exam, and due to some COVID reasons, travel restrictions, my lords, she could not attend the examination in the year 2020 and 21, my lords. Now in the year 2023, the first year exams was cleared, my lords. Now she applied for the final year exam, my lord. It shows that your maximum duration exceeds, my lords.
Number of chances ಎಷ್ಟಿತ್ತು?
6 years, my lords.
ಇವಾಗ ಕಮ್ಮಿ ಮಾಡಿದ್ದಾರೆ.
No, my lords. As per
Maximum duration is, my lord, 6 years. Kindly request for page 22. Page 22.
Yes.
Lords, the fifth, my lords, serial number 5, Ayurveda. For PG, my lords, 3 years is the, my lords, and maximum duration is 6 years. The petitioner, my lords, got admitted, my lords, in the year 2018 and 19. So, my lords, in the year 2024 itself, my lords, 6 years have already been exhausted.
Not given any this one for COVID. COVID again.
COVID again, there was a notification with respect to the students of the year 2014, 15, 15, 16, 16, 17 ಅವರಿಗೆ
them also. As long as they were students during the COVID period.
Of course, ಯಾಕಂದ್ರೆ that notification has been revised. That they have questioned today, my lords.
Yesterday, my lords have given.
Annexure H.
Yesterday, my lords have given interim order in the similar matter, my lords.
If you're not given COVID exemption.
That COVID exemption, that notification was only with respect to the students of the.
You already passed an order in some matter. You said the interim order.
That I'm unaware.
Shri Avinash Bankar accepts notice for respond number 1 and 2. Shri Avinash Angdi accepts notice for respond number 3. Alva?
1 and 2.
NCIM SM Avinash
NCISM Avinash Angdi, of course.
The respondents are directed to permit the petitioner to appear for the final year examination scheduled to commence from 4/3/2025 for PG course in Ayurveda by accepting the fees, examination fee to be paid by the petitioner and issuance of necessary hall ticket in relation thereto. Relist on 21st. Not even judgment is the same judgment we can apply.
Kindly permitted to take hand delivery, my lords.
Again hand delivery. 23rd tane naale baratte.
Time at what?
You go home. Go to office.
14.
125 is allowed. Production of certified copy of annexure H is dispensed with.
2 Pooja Saudati.
My lord, with respect to the petitioner's request for the affiliation of the institution, my lord, the intake of students about 50 students per unit, whereas they have to take 100 students per unit, my lord. It's for the admission. And 15th is the last day.
Already come up earlier, alaido.
Yes, my lord.
Actually, my lord, day before yesterday it was listed. My lords, my lord, granted time to my lord submit this thing.
No, this is the,
You sought time to obtain instructions.
this is the.
Now, my lord, I have received, my lord, parawise as well as records.
Hmm.
Petition has been, my lord, filed seeking mandamus, my lord, to affiliate additional 50 seats. My lord, their request, my lord, is already, my lord, rejected in the year, my lord, 29th November 2024 itself. Endorsement is issued. My lord,
They
the
are
principal.
not requested for additional. The 2/5/2016, they permitted annual intake of 100 students.
Pardon me?
2/5/2016,
Yes,
they were permitted to conduct B.Ed program
yes.
with annual intake of 100 students.
That is, my lord, permission by NCT. That is subject to, my lord, the condition therein, my lord, at number 2 may kindly be seen, page number 10.
Page number 10.
10.
Hmm.
My lords get it?
Hmm.
Yes. Further, the recognition is subject to fulfillment of all such other requirements as may be prescribed by other regulatory bodies like UGC, affiliating university body or the state government, etc., as applicable.
Hmm.
My lord, as per the, my lord, government notification in the said regard, for renewal of, my lord, affiliation every year, my lord, every college needs to, my lord, score minimum 40 points, my lord, depending upon various parameters. My lord, the college was, my lord, assessed by local inspecting committee, my lord, which could score only 38 and some odd points, my lord, for 24-25. And for additional, my lord, increase of intake, my lord, the college has to, my lord, secure minimum 45 marks, 45 points.
Additional, we agree. But is 100 and already sanction agidella.
That is subject to, again, my lord, sanction, my lord, permission is granted, my lord, by the NCT. That is not binding, my lord, on the.
So who reduced it to 50?
My lord, the affiliation would be, my lord, granted, my lord, after inspecting the infrastructure and other, my lord, parameters, my lord, laid down, my lord, by the government.
So where is the order restricting it to 50?
Annexure E, my lord. Now, my lord, for 24-25, we have given affiliation for 50 seats. 25-26, my lord, we have granted them, my lord, 100 seats. Now, my lord, process of affiliation would take place, my lord, previously. So far as 24-25 is concerned, my lord, process of affiliation is already over. After that, my lord, they sought additional intake affiliation of 50 seats. That was rejected, my lord, by endorsement dated 29th November 2024. And the, my lord, college also accepted the same. And, my lord, pleaded for granting of.
So that is for the year 24-25 is already rejected.
Yes, yes.
25-26 you are given 100 now.
100, my lord.
24-25 andre yaವಾಗ start agide?
Annexure F, my lord, page number 16, we have already given one representation after receiving the notification, my lord, that Sharattu Baddha Anumodane. And regarding
If they have
this,
rejected it already, you have to challenge it. Mandamus
That
will not be
endorsement is
maintained.
not challenged.
Reject ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ you will have to challenge that rejection.
my lord, according to this rules of NCT, my lord, there is no.
It may be against, but unless you challenge it, we can't refer to it.
Even the principal has accepted that we would go ahead with only 50 seats. Their own principal.
No, my lord.
Both these documents may kindly be seen. This is 1/1/2025, my lord, and the endorsement is dated 29th November 2025. Kortini, just now, my lord, I have received the records. In fact, my lord, they applied for affiliation of 50 seats only for 24-25, and later sought, my lord, extension. The committee inspected, my lord, and submitted the report. They accepted.
Please get instruction if these two documents.
My lord, at page number 16, annexure F.
Normally, learned counsel for the respondent submit that the earlier request for enhancement of intake submits that though the
My lord,
NCTE had permitted the petitioner to run 2 units having intake of 50 students each, the petitioner not satisfying the requirements, the number of seats were reduced, number of intake was reduced to 50. An application had been made by the petitioner for increasing of the intake had been rejected on 29 November 2024, which has been accepted by the principal of the petitioner college on 1/1/2025. Faced with the above situation, learned counsel for the petition seeks fund is granted to days time to obtain instruction, make a submission. Released on
My-
17th at 2:30
My
PM.
lord, 18th, my lord.
18th at 2:30.
Whereas this is the copy wherein I'm submitting before this honorable court that
See,
15th
this-
is the last day for admission, my lord, and with
We'll
penalty
extend
fees.
it if it is required, but then your principal has accepted it.
I'll seek
Not yet.
instructions with regard to that.
And that has been rejected. Unless you challenge it, we can't look into
Much obliged, my lord.
it. In.
List 3. Joshi Sripad, still number 1.
Yes.
Your Lordship, a case of disqualification of a corporator for Municipal Corporation Belgavi, Your Lordship.
Disqualification under what provision?
On perusal of the impugned order, Your Lordship, there is no provision as such, but the allegations made are under 26(1)(c) and K of the Karnataka Municipal Corporations Act, Your Lordship, 1976.
Yes.
Lordship, the factual matrix of this case, just in brief, is that, Your Lordship, the petitioners were elected as corporators from Belgavi Municipal Corporation from the respective wards in the year 2023. If I may take a Lordship's kind attention to Annexure B, the complaint filed by the complainant, the respondent number 4. Though, Your Lordship, he has no caveatable right in this petition, but for formality's sake, he has been served a copy. Annexure B of my petition, Your Lordship.
My lords, I appear for the respondent before in this matter. I am the caveator, my lords, the complainant caveator. My lords, this petition itself is not maintainable on the grounds that, my lords, under 26(3) of KMC Act, the person aggrieved by the order of the regional commissioner, the respondent number 2 herein, has a provision to appeal before the state government within 30 days of the order being passed. Before exhausting that remedy, my lords, the petitioners have come before your lordships.
Grievance was that there was no notice issued to the petitioner, morning when you mentioned.
No, Lordship, my grievance was section 33 of this act.
Election petition. It pertains to election petition, my lords.
No, I'll make my submissions, Your Lordship.
Yes.
No election of a councillor shall be called in question except by an election petition presented for adjudication to the district court having jurisdiction within 30 days from the date of the publication of the result of election under section 32. Now, I rely on this provision, Your Lordship, for the sole reason that the allegations made in the complaint against the petitioners are that in the year 2020, the wives of these petitioners in an auction took a property on lease under the PWD department, and wherein there are 48 units, and the wives of the petitioners, two petitioners, two wives, they have been running on lease a shop in the Tinisukatte, which is a food court in Belgavi, Your Lordship.
On the merits of the matter.
No, my submission is, Your Lordship, there is misapplication of mine for the reason that
Misapplication, you go on appeal. If you have been served with notice and orders have been passed.
Yes, my lords.
If you have not been served, that's different.
my only submission is, Your Lordship, I'm relying on this fact that I was not even a corporator when the...
Are we the appellate authority?
No. No, Your Lordship.
You want to make this court the appellate authority?
I cannot, Your Lordship.
But if there is an appeal provided, go under the appeal. If we have if you don't have anything, we'll consider it under 227. Otherwise, no.
No, if
Appeal haki. Idaka kaigate adu nadene haki.
In fact, my lords, the very
Appeal under section?
Section 26 sub clause 3.
sub clause 3, my lords. Yes, 26.
You've been heard.
Now, my ground is, Your Lordship, the regional commissioner does not have any authority to pass an order disqualifying the corporators is what my submission is. Therefore, since there is illegality of jurisdiction itself is not granted to the regional commissioner, Your Lordship, is what my ground is. Had there been a express provision providing an authority to the regional commissioner to adjudicate on a complaint, then I would have to go to the appellate authority, Your Lordship. Therefore, my specific ground, my primary 3 grounds are that he does not have any authority to adjudicate on this matter, on a complaint.
Because this point was raised before the regional commissioner.
Complaint he can adjudicate.
Please, Your Lordship.
Without a complaint he can adjudicate. With a complaint he cannot.
No, Your Lordship, my submission is the regional commissioner has no authority under the Karnataka Municipal Corporations Act for disqualification of a corporator. My only question is,
who is the person under 26 who has the authority to do so?
My lords, if my lords would read the subsection 3 of the section 26, my lords would find that the word there used is the regional commissioner, the person being aggrieved by the order of the regional commissioner. So there is no other authority than the regional commissioner to address this issue, except it is for the election petition. The matter has to go before the district judge. If these grounds were to be urged before the regional commissioner, matter would have been something different. They have argued about the jurisdiction before the regional commissioner. The regional commissioner has addressed this issue that the regional commissioner has authority under section 26. If the
AGA accepts notice for respond number 1, 2, 3, and 5. Corporation City Belgavi.
Vinay
Kaujalgi for respond number 6. It's also accept notice for respond number 4.
4, my lords. I filed the caveat, my lords.
Petitioner is before this court seeking for the following reliefs. What is essential challenge in the present matter is an order passed under subsection 2 of section 26 of the Karnataka Municipal Corporation Act 1976, as regards which the petitioner has an alternative efficacious remedy in terms of appeal provided under subsection 3 of section 26, reserving such liberty and leaving all contentions open. The petitioner is relegated to such appeal remedy. The petition stands dismissed.
Obliged. Grateful, my lords.
To Nitin Ramesh.
My lord, the petitioner, my lord, is a lady who got the construction license on 22nd of January. And then just 8 days, I taken was just, and already a notice is issued saying that I should stop the construction. My lords, Annexure A, page 18. My lords,
Yes.
this is clearly violation of my natural justice, my lords. What happens is, on the complaint given by some person calling himself an RTI activist on 30th 12 2024, in respect to the same property, a notice is issued at Annexure F to some person called Amar, my lords. Amar Babjan or Dala Banjan, they say, my lords. Amar Dala Banjan. He says, I have nothing to do with this property. I am not doing any of these illegalities. That is over. I don't know. I got to know this only subsequently. All of us, and after this happens in December of 2020.
Only stopping construction. We'll hear the other side. Who is the counsel for TMC Agri Bomanadi? Standing counsel, yeah.
Lords, I'm not aware. Lords.
A notice by post returnable 6 weeks. ಬೇಗ ಹೇಳ್ಬೇಕು ನೀವು ಚೆಕ್ ಮಾಡ್ಬೇಕು ಅದು ಯಾರಪ್ಪ TMC ನೋಡಿ ಎಷ್ಟು ಜನ litigants ಕಷ್ಟ ಕೊಡ್ತೀರ ಅವ್ನು ಲಿಸ್ಟ್ ಮಾಡ್ಕೊಡಿ ಅಂದ್ರೆ ಕೊಡಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ. Issue emergent notice to the respondent. Counsel for the petitioner is also permitted to take out hand summons on the respondent, as also serve standing counsel, if any, of the respondent. Relist on 20th February.
Interim order, my lord. My lords, I will undertake construction as per the license, my lords. If there is any violation, I will not claim equities.
We don't want to demolish constructions like we are forced to do in many matters. Why do you want to take the risk of wasting money? Wait for another week.
21st, my lord. 21st.
21st.
Can it be
20th? 20th or 21st? 20th.
21st.
21st you want, 21st.
Please, 21st. Grateful.
Please, my lords. My lords, the present petitioner is the defendant before the trial court. Plaintiff has filed the suit for recovery of money, my lords. The plaintiff is at paragraph now, page number 12, my lords. He has filed the suit for recovery of 2,71,31,000 rupees.
Yes.
And he is claiming the said amount based upon a document which is annexed at page number B, my lord, page number 19 at annexure B, my lords. The said document is unstamped and unregistered, my lords. During his examination in chief, he wanted to get
memorandum of understanding.
Yes, my lords, this is a memorandum of understanding. But if your lordship is pleased to peruse the recitals, that is, my lords, whereas the fourth para, whereas the party number 1 had orally agreed to sell the scheduled property to party number 2 in presence of below named witnesses on so and so date during the meeting held in the house of party number 1. Whereas after such oral agreement, further development could not take place with regard to the said transaction due to pandemic. So now the parties are desirous of getting reduce the agreement terms in writing to the sake of memory under this MOU. My lords, if your lordship is pleased to peruse the further terms, the party number 1 had orally agreed to sell the scheduled property to party number 2 on 25/2019 for a sum of rupees 5,40,000 per gunta.
Now it's not been marked.
It is not yet been marked, my lords. I have objected to it, and there was hearing upon the said objection, and the trial court has passed an order.
What are you challenging now?
I'm challenging annexure D, my lords.
ಏನ್ ಮಾಡಿದ್ದಾರೆ?
At page number 29 of annexure D. Moreover, the defendant have no, hence the plaintiff is permitted to mark the document, and defendant has got every right to cross-examine the plaintiff. Now, by virtue of this particular document, he's claiming his right entirely revolves around this memorandum of understanding, my lords. Further, this memorandum of understanding is directly linked to the sale transaction that has taken place between them. Further, my lords, as per section 17 of Registration Act, I'll read clause C of section 17. Non-testamentary instrument which acknowledges the receipt or payment of any consideration on account of creation, declaration, assignment, limitation, or extension.
17 won't apply to you. It is 100 rupees which is required to be paid in terms of 5(1)(e) of the Stamp Act.
Yes, my
Only
lords.
that has not been paid.
Yes, my lords. Even it is not been stamped, my lords. The document is not stamped.
100 into 10,000 rupees.
Yes, my lords.
We'll direct that to be done and dispose the matter.
In the mark agilla sami naligide. If it is important and
is before this court seeking for the following reliefs. Notice to the respondent is dispensed with the new of the proposed order to be passed. The grievance of the petitioner is that a memorandum of understanding dated 25/1/2023, which is actually an agreement of sale, has been permitted to be marked,
my lords,
in evidence,
my lords,
without the same having been registered or stamped.
One fact, my lords, it is not an agreement of sale. What has happened is, even prior to signing of this memorandum of understanding, sale transaction has already taken place. Sale transaction has taken place on 26/2/2021. The sale transaction has been taken place. The same is forthcoming in the plaint, my lords, at annexure A.
Then the only agreement here
is for enhancement of money which he is claiming, and it directly relates to the sale of the property, my lords.
So how is it relevant? If you're not, if you are also contending it's not an agreement of sale,
Yes, my lords. It is an agreement wherein he's claiming amount from.
category would it have to be stamped?
My lords, if it is not an agreement of sale, it relates to the sale transaction that has taken place between the parties. It mentions about that there was a sale transaction so and so date for such and such money, and afterwards they have agreed into an agreed amongst themselves, wherein party number one, that is the defendant number one, defendant has agreed to pay enhanced amount to the plaintiff. If there is any enhancement of amount with respect to the sale of a property, my lords, it ought to have been stamped or it ought to have been registered.
The grievance of the petitioner is that the document styled as memorandum of understanding, which is sought to be, which has been permitted to be marked in evidence, is an agreement under which an additional consideration was agreed to be paid in
Yes, my
respect of a sale transaction which has already been concluded.
Yes, my lords.
And as such, he submits that without the same being stamped and registered, the document could not be marked, and in this regard, he relies upon section 17 of the Registration Act, 1908.
Also 34
So
of
far as
stamped.
the contention of counsel for the petitioner that the document is required to be registered, the said contention would have to be rejected in limine in view of the fact that there is no transfer of right, title or interest in any immovable property under the memorandum of understanding. Even according to the petitioner, the memorandum of understanding is executed after a sale deed had been executed in respect of the property, agreeing to make payment of an additional consideration. Thus, the requirement of the embargo under section 17 would not be applicable to the said document. As regards the second contention, that the document was also required to be stamped, even as per the contention of the counsel for the petitioner, this document is only, the memorandum of understanding has been entered into only for the purpose of agreeing to make payment of an additional consideration over and above that paid under the registered sale deed, already executed.
Yes, my lords, already executed.
If that be so, as held above, the same not being required to be registered, if there is any stamp duty required to be paid thereon, at the time of marking of the document, the trial court could always call upon the petitioner to make payment, plaintiff to make payment of the stamp duty thereon, along with penalty if so required.
Please, my lords.
The petition has been filed even before the marking of the document and
Yes,
before
ma'am.
any orders are passed.
Or-
As such, I am of the considered opinion that they said the above petition is premature and is not required to be considered at this stage. So the trial court would always have to take into consideration the above observation while permitting the marking of the document, if so permitted.
Please, my lords. My lords, may I pray for hand delivery of the order, my lords?
Which hand delivery? Why do you want hand delivery of this?
Tomorrow it is posted for marking, my lords. So,
Yearly. Yes.
and
hand delivery ಎಲ್ಲಾಗತ್ತೆ 6 ಗಂಟೆಗೆ.
please.
112. Sorry, Mlats, for the interruption. But serial number 68, it is infructuous, Mlats, there.
68 dismissed.
I'm
with
filing a memo
infructuous.
in this regard.
Petitioner is before this court seeking for the following relief. Memo dated so and so has been filed, signed by the counsel for the petitioner, which reads as under. 50 to 71 ಯಾವ್ದಾದ್ರು ಆಗಿಲ್ಲ, put it dismissed.
Grateful, Mlats.
Yes.
Lord, I brought to your lordship's kind notice the award passed by the special land acquisition officer. My lord will kindly, special land acquisition officer is, my lord, here, my lord, in this petition is the second respondent.
Yes.
Is a second respondent. My lord will kindly, my lord, the abatements made in the, my lord, writ petition, my lord, I bring you to your lordship kind notice. What is challenged, my lord, kindly, para 8, my lord, your lordship will kindly. One of the landowners, in so far as the lands acquired, same preliminary notification, that is survey number 75/2A and 75/2C,
measuring 2 acres 12 guntas and other survey number sought for a reference application under section 18 of the LA Act for enhancement of compensation, which was registered as LAC 183 of 2000 and other connected matters. The reference court by its judgment and decree dated 9/7/2010 enhanced the compensation to 2,40,000 as per acre. The copy of the judgment and decree in LAC 183 of 2007 and connected matters dated 9/7/2007 is produced as Annexure C. The petitioner here which states that the said judgment has attained a finality. They have satisfied the judgment.
Yes.
Please. Then, my lord, your lordship will kindly, para 9. Page 7, next page. However, your lordship will kindly. I'm sorry. Thereafter, it is alleged that.
Mr. Ravi, this order of 9/7, judgment of 9/7/2010 in LAC 183 of 2007 and connected matter, that is attained. You have paid monies on that?
That is certain thing, my lord. My instructions are not challenged, not in penalty.
You have paid money?
Yes, sir.
You're not challenged, finality, you're not challenged and you paid money?
Subject to my instructions, I think it is my it paid it.
Yes, but you said attend finality andre payment agide antane.
Right.
Inne challenge madilwalla. Yes.
First round itself, you have taken this contention. Finality agide.
Finality.
First round of.
Andre paid anta. Yadu tondbekalla. Yes.
Lord, then, my lord. Thereafter, it is alleged that respondent number 3 has filed an application before the respondent number 2 SLO under section 28A of the LA Act on 14/9/2010 for the purpose of redetermination of compensation amount on the basis of the judgment and decree LAC 183 of 2007 and connected matters dated 9/7/2007. Since the scheduled property was acquired under the same preliminary notification, however, the said application is not forthcoming and does not appear to be in the records. The petitioner has made a hectic efforts to find out the copy of the application. However, when requested from the office of the SLO, respondent number 1 herein, a copy of the application filed under Order 1, Rule 10 by the respondent number 3 was made available. The copy of the application dated 14/9/2010 is produced as Annexure D. Lord, may I request this Annexure D may kindly be taken. This is the amendment.
Annexure D is the application on 28A.
28A, my lord, this is a statement that has been made in the written application.
Then what kind of statement is this at para 9?
That's some.
You're trying to mislead the court.
Some mistake.
Mistake
Maybe some
You should
other.
have by now deleted it.
I'll
Is there an marta idri?
there's some.
You gone on to say 1 Rule 10 application is.
ಇಲ್ಲ connected matter ಯಾವುದು ಯಾವ connected matter ಇದೆ this way. I'm. It has to.
We'll have to deal with it, whether you like it or not. ಹಿಂಗ್ ಮಿಸ್ಟೇಕ್ ಮಿಸ್ಟೇಕ್ ಆಗುತ್ತೆ ಅದನ್ನ ಕರೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡು
Correct.
Before we pass orders, if you correct it, well and good. Otherwise, we'll have to deal with it.
Correct.
It won't look good on paper. That is how much we can say.
No, we'll correct that.
Yes.
Lord, next paragraph, your lordship note. The respondent number 1 by an order dated 13/2/2020 allowed the application filed by respondent number 3 under section 28A without hearing the petitioner and redetermined the compensation with respect to a scheduled property arbitrarily and without application of mind. After the lapse of nearly 10 years, furthermore, the respondent number 1 has granted a compensation along with the interest at the rate of 9% for the first year and 15% from 28/6/2000 till the date of the order, which is opposed to all canons of law, my lord. Sundar's case, my lord, it is blaringly, my lord, it is stated law on the point. And my lord, it was referred to a constitutional bench, this matter. Constitutional bench has decided this question, stating that, my lord, your lordship should kindly stating that so far the redetermination is concerned, Lord, they are entitled to all the benefits. But Lord, the statement is not on. Then Lord, your lordships should kindly another paragraph, Lord, which I request your lordships. Para 13, Lord. Subsequent to the said final order in the writ petition, my Lord, your lordship, the final order passed in the writ petition was produced as an Annexure F.
Yes.
Subsequent to the said final order on the writ petition, the petitioner submitted objections to the application for a redetermination of compensation under section 28A. The copy of the objection is produced herewith as Annexure G. Respondent number 1, after giving an opportunity of hearing to the beneficiary as well as to the other parties, has now passed an impugned order on 7/7/2022, allowing the application of the claimants under section 28A of the Land Acquisition Act of 1894. The copy of the said order dated 7/7/2022, passed by the respondent number 1, is herewith produced and marked as Annexure H. My Lord, thereafter, your lordship should kindly ground number, my Lord, your lordship would kindly take 18, my Lord, ground number. So far as
yes,
section 28A Act extracted hereunder. Section 28 redetermination of amount of compensation on the basis of the award of the court. Please, Lord, this ground. Next, Lord, the collector on the receipt of the application, they say so. And Lord, the delay is on the part of the Lord landowner, the land losers, which is factually incorrect and contrary to the records. Lord, may I request, Lord, in this regard, I filed, Lord, objections to this application.
$8 years in redetermination of the award. So that's an allegation against the SLO, not against you.
My Lord, I filed an application for a dismissal of the writ petition, my Lord. On 12/6/2024, your lordship.
Yes.
It is submitted that the petitioner has filed the top noted writ petition, inter-alia contending that the award passed by the land acquisition officer awarding interest under section 34 of the Act is not applicable. It is submitted that the said contention has been answered by the Honorable Supreme Court in the case of Union of India and other versus Pradeep Kumari and others reported in the year 1995 SC, page 2259 in para 14 of the judgment, holding that as the redetermination being done under chapter 3 of the Land Acquisition Act and the reference is governed by the sections 18 to section 28 of the Act.
Patil, yes. I don't know why these kind of memos are filed here.
Please.
ಇದು ಒಂದೇ ಗ್ರೌಂಡ್ ಇರೋದು ಪೆಟಿಷನ್ ಅಲ್ಲಿ. ಈ ಪೆಟಿಷನ್ ಎಂಟೈರ್ ಪೆಟಿಷನ್ ಒಂದೇ ಗ್ರೌಂಡ್ ಇರೋದು.
ಅದೇ ರೀಡಿಟರ್ಮಿನೇಷನ್ ಮಾಡ್ಲಿಕ್ಕೆ ತಪ್ಪು ಅಂತ ಹೇಳೋದೊಂದು ಬಿಟ್ರೆ ಬಾಕಿದ್ ಏನೂ ಇಲ್ಲ.
ಅದು ಇಂಟ್ರೆಸ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಒಂದೇ ಗ್ರೌಂಡ್ ಇರೋದು.
ಹೌದು, ಇಂಟ್ರೆಸ್ಟ್ ಕೊಟ್ಟದ್ದು ತಪ್ಪು.
ನಿಮ್ ಪ್ರಕಾರ ಅದು ಒಂದೇ ಗ್ರೌಂಡ್ ಇರೋದು.
ಅವ್ರ ಪ್ರಕಾರ ಇಂಟ್ರೆಸ್ಟ್ ಕೊಟ್ಟದ್ದು ತಪ್ಪು ಅಂತ.
ನಿಮ್ ಪ್ರಕಾರ ರಿಟ್ ಪೆಟಿಷನ್ ಏನಿದೆ?
ಎಂಟೈಟಲ್ ಫಾರ್ ಇಂಟ್ರೆಸ್ಟ್.
ಅಪಾರ್ಟ್ ಫ್ರಮ್ ದಟ್ ಎನಿ ಅದರ್ ಗ್ರೌಂಡ್ ಇಸ್ ರೇಸ್ಡ್?
ಏನು ರೇಸ್ ಮಾಡಿಲ್ಲ, ಆದ್ರೆ
ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬೇಡಿ, ಇದು ಒಂದೇ ಮಾಡಿ, ಬೇರೆ ಏನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬೇಡಿ
ಪ್ಲೀಸ್.
You file this kind of memo to dismiss the petition only on one ground.
ಅಲ್ಲ, ನಾನು ಎರಡು ಜಜ್ಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಬಿಟ್ಟು.
What kind of memos are these?
I will bring these two judgments for your lordship.
Why do you file memo for dismissal of the writ petition? Argue the matter.
That would have been.
As if to say this is the only contention raised in the petition, therefore dismiss it.
ಅಲ್ಲ, ಅವ್ರು ಏನ್ ಮಾಡಿದ್ರು ಅಂತಂದ್ರ ಕೊಂಕಣ್ ರೈಲ್ವೆ ತಗೊಂಡ್ಬಂದ್ರು, ಅವಾಗ ನಮಗೇನೈತಿ ಇನ್ನೆವಿಟಬಿಲಿಟಿ ಆಗಿ ಐತಿ ಈ ಅಪ್ಲಿಕೇಶನ್.
ಮೆಮೊ ಏನಕ್ಕೆ ಹಾಕ್ತೀರಾ? ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ, ಪ್ರೊಡ್ಯೂಸ್ ದ ಡಿಸಿಷನ್. There are 10 grounds which have been raised.
Your lordship, sir.
Memo is saying as if only one ground.
Yes.
Not only in this matter, we are seeing that in a lot of other memo of dismissal.
Yes.
No grounds made out, dismiss.
Yes.
Nobody wants to argue.
Lord, 3 judgments ನಾನು ಕೊಟ್ಟಿದ್ದೀನಿ.
You have produced one judgment.
My lord, I have produced all the
1995
three
SC
I have produced all the
2259.
three. ಕೊಟ್ಟಿದ್ದೀನಿ ಅಬ್ಜೆಕ್ಷನ್ಸ್
ಒಂದೇ ಇರೋದು ಇದ್ರ ಜೊತೆ.
ಅಬ್ಜೆಕ್ಷನ್ ಜೊತೆ ಎಲ್ಲ ಜಜ್ಮೆಂಟ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀನಿ.
ಎಸ್ ಅಬ್ಜೆಕ್ಷನ್ ನೋಡ್ಬೇಕಾ?
ಅದ್ರ ಜೊತೆ 2001 23 January 2025 ಹಾಕಿ.
ಎಸ್ AR 2001 SC 3516.
ಪ್ಲೀಸ್. My lord, para 23 and para 24, my lord, I place a reliance. 20.
Mr. Ravi, is your contention as regard the quantum of interest and solution, or because the delay interest should not have been awarded?
Delayed interest.
Delay is not on the.
Not on solution.
You don't need to do. It's not their contention.
Para 23 and 24, my lord.
It is not their contention.
Omega
Their
judicial
only
review.
contention is SLO on that interest. Is SLO has delayed it by 8 years.
Yes.
Because the SLO delaying, SLO should not have awarded interest. The delay is not even attributed to you. Unlike in Konkan it was.
Please.
Idralilla, Madhusudan Naik or argument adu.
Yes. My lord, so far the scope of the court is para 18 one paragraph tamaga just ನಾನು ನಜರ್ ತಂದು ಬಿಟ್ಬಿಡ್ತೀನಿ.
Yes.
Para 18 page 36 ಆ judgment.
Yes.
Justice is a virtue, your lordship.
ಯಾವುದು 2001 SC ಯಾವ ಜಡ್ಜ್ಮೆಂಟ್ ಇದು ಸುಂದರ್ ವರ್ಸಸ್ ಯೂನಿಯನ್ ಆಫ್ ಇಂಡಿಯಾ
1993 supplements 4 SCC page 595
ಅಲ್ಲ ಇಲ್ಲಿ ಇಂಕ್ ಪೇಜ್
79 document number 2 17 document number 2
is 1993 supplemental 4 SCC 595.
Please. ಒಂದು para 18 ಅಷ್ಟು ಓದಿ ತಮ್ಮ.
Yes, Nagaraj. Para 18.
Yes. The powers of the constitutional court, my lord, has been held by my lord honorable Supreme Court. Page para 18. Neither the rules of procedure nor the technicalities of the law can stand in its way. The order of the court should not be prejudicial to anyone. Rule of stare decisis is adhered to for consistency, but it is not inflexible in administrative law as in public law. Even a law bends before the justice. The entire concept of writ jurisdiction exercised by the higher courts is founded on equity and fairness. If the court finds that the order was passed under a mistake, or it would not have been exercised the jurisdiction, but for the erroneous assumption, which in fact did not exist, and its perpetuation shall result in miscarriage of justice, then it cannot on any principles be precluded from ratifying the error. The mistake is accepted as a ratification depending on the facts or law, but the route for which the power flows from anxiety to avoid injustice, it is either statutory or inherent. The latter is available where the mistake is of the court. In administrative law, the scope still wider. Technicalities apart from the court is satisfied that the injustice, then it is constitutional. Legal obligation is set to right for recalling the order. Here, as explained, the bench of one of us also was a member of the committee error, so principles of so, Lord. Therefore, my respect to submission for your lordship's consideration. Lord, your lordship
This
in
is
fact.
normally a judgment which will be used by the petitioner, not by respondent.
No. Lord, this is a constitutional courts, Lord, where your lordships have day in and day out, Lord, exercises the powers.
Correct the defect. ನೀವೇನ್ ನಿಮ್ಮ ಅವಾರ್ಡ್ ಅಲ್ಲಿ ಡಿಫೆಕ್ಟ್ ಇದೆ ಅಂತ ಇದೀರೋ?
ಇಲ್ಲ, ಡಿಫೆಕ್ಟ್ ನಮ್ದ್ರಲ್ಲಿ ಏನಿಲ್ಲ ಇಲ್ಲ. ಪೂರ್ತಿ ಏನೈತಿ ಗೊತ್ತು ಇದನ್ನ ಮಾಡ್ಕೊಂಡು ಪೂರ್ತಿ ದುಡ್ಡು ಸಹಿತ ಅವರೇ ಹೇಳಿದ್ದಾರೆ.
This is a petitioner's judgment, not a respondent's judgment.
That's all.
Yes, anything else in yaradru? Nimde newe SLO. SLO, you have to answer one question. SLO is with KNL's office or separate? Where does it?
12.9 of scene.
In baki ella nimde argument copy. ಯಾರಿದ್ದಾರೆ petitioners ಇದ್ದಾರೆ respondents.
A few allegations, my lord, that there is no inward number.
Avinash, you adopt.
There are allegations that no inward number was found. There's 5 matters.
Who adopt what?
Itralla 5 matter they are different. There's no inward number ಅಂತ. Those submission.
ಅದು ಮಾಡಿದ್ದಾರೆ.
Respondent if they have to reply for that.
Lord,
SLO ಎಲ್ಲಿ ಕೂತ್ಕೊಂತಾರೆ?
please, Lord, as per the Lordship's question, whether office, separate office or in the, with regard to that, my Lord, I have no knowledge. Whether there is a separate office.
Tell us.
I will give,
Tomorrow you tell
please,
us.
by tomorrow morning itself, I will give with regard to that.
Submission made was that the documents were not available, they had no access to it.
Yes.
It was somewhere else.
Yes.
So SLO,
yes,
in
with
another
regard,
matter, it was told to us that SLO sits in KNL now.
yes, with regarding to that, tomorrow morning itself, I will make submission. Senior saying that both office are in one, ಅದನ್ನ ಕೇಳಿ ಹೇಳ್ತೇನೆ ಅಂತ.
ಇನ್ನೊಂದ್ರಲ್ಲಿ ಯಾವ್ದೋ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರು, ಬಟ್ ಒಂದ್ಸರಿ ಸಬ್ಮಿಷನ್ ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ರೆ ಕ್ಲಿಯರ್ ಆಗುತ್ತೆ. ಇದ್ರಲ್ಲಿ ಕೇಳಲಿಲ್ಲ ಅಂತ ಹೇಳ್ಕೊಡಿ.
Please. My lord, as per the applications which have been submitted by the applicants for redetermination of compensation, my lord, though the applications were submitted in the year 2010, as per the registry which has been maintained by the SLO, it reflects that they have submitted an application and it has been received by the thereafter, my lord, in view of regular SLO having not been posted to the said office till 2015, there were only a in-charge SLO was there.
Who did not do anything.
Though he did not do anything as per the instructions given by the present officer itself. Thereafter, in the year 2015, the proceedings started. Order sheets are maintained. Finally, in the year 2000, the stage something went where a lot of notices were not regularly served to all the applicants. Even though the claimants did not made the beneficiary as a party before the reference court, in which the judgment which they are relying, based on which they are seeking for redetermination. Now, subsequently, after the passing of the earlier award by the SLO, for the first time in the year 2020, the beneficiary approaches this honorable court seeking for quashing of that order, wherein this honorable court an opportunity was not provided to them and the matter remitted. May I take it to Lordship the observations?
And there's a state have two things you have to answer.
Yes.
One is
yes.
and more importantly, does the state have any